Welcome, everyone, to the House Judiciary Committee. It is, February 26th. Before we start our bill hearings, we're going to acknowledge any AKAs in the committee today. All right, great. Because today is the AKA day at the Capitol, so I wanted to make sure, and I am also an AKA, which is why I have my pink and green on. Delegate Patterson is behind me with her pink and green. So we have Ways and Means members joining us today as well for 2 bill hearings, and we're going to get started. Delegate Ebersol, you ready?
Thank you so much, and I want to point out I'm wearing Kappa colors.
And
not by sheer accident. Pink's not really a big color for me.
You're doing great. You're doing great. So here's what we're going to do. We're going to start with you with House Bill 658.
Correct. Thank you.
And you have 2 witnesses, correct?
I think I do. I think they're from JSEP, who would like, and if they're here and they.
Okay, let's call them up.
Bring them up with me.
Actually, I just have Kimberly Polk.
Whatever you say.
That's all I have.
Whatever you say.
Is Kimberly here? Okay, delegate.
They're all favorable anyway, so we're pretty good here.
It's on you.
Well, it's exciting to be in front of this committee. I so rarely get to do it, and it's so exciting.
Right.
You're one of my 6 favorite committees in the House, I got to say.
So you're using up your time. You get 3 minutes.
Okay, here we go.
Begin.
Here we go. So the Juvenile Services Education Program has asked me to bring this bill to make it possible for them to keep board members a little longer and expedite the process. They're having a little trouble attracting board members. If you're not aware of it, we allowed Juvenile Services to have their own education board a few years ago. And while it's working out well as a concept, they need some help keeping people. The bill says a couple of things. If somebody replaces a departing member, they can finish their term, but they can then serve for 2 consecutive terms after that. If they're on, of course, the Senate, the whole thing is they have to stay on until they're replaced. But basically, we let the state superintendent of schools was supposed to serve, but it says they can appoint somebody. The same is true for the MHEC. It can be a representative rather than the exact person. Really, it's just kind of clarifying and making it a little bit better. The only other thing is, right now the law says they have to meet every month. They say 10 times a year is enough, and maybe at will. In other words, if they need to meet twice in a month, it wouldn't prevent them from that. So it's just a couple of clarifiers to make their board run more smoothly. And with that, I'll conclude my testimony. Look at that. 1 minute and 10 seconds.
Thank you. And it is kind of ironic that we're asking for more people and your person didn't show up. I'm joking.
It probably took a little longer than they expected here.
Yes, no problems, no worries. Does anyone have any questions? And it looks like we do. Delegate Erican.
Thank you, Madam Chair.
I buy my ties at Walmart.
I
thought that was your question.
Certainly not. No, I have a substantive question. I would like to know a little bit about the bill, actually. So it says that they can serve for not more than two consecutive terms. What's the length of the terms typically?
4 years.
4 years, okay. And then you said 10 times instead of 12 now.
Well, 10 times instead of monthly.
Right.
Monthly is 12.
Correct.
But the 10 doesn't even say which months they have to meet in.
Right, so now it's going to be, they could do 2 in a month. Can you tell me, does this mimic how we treat our other school boards? I'm just wondering if there's any type of variation.
This is a new board, so it may not.
Okay.
They're kind of getting themselves established because in years, it's relatively new.
Okay, so you're not, like for Baltimore County, for example, do you know if are they required to have monthly meetings, or do they have also 10 that float around?
I don't know what Baltimore County requirements are. Every board has its own set of,
Okay, I just
bylaws.
thought you might be the expert on Baltimore County.
I am, but unfortunately, I'm not today because my bill's not on Baltimore County.
Maybe your staff could email me and let me know.
Oh, I'm sure they would love to do that.
That's wonderful. I would love that. Thank you so much. Welcome to the Judiciary.
It's a great place to be.
All righty. I don't see any more indication of questions. If Kimberly Polk came in, Kimberly? Oh, right,
oh,
great.
Yay. She might be able to answer a few of the questions in a little more detail than I.
So, is it Polk?
Yes.
Okay, Ms. Polk, you will have 2 minutes if you could provide your testimony. Sure. Thank you very much.
Take a deep breath.
Thank you.
Okay.
Good afternoon, Chair Clippinger and Vice Chair Bartlett, and members of the Judiciary Committee. My name is Kimberly Pogue, and I am the Superintendent of the Juvenile Services Education Program, known as JSEP. I'm here to testify on behalf of the Juvenile Services Education Board. Thank you for allowing me to speak today on House Bill 658, the Juvenile Services Education Board Alterations Bill. I urge the committee to issue a favorable report on HB 658. As outlined in Senate Bill 497 of 2021, the JSEP board was created as an independent unit within the DJS 4 years ago. The board is responsible for the oversight and approval of education services provided to all juveniles in DJS facilities. The board has discussed recommendations for strengthening its operations to address outstanding operational issues. The JSEP board asked the committee to consider amendments as outlined in the bill. The JSEP board consists of 11 members, 5 ex officio, 5 appointed by the governor with the advice and consent of the Senate, and 1 educator currently teaching in a DJS residential facility. The board requests added language to permit the designation of representatives for 2 ex officio members, the State Superintendent of Schools, and the Secretary of Higher Education, in line with the current provision that allows the Attorney General to be represented at board meetings by a designee. Allowing the ex officio member to be represented by a designee will increase their level of participation and ensure that their unique perspectives as educators are shared. Both offices have agreed to the language. The board also requests adding language to the bill for term limits. Each of the 5 appointed board members serve 4 years. To avoid the excessive turnover of members at any one time, the board proposes staggered terms as outlined in the bill. Additionally, the board asks for language to limit terms to 2 consecutive terms. Thank you for your consideration of the board's proposed changes to our implementing statute. I urge the committee to issue a favorable report.
Great, thank you.
Thank you.
Looks like we have a question from Delegate Pasteur.
I'm looking forward to this one.
Okay. Yes.
Did I miss our meeting?
Yes, you did, but it's okay. We'll reschedule.
I had to ask a question. Okay, so I apologize.
No problem.
But we're rescheduling.
We definitely will.
I really appreciate this, this amendment to this and the inclusion of someone from MSDE, because that was what was missing, participation in the first place. And so now it pulls the 2.
It will allow them to have a designee, which I think will up their participation.
Sure, that's excellent. Thank you.
Thank you.
Okay, thank you. Seeing no further questions, that concludes the testimony for House Bill, or the hearing for House Bill 658.
Thank you, Madam Chair.
You're welcome. We're going to move on now to Delegate Tolles, House Bill 1433. And Delegate Tolles, while you make your way over, I'm going to start calling out names, and if you could start coming up, unless you have a particular panel. Okay, well, you come on over. So we'll have Kara Anderson, we have Emily Virgin. Are we having Judge Caroon come up now, or is he still here? Oh, there he is. Okay.
Who, Ryan? Somebody's virtual?
Liz. Yes.
Liz Ryan is virtual.
Well, I've got Monique Dixon virtual. Okay. All right. So let's go to, and we also have Ikra Ashraf, I'm sorry. And I think that will do it. We'll continue calling our favorable witnesses after this panel.
Emily.
So Delegate Tolles, whenever you're ready, you'll have 3 minutes.
Okay, wonderful. Thank you so much, Madam Vice Chair and colleagues on the Judiciary. This bill is in support, I'm testifying in support of 1433, juvenile jurisdiction. House Bill 1433 attempts to address automatic charging of youths as adults. It is not a full all-out end of automatically charging youths as adults. Instead, it is a narrowly tailored approach, a pared-down approach that will begin to move the needle in the right direction for certain charges. HB 1433 will alter the jurisdiction of the juvenile court by repealing provisions specifying that the juvenile court does not have jurisdiction over a child alleged to have committed certain acts. It is important to note that for this bill, that charges for this bill of first and second degree murder, rape, and carjacking will remain under adult court jurisdiction. We are paying more money, taking longer time to end cases, and we are getting worse public safety outcomes. I encourage you to take a more thorough look at the DGS submitted testimony to see how this bill will create public safety create a better public safety outcomes for Maryland communities, and Kara will go into more detail about their testimony. The process needs to be streamlined because we are spending, again, more money, and cases end up being waved back to the Department of Juvenile Services anyway. When youth are charged as adults, they end up waiting over 100 days longer than youth charged in the juvenile system. Enacting this approach would save DGS at least $17 million, where the money could be spent on other services. This is a critical issue for Maryland. Only Alabama charge children as adults at a higher rate than Maryland. In most cases, it's Black kids that are impacted more than any other race of children. And I'm trying to go through this quickly. The data is compelling. If you refer to the racial equity impact note that was given, by DLS, you will see that the fiscal year 2023 in the Governor's Office of Crime Prevention and Policy, or whatever we call it, like as we like to say in Judiciary, reported a total of 737 youth were charged as adults for crimes of violence by the state, and it shows that 81% of these individuals were youths of color, with the majority being Black individuals. In fiscal year 2024, DGS reported a total of 604 youth were adjudicated for crimes of violence. Of those 604 youth, 89% are youth of color. The circuit court and juvenile courts processes share similar racial distribution for youth charged with crimes of violence. The statistics show, if I could finish briefly, thank you, Madam Chair. Statistics show and provide evidence of substantial disproportionately in the proportion of youth in color charged with crimes of violence. The disparity ratio for youth of color under the age of 18 means that the youth that these youth are 5.5 more likely to be charged for crimes of violence over their white peers in juvenile court. For youth charged as an adult for crimes of violence heard in the circuit court, youths of color are charged as adults slightly overrepresented in cases adjudicated by the circuit court and are more likely to be charged as adults for violence of crimes, for crimes of violence compared to their white youths. Overall, in closing, Black youths are overrepresented and are more impacted by crimes of violence charges, whether they're adjudicated in juvenile court or circuit court. Therefore, they're experiencing harsher penalties. And this is precisely why this is a legislative Black Caucus of Maryland priority. If you look at the numbers and any other government agency perform this poorly, we will be looking to rectify the error. Why not in this case? This is not an overnight fix, but in the case of children, they are one of our most important assets. This bill is supported by retired judges, the community, and you will hear from many advocates. Colleagues, I urge you to vote favorable for HB 1433. Thank you, Madam Chair, for your indulgence.
You're welcome. We went over a little bit, colleagues, but we're going to have a whole lot of testimony, and I wanted to make sure that the sponsor was able to get out her positions, because there are going to be a lot of witnesses for this bill. So we're going to move on to.
Oh, I'm sorry. Can we go to
Yep, Kara, you want to go
Thank you,
next?
Madam Chair.
All right, good afternoon, Madam Chair and members of the committee. My name is Kara Annenson. I am the Director of Legislation, Policy, and Reform at the Department of Juvenile Services. DJS supports HB 1433 because it promotes efficiency, fairness, and better public safety outcomes for Maryland's communities. The current system negatively impacts detention center operations, delays access to rehabilitative services, and disproportionately impacts kids of color. In addition, the current system is incredibly costly. DJS spends roughly $17 million annually to accommodate youth charged adults in juvenile detention facilities, and is unnecessary since judges are choosing not to use the adult correction system in nearly 85% of youth automatically charged as adults cases. This legislation does not change the current law that requires youth who are alleged to have committed the most serious offenses, such as rape, murder, and carjacking, to be automatically charged as adults. In addition, the current law allows for the waiver process, the ability for prosecutors to ask the juvenile court to move a case from the juvenile court to the adult court for prosecution and sentencing. HB 1433 takes a measured approach to improving public safety outcomes for youth by codifying the current process, recognizing the long-standing research on adolescent development, and prioritizes service and treatment for youth while maintaining public safety. For these reasons, we urge a favorable report.
Thank you, Madam Vice Chair, members of the committee. My name is Emily Virgin, and I'm the Director of Advocacy and Government Relations at Human Rights for Kids. In November, we released our latest report entitled Disposable Children, which details the staggering rates of childhood trauma, abuse, and neglect among the population of children who are convicted as adults in Maryland. What our research showed was that children who come into conflict with the law are almost universally contending with early childhood trauma and unmitigated adverse childhood experiences. Nearly 70% of the children who were tried and convicted as adults had experienced at least 6 out of 10 ACEs prior to their incarceration. About 74% had experienced physical abuse, and around 40% had experienced sexual abuse. The average age that this group of children first experienced abuse was 6 years old. The current system of allowing these children to be automatically charged and treated as adults means that children with severe trauma sit in detention with no services, treatment, or accountability until after their transfer hearing takes place. Most of them are housed in a DJS facility but are unable to receive those services. It takes about 4 months before children are transferred to juvenile court, and it's important to note that most of them are transferred to juvenile court. As Ms. Annenson said, over 80% of them. This legislation would simply start cases in the system where they already end up and allow children to begin receiving treatment much sooner. When a child comes before the juvenile system, their cases are processed fairly quickly. They're held in detention for an average of 71 days. During this time, DJS conducts their risk assessment, develops a treatment plan tailored to address the child's behavior and their background and reduce the likelihood of recidivism. When children commit crimes, swift consequences and treatment for underlying trauma are paramount for the protection of public safety of all Marylanders. We urge a favorable report.
Whoever's ready.
Good afternoon, Madam Chair and members of the committee. My name is Ikra Ashraf, and I'm a student attorney in the Youth Education and Justice Clinic at the University of Maryland Francis King Carey School of Law. I am here to testify on behalf of the clinic, as well as from a personal perspective, as I have a close family friend currently charged as an adult in Maryland awaiting judicial review. Out of respect for their privacy and given the pending nature of their case, I won't provide further details. However, I want the committee to understand that if HB 1433 were in effect, my loved one would not be confined in an adult cell right now. Since 2021, more than 2/3 of children charged as adults have been returned to the juvenile system. Not only does this statistic reveal that the current system is ineffective, there is a human cost. For a child spending that time in an adult facility, the situation is dangerous even in moderation. For example, adult facilities are not equipped to house children. Since children are legally required to be separated from adults in custody, children in detention centers are often held in solitary confinement. Additionally, the children staying in these detention centers are prone to victimization. Human Rights for Kids surveyed individuals who had been charged as adults in Maryland and held in adult facilities. Approximately 82% reported they were harmed by staff or other incarcerated individuals at least once during their stay. My own family friend has shared that they had been verbally harassed. What might appear to be a short stay on paper often inflicts long-term emotional damage in the child that endures it. Given the inefficiencies of this process and the lasting trauma it inflicts, it is important that Maryland narrow and limit the offenses for which a child can be charged as an adult. We should expose as few children as possible to the adult criminal system. For these reasons, the clinic strongly supports House Bill 1433 and requests a favorable report. Thank you.
Thank you. Judge Crone?
Thank you. Madam Chair, Acting Chair, Delegates, Phil Karoum, speaking based on my 24 years of serving as both a juvenile and an adult criminal court judge. I should add, I'm not speaking on behalf of the court system, but speaking on behalf of nonprofit group Maryland Alliance for Justice Reform. I'd like to point out that the current system charging children as adults is a major conduit of the school to prison pipeline, in the sense that when we charge those kids and make them spend an extra 100 days in pretrial detention or otherwise, that makes about 3/4 of them drop out of school and they never return. When they are put out of school, they are then hanging around with the worst possible companions in the adult system. Unfortunately, there is access to illegal drugs in those systems. While you heard lots of bad things about the Department of Juvenile Services today in terms of how inefficient and short of resources they are, the adult system is 2 or 3 times worse. There are no school programs for them there. If a child is charged as a juvenile, however, they stay in school. They have regular counseling, even in pretrial detention. They are kept away from illegal drugs, and they're in a much better position to succeed when, as you have heard, more than 80% of the charges are dismissed. So it is a system which costs the taxpayers lots of money. It creates more of unemployed school dropouts who will get in trouble worse. And for all those reasons, I strongly urge you to support House Bill 1433.
Thank you. Are there any questions for this panel? Yes. Delegate Kaufman.
And I have 2, if that's okay. Delegate Tolles, thank you for bringing the bill, very important bill. Yes. It won't surprise you that Mr. Schellenberger is opposed to your bill. And so my question is, as he often does, he, in his testimony, he lists a series of terrible anecdotes. So what I wanted to know, is, do you think that there's a point there that the most people with the most egregious offenses should be tried as an adult, or do you think it's cherry picking? And my other question is for your experts on the panel. The judge talked a little bit about this, and the law student talked about her friend who's been verbally abused. But do we have any long-term studies on the benefits of juvenile justice or juvenile services rather than adult incarceration? Do kids fare better 10, 20, 30 years later? So whichever order you want to take those questions in.
Sure, I'll start. Thank you, Delegate Kaufman, for your always great questions. I would say I did not read Mr. Schellenberger's testimony because I'm sure I can guess what he is saying. So it's no shocker there, but I will say that, as I indicated in my opening remarks, that it's only, the most egregious crimes of murder, first degree, second degree, manslaughter, rape, even armed carjacking would still remain under adult court jurisdiction. And they would have to go through the process of getting waived down through the courts. And so that's a current process that already exists that does not change. Where we see a lot of the issues is where we have, children with, handguns or first degree assault or some type of firearm. Those are charges that we are looking to start in the juvenile court jurisdiction because they get waived back anyway to juvenile court, most likely. And so instead of starting off as an adult in adult court, waiving them back would be the most ideal approach. And would, as we talked about savings, harshness, all of that is extremely important for why we need to push this bill forward because they're coming back anyway. I will let Kara, add on to that. She's itching to add on to it, so I know she can add on to that. And in terms of your second question, I will refer to the human rights to talk about any studies regarding juveniles.
I was going to touch on that.
Yes.
Oh, you can touch on that as well. Yes.
Yes, and I did want to let you know, I was paying attention to when you said the carve-outs the first time, but given the opposition testimony, I thought it was good for you to reiterate it.
Oh, thank you.
But go ahead, I'm sorry.
No, thank you. I know. That was for those that were listening in case they don't listen as good as you do, Delegate Call.
Okay, well, thanks. If you could answer the second question.
Yeah, I was just going to say there's lots of national research showing longstanding that starting kids in the juvenile court system have better public safety outcomes because young people are able to access treatment, education, and services. And I think former OJJDP Administrator Ryan can speak really about that just in Maryland and across the country.
And, okay.
If it's possible to provide a response in advance to the horror stories that another witness might tell of juveniles in pretrial detention, those incidents that you may be about to hear of are just a tiny percent of all of the hundreds of children that go through the Hickey School and other juvenile detention facilities. And I think the concept of sending more and more into adult pretrial detention isn't justified by that in the sense that the adult system is much more dangerous. There are more assaults that occur there, more deaths that occur there in the juvenile system, and it is a rare and highly unusual thing, which obviously should be addressed by Department of Juvenile Services if there's a problem in detention with assaults. But that doesn't mean that one should punish the other 99% of kids who could better be handled in the juvenile system that way.
Very quick follow-up, Madam Vice Chair. Thank you. And I already articulated someone's opposition, but Delegate Tolles, do any of the other 23 state's attorneys support your legislation?
I would say probably not, and that's okay, because, as prosecutors, they want the ability to be able to decide, where the jurisdiction would be. But as I indicated, this does not allow them to not ever do that, So it would start off with DJS with some of the charges I indicated, like armed robbery, handgun, but where I think it's important for the prosecutors to focus on is some of these most egregious cases that may start in DJS, but then, that may start in adult, court, and then they can still decide if they want to be able to, feel like, hey, it's a first offense, they are not, maybe it was self-defense or whatever reasoning they may feel like that particular individual could be waived back down to, juvenile court. But I think, as I indicated, and Kara can add on to this, but I think what the most important issue is that we have more minorities that are impacted by this. And we know that Maryland incarcerate Black individuals at a higher rate than any other group. And so we want to be able to really take a look at that and see how we do things differently. And this bill will give us the ability to do that by starting some of these kids off in the juvenile court, allow for them, as you heard previously, to get some resources, get some support that they need in order to be more productive citizens in society. But when you start them off at adult court, it is a much harsher, jurisdiction, so.
Thank you, Madam Chair. Thank you, Delegate Tolles.
Do you want to add? I'm sorry.
No.
Emily,
Well, just one quick point, Delegate Coffin, on the issue of there being serious offenses that the prosecutors are concerned about. If this bill were to pass and those offenses, those children started in the juvenile court, the prosecutor always would have the ability to seek to transfer the child or to waive the juvenile court jurisdiction and try the child in adult court, and a juvenile judge would make that decision. So they're not stuck in juvenile court. They could still be in adult court.
Thank you. Delegate Taylor?
Thank you, Madam Chair. And Delegate Tolles, thank you for bringing this bill. This is also considered the YES Act, right?
yes, correct.
I also wanted you to know that more of our sorority sisters have arrived, and they're all sending you pink and green love, including my cousin Sandy Banks back there. But I do have a question. Anybody that can answer this question. If a child is sent to an adult facility, what does that look like for them? Are they placed in a cell with an adult? Are they isolated? What does that look like? And then for the judge, you mentioned that there was some percentage that were dismissed ultimately. What was that percentage again? Can you repeat that? And
So the percentage that comes from the Department of Juvenile Services keeping statistics is, I think it's between 81 to 87%. Maybe it's an average of 85%. Have their charges dismissed and are sent back to juvenile court after waiting on average 100 days for their turn to come up for that hearing. If the case is started in juvenile court has written into its rules that we handle those cases much more quickly. So they would have their hearing and the decision would be made to keep them in juvenile or send them to adult within 60 or 70 days at tops. So, but during that 60 or 70 days, they could stay in school. They would be in the company of other juveniles. Your other question was, what does it look like when they are in adult prison? And the answer is that there is a statute which says they should be kept in a way that is out of sight and sound of adult offenders. So there should, in effect, be a separate area for juveniles. However, until they turn 18, in which case they are then thrown into the adult population and really don't mix well. They really become victimized at a much higher rate by the older, more experienced prisoners. But because they are stuck in this smaller area, there's fewer facilities for them there. Some people say that it is comparable to solitary confinement because they do not have the same opportunities to socialize and have other programs as older prisoners might. But again, the services and the education and the job training in the adult system is way more scarce than it is in the juvenile system. In the juvenile system, every single child, every single individual has education, treatment, and ultimately, if they don't stay in school, job training. In the adult system, 1 out of 10 prisoners has the chance to participate in correctional enterprises for job training. And it's a very small percentage of adult prisoners who ever complete their GEDs or go on with their education.
thank you.
Seeing no further questions, that concludes this particular panel. We'll move on to the next panel.
Madam Chair, I'm sorry, we did have some virtual, so that was part of this panel.
Yeah, but we've got a lot of favorable. Okay. Wait.
I know, we was looking to have Liz Ryan with us, if that's possible. Sorry, we were looking to have Liz Ryan. That's okay. Yeah, as part of this.
Monique, okay, thank you. Okay, so we're going to go ahead and have Monique Dixon, and I believe that's Liz Ryan next.
Okay.
So, Ms. Ryan, if you want to start, and then we'll go to Ms. Dixon. There you go.
Good afternoon, Madam Chair and members of the committee. I'm Liz Ryan, the former administrator of the Office of Juvenile Justice and Delinquency Prevention at the U.S. Department of Justice. Thank you for the opportunity to speak in favor of HB 1433. I'd like to focus my comments briefly on why starting youth in the juvenile justice system rather than the adult criminal justice system enhances public safety. The research is clear. Youth who enter the adult criminal justice system are much more likely to reoffend and to do so more violently than those who are in the juvenile justice system. When I served as OJDP administrator, we conducted an analysis of the research on this, much of which OJDP invested in. For example, 6 large-scale studies conducted across 5 jurisdictions examined the deterrent effects of transfer laws. All 6 studies found higher recidivism rates among youth who had contact with the adult criminal justice system. The juvenile justice system is designed specifically for young people, incorporating research on adolescent brain development and behavior. The Office of Juvenile Justice and Delinquency Prevention and national experts emphasize that the juvenile justice system provides developmentally appropriate interventions that reduce reoffending, evidence-based services which significantly lower recidivism, mental health and educational support which the adult criminal justice system lacks. That's why I, along with 4 other OJDP administrators, have publicly stated our support for this legislation. In closing, the adult system has been proven ineffective at rehabilitating youth or keeping communities safe. It increases recidivism and exposes young people to conditions that make them much more likely to commit future crimes. Maryland has an opportunity to come into alignment with science, data, and proven solutions. I urge support of HB 1433. Thank you.
Thank you. Ms. Dixon.
Good afternoon. I am Monique Dixon, Executive Director of the Gibson Bank Center for Race and the Law at the University of Maryland, Carey Law School. We appreciate the opportunity to provide both written and oral testimony on House Bill 1433, which is a step in the right direction toward ending Maryland's inefficient, racially disproportionate, and harmful practice of automatically charging children as adults. Limiting the automatic charging of children as adults could positively impact Black children who are overrepresented among these young people when compared to their statewide representation. National research shows that Black children are overrepresented in both the youth and adult criminal legal systems, in part because they are often seen as being older and less innocent than their white peers. Consequently, Black children are often unfairly feared and criminalized by the general public and decision makers. House Bill 1433 could significantly impact Black children by beginning more cases in the juvenile court system where they would have access to treatment and services that are unavailable to them in the adult system. Also, because over 80% of children who are charged as adults have their cases either transferred to juvenile court or dismissed, House Bill 1433 would result in a more efficient process by allowing more cases to begin in the juvenile court system. And this could result in a cost savings that could be used for more treatment and other services. In our view, all cases involving children should begin in a system that understands children are different from adults and that they are more responsive to treatment, rehabilitation, and accountability systems. We respectfully ask that you issue a favorable report for House Bill 1433. Thank you.
I believe that's Delegate Hornberger, right? Okay, Delegate Hornberger. Just wanted to make sure I had the right light associated with the right individual.
Thank you, Madam Vice Chair. And I'm from Ways and Means, so this will be more of a question from that perspective, sort of on the educational subcommittee. So this population that is sort of at the edge of the juvenile spectrum, are they being detained while they're awaiting trial? Is that accurate to say? So the proposal of the bill is to detain them with the younger cohort, right? The juvenile population. Is that accurate?
Yes.
Do they have the same segregation requirements that you just alluded to, this gentleman on the end? Judge, that they would in the adult incarceration areas?
I can just touch a little bit on that, because right now, actually, the overwhelming majority of DJS's detention centers are young people charged as adults, because in 2015, the law was changed to say that young people who are automatically charged as adults at the point of bail review could be held in a juvenile detention facility and not in an adult jail. So we're already serving those young people. We're providing them education and services. So they're being held with us pre-trial, but they're still being automatically charged as an adult.
So for this age cohort, which is 15, 16?
No, it is 14, 15, 16, 17.
Okay, so 14 to 17, depending on the severity of the crime, you will either go to a juvenile facility or an adult facility. Is that accurate?
You'll start in the adult, and if you're automatically charged as an adult, you'll start in the adult system. The court can then move you to a juvenile detention facility pending your transfer hearing.
Okay, so my concern becomes if this population was identified to go to the adult court, this bill seeks to change that, automatically send them to the juvenile court. What is the disproportionate impact they may have on the folks that are in the juvenile facility?
They're already in our facilities right now.
But not at this offender level?
At this offender level, yes.
If the judge determines that they should go there?
Yes, they may. Yes.
Okay, so is there concern that?
No, the department is currently housing these kids every single day. We're able to serve them.
Well, if they're already doing that, then why do we need the bill?
Because what the bill does is saying where they're starting their case. So when a youth is automatically charged as an adult, they're going through the adult justice system. They're being held in a juvenile detention facility, some of them, pending that decision. What this bill would do was say that they would start their entire case in the juvenile delinquency process, and then if a state's attorney felt like this case should go to the adult system, they could then waive that case to the adult system.
And upon that decision, would they be automatically transferred to the adult facility?
If they were waived to the adult system, yes.
Okay. All right. Thank you.
Okay, seeing no further questions, that concludes this particular panel. We'll keep moving.
Thank you.
Thank you.
Thank you, Pam.
Let's see, we have Lawrence Grandpre from Leaders of a Beautiful Struggle, Katrina Emerson from District Heights Family Youth Services Bureau, Yassim El-Koshari, Nadine Finnegan-Carr, Reverend Palmer, Esquire, Michael McCoy, do we have virtual Todd Urey? Okay. Okay, I have named all the names on our favorable, so let's just make sure everybody heard me. From Leaders of a Beautiful Struggle, District Heights Family Youth and Services Bureau. Okay. Yassim? Yes? Yes. Okay, thank you. Nadine? Okay. And Reverend Palmer, Esquire? And Michael McCoy? Michelle. Very good. Okay, so we're going to start with whoever wants to go first. I usually like to start here and go down. It just makes it easy for me to remember who testified, if you don't mind. Thank you.
All right. Good afternoon, Madam Chair and the Judiciary Committee. My name is Katrina Emerson, and I'm the Executive Director of District Heights Family and Youth Services Bureau. From a preventative standpoint, I fully support House Bill 1433, which aims to eliminate automatic charging for children aged 14 and 15 and reduce the list of charges to 16 and 17-year-olds. In addition to this important legislative step, I strongly recommend that mental and behavioral health services be mandated for these individuals. It is essential that these services are not only available, but also delivered in a timely, consistent, and effective manner. The success of each service depends on the active involvement of the individual, their family, and their community, fostering a holistic approach that minimizes further interaction with the judicial system. I have personally witnessed the impact of this approach with a former client referred to my agency due to disruptive behaviors, impulsivity, and poor decision-making, which put them in contact with the juvenile justice system. Throughout their engagement in services, the client demonstrated a significant reduction in negative behaviors and began to challenge and adjust their established thought patterns. However, as the client's behavior improved, their session attendance began to decline. Regrettably, the absence of consistent support and participation led to a relapse in negative behaviors, and the client ultimately lacked the necessary resources to maintain their progress in treatment, thus resorting back to the juvenile justice system. In my experience, mental and behavioral health services play a crucial role in helping youth build resilience, increase self-awareness, and acquire the life skills necessary to navigate challenging situations effectively. The key to success is with any intervention or prevention effort lies in consistency. Regular sustained care can significantly improve outcomes and guide youth toward becoming healthy, productive adults. Thank you for considering the importance of both the legislative reform and the critical need for consistent mental health support in the lives of our youth. Thank you. You're welcome.
Good afternoon, and thank you, Sora and Madam Chair Bartlett. My name is Dr. Nadine Finnegan-Carr. I'm the Executive Director of the Center for Violence Prevention. The center is a community-centered, community-informed initiative of the University of Maryland, Baltimore, in collaboration with the R. Adams Crowley Shock Trauma Center at the University of Maryland Medical Center. It is a first of its kind to combine the resources of the school and the hospital. Our aim is to build resilient communities for all through the prevention and intervention of all forms of violence and trauma. We do this in an interdisciplinary collaborative fashion where we conduct community-based participatory research, provide creative and impactful education, and inform and advocate for policies that strengthen our communities to prevent violence and trauma. Our support of this bill is in line with the latter. Our Center for Violence Prevention strongly supports HB 1433, which would limit the number of charges that automatically place youth in the adult prison system. Despite having separate criminal justice system, youth are routinely charged and prosecuted in this adult criminal system, which is detrimental to their long-term well-being. It is best for all if cases involving youth begin in the juvenile court. Research shows that the key developmental differences between the youth and adults impact their decision-making, impulse control, and susceptibility to influence from problematic peers and adults who are looking to exploit them. And while these do not excuse youth from the responsibility of their actions, it is repeatedly recognized that youth are less blameworthy and more capable of change and rehabilitation when we expose them to the adult criminal justice system for crimes that are considered adolescent limited for their developmental stage. What we miss is the fact that as they mature, they are actually substantially less likely to reoffend. Locking them up in the adult system extends their incarceration far beyond the time needed for them to be rehabilitated. Many of the youth have experienced violence and trauma, and as already been stated, most of these are Black children, and the remainder of my statements are in my written report. Thank you.
Good afternoon, Madam Chair and members of the Judiciary Committee. On behalf of the Maryland Office of the Council on American Islamic Relations, thank you for the opportunity to testify in strong support of House Bill 1433, which expands the jurisdiction of the juvenile court by ensuring that children alleged to have committed certain offenses remain within the juvenile justice system rather than being automatically tried as adults. This bill is a crucial step toward a more just, rehabilitative, and effective juvenile justice system in Maryland. Maryland's current policies disproportionately funnel young people, especially Black and brown youth, into the adult criminal legal system, where they face severe and often irreparable harm. Scientific research and legal precedent confirm that children differ significantly from adults in their cognitive development, impulse control, and capacity for rehabilitation. Despite this, Maryland remains one of the states that still transfers juveniles to adult courts at alarming rates, disproportionately impacting communities of color. And here are a few points why HB 1433 is essential. Prioritizing rehabilitation over punishment. The juvenile justice system is specifically designed to focus on rehabilitation rather than retribution. When young people are charged and tried as adults, they lose access to critical services that could help them reintegrate into society as productive individuals. HB 1433 ensures that young people receive age-appropriate support and interventions. Reducing recidivism. Studies show that youth prosecuted in the adult system are significantly more likely to reoffend than those who remain in the juvenile system. By keeping juveniles in the court system designed for their rehabilitation, Maryland can lower recidivism rates and improve public safety in the long term. Protecting vulnerable youth from harm. Youth incarcerated in adult facilities face extreme risks, including higher rates of physical and sexual violence, mental health deterioration, and increased likelihood of self-harm. HB 1433 helps protect children from those dangers by keeping them in juvenile facilities better equipped to address their developmental needs. Thank you.
Thank you. Just move the mic over. Thank you.
Good afternoon, Madam Chair, and all those distinguished members assembled. My name is Dr. Michelle McCoy, and today I'm representing the Prince George's County branch of the NAACP. I'm on the executive board. I come before you to share my support with some revisions for HB 1433. As an educator with over 31 years of experience working with youth, especially those with emotional or behavioral disorders, too often their abilities to make good decisions is impeded by not only their disability, but their age, socioeconomic status, and their lack of familial support. As an educator in Prince George's County Public Schools, they have experienced supposedly progressive discipline, which is something that is professed to have been in place. However, too often these same youth and adolescents are given excessive punishment to include up to 45 days of suspension or expulsion from school. I believe incorporating proactive strategies in place, such as restorative practices that restore and rebuild relationships rather than provide punitive actions, would transform youth and adolescents into productive citizens. We have research, which you've heard today, that support the fact that here in the state of Maryland, too often our Black and brown youth are charged as adults way too frequently. Having children locked away with hardened criminals only negatively impacts that child and increases their chances of becoming a hardened criminal as well. These children are often the victims themselves of emotional abuse or lack of parental or adult guidance. With appropriate social-emotional interventions, wraparound services, and restorative practices, these children may make great mistakes and turn their lives, but however, can turn their lives around. If sent to adult prisons with adult criminals, it is guaranteed they will not receive the type of interventions and support that they lack. Thank you for giving me this opportunity.
Thank you. And there's the bill. Does anyone have any questions? Delegate Conaway.
Thank you so very much for recognizing me. Thank you, panel, for coming in to testify. Is there any data that suggests that the negative stimulus that these juveniles are experiencing helps to change the brain in order to deal with their environment?
Do you mean the negative stimulus of being in the adult system, or
no,
what are you referring to?
The negative experience of just the environment in general.
Yes. Yes, but it also depends on which environment you're referring to.
Okay, well, let's say if you were in the inner city in the projects, and you were trying to survive in that state while your brain is developing, shouldn't your brain tell you how to survive in that type of environment?
Yes, so what you're speaking about, I'm sorry if I cut you off while you're still, okay. No. What you're speaking about are the adverse childhood experiences that may occur in these children in their environments, whether it is an inner city or what have you. And many of the youth that are disproportionately experiencing adverse childhood experiences are Black and Latino children, primarily in the inner city. in the inner city. I myself experienced 3 adverse childhood experiences before the age of 4 years old, including the death and incarceration of a parent. I should not be here because of that. But my family was able to put things in place so that I was not impacted the way someone else that I saw in my community was impacted. Disproportionately, Black children experience adverse childhood experiences at a rate of 61% compared to 40%. And so those types of experiences
I was trying to get into what happens to the brain development.
So this is what I'm getting to.
Yeah, I understand. So the super predator type of mindset might kick in earlier because of the environment, poverty, and things like that.
So the super predator mindset has been debunked by research for over a decade. Well, that is not an actual research issue. It's not something that can be proven. That is something that is a talking point. But I would not say that youth become super predators because they've been experiencing these types of environments.
Well, what about alpha males?
I'm going to defer to someone else to respond to that.
Thank you.
Thank you. Are there any other questions? All right, seeing none, that concludes this particular panel. And do we have anybody virtual, Mr. Okay, but Mr. Yuri is not there. Okay, I'm going to call, now I'm going to go to the panel of favorable with amendments. And I understand that Mr. Grand Prix is testifying across the street. So if he comes in, he's favorable, then we'll call him back up, members. All righty, so let's go now to favorable with amendments. We're going to just start naming names. Reverend Dr. Marlon Tillman, Melissa Goldman, Kelly Quinn, Natasha Darteague from the Maryland Office of the Public Defender, Kimberly Watts, I called out 5 names, so we might be able to fit everybody. Oh, we've got 4 people present, so. What about Nika Duckett Randolph? Okay, Reverend Dr. Tillman, if you want to start. We're going to go to Melissa, let's see. Melissa Goldman, okay, you'll be our last person. We'll get to you in just a moment. Reverend Dr. Tillman.
Chair Bartlett and members of the Judicial Committee, Bridge Maryland Incorporated is an interfaith organization with laity and religious leaders who pursue equity and opportunity for all Marylanders. We are in support of HB 433 with amendments. Children are redeemable. Children are redeemable when given the opportunity to be redeemed. And the law, any law that adultifies a child to justify their imprisonment is unjust. Any law that can traumatize a youth indefinitely into their adulthood is unjust. Any law that can place our children in danger of rape, abuse, isolation, or mental anguish is unjust. Thus, we see this bill as a good step forward to undoing the unjust legislation by addressing 73% of the children in the legal system who have been detained. Let's give judges back their discretion, wisdom, and duty to look at alleged crimes first in the judicial legal system based on each situation, for each child is unique and therefore different. All youth are redeemable and not to be thrown away. Our God requires that we do justice and to love mercy. Automatically charging any youth as an adult is an unjust law, and this is a good step in the right direction. We again vote favorable for this bill with amendments.
Good afternoon, Chairperson Bartlett and distinguished committee members. I am Kelly Quinn, a Managing Director of the Choice Program and a resident of District 46. I wish my delegate was here right now. The Choice Program at UMBC is in support of House Bill 1433 with amendments. As a mentoring program, we have served more than 27,000 youth and families since 1988. Choice helps children in the community because it is anti-racist and morally right. We want to abolish auto charging entirely. The reason why I wish Luke was here because I want to publicly acknowledge him. He met with Choice staff and youth on ACLU's Day of Action last Monday. I asked one of the youth as we left how she felt after meeting with him, and she said one word: empowered. She had been charged as an adult, one of the 932 children in fiscal year 24. On the ride home, she told me that she didn't think an influential legislator would ever listen to her. I hope you will. I only wish that he had had a chance to hear about her new job, her activities with her mentor, including visits to UMBC and CrossFit. This is the year for the General Assembly to recognize that Black and brown kids deserve to be treated like kids. The Choice Program urges a favorable with amendments report for House Bill 1433. Thank you.
Good afternoon, Madam Chair, distinguished committee members. I'm Natasha Darteague, Public Defender, and the OPD supports with amendments HB 1433. You often hear OPD say we must treat children as children, and this is because their brains are not fully developed. They fail to appreciate risk. They do not understand long-term consequences, but also age-appropriate treatment works. So I say thank you to sponsor Delegate Tolles and members of the Legislative Black Caucus for bringing forth this bill, because Black children are disparately impacted by the automatic charging laws. Over 80% of children are automatically charged in adult court are Black, despite comprising only 30% of the state population. The damage is on Black children, primarily from marginalized communities. The other piece that is important to note is that more white children are transferred from adult court to juvenile court. And these facts may not resonate with everyone. So let's talk about the money. The bill saves Maryland millions of dollars. Please look at the fiscal note. OPD's contractual expenses would decrease by approximately $1.4 million. There would be a reduction in OPD workload, approximately $2.6 million. DJS estimates that passage would cause spending to decrease by $12.3 million. And lastly, if that does not persuade you, please read yesterday's Maryland Matters article that was authored by retired Chief Judge Barbera, as well as letters from retired judges that ask, as OPD does, that you stop the practice of automatically charging children as adults, that you make Maryland courts more effective, that you create more just outcomes, and you advance science over bias. Please adopt OPD's proposed amendments and enter a favorable report. Thank you.
Thank you. My name is Kimber Watts. I'm an attorney with the Public Defender's Office. I'm the chief of our Forensic Mental Health Division. I've also been representing kids in both juvenile court and charged as adults for about 25 years now. For years, decades, we've been paying more money to have worse outcomes, as Delegate Tolles said. We know that rehabilitation works, particularly as compared to prison sentences. The process, as the gentleman from Ways and Means asked about, is what I'm going to address. So please feel free to ask questions. When kids start in adult court, they have a bail review in front of a district court commissioner and then another one in front of a judge. District court cases, well, adult cases always start in district court and have 15 days for kids to either be indicted by the state's attorney or have a probable cause hearing. From there, there's a 180-day time limit once they get into circuit court. When you look at the cost, that's where the cost is coming in. If it costs DJS about $1,000 a day to house a kid, that 15 days alone is $15,000 per kid. The 147 days that it takes on average for them to have a transfer hearing is $147,000 per kid. The opposite is true for when kids start in juvenile court. They have an intake hearing in front of a DJS officer. They then have a detention hearing in front of a magistrate. From there, there's 30 60 days at max to try the case. So the waiver hearing happens on average in about 27 days. Again, $27,000 per kid as compared to $147,000. That time is also critical because that's the time period where a kid hasn't even been found guilty. They're still presumed innocent at that point. As always, I'm happy to answer questions.
Good afternoon, Madam Chair and members of the committee. My name is Nika Duckett-Randolph, and I am a proud resident of the powerhouse that is District 46. I am not here as a policy expert, though Out for Justice is quickly changing that. I am here as someone who sees the truth plain as day. We are throwing kids away. And if we don't fix this, if we don't change course, we are going to have to answer for what we've done. House Bill 1433 is a step in the right direction, but we cannot stop until we have ended the automatic charging of all kids as adults, regardless of the circumstances. The idea that a child, no matter their mistake, should be forced into an adult system before anyone takes a real look at who they are or what they've been through is not justice. That's failure. Kids deserve to be seen for who they are, not just their worst moments. We know the science. The research is overwhelming. Kids' brains are not fully developed, and their decision-making is impulsive, emotional, and influenced by their environment in ways that adults aren't. Instead of addressing that, we put them in an adult system that only hardens them, isolates them, and increases the chances that they will never recover. Maryland can do better. Maryland must do better. This is personal. I think about the kids I see every day, my nephews, the students I mentor, young boys and girls walking home from school, laughing, running, playing. I think about how, if they make a mistake, just one bad decision at the wrong time, at the wrong moment, their whole future could be decided by a law that doesn't even consider their full personhood. And it is not just any kids that this happens to. We know exactly which kids this system swallows up. Black and brown kids, foster kids, poor kids, kids without someone to fight for them. I don't have to wonder why. It's the same reason this state has failed so many generations before them. We have a choice, and it's an easy one. Pass this bill and fix it first. Amend it so that no child is automatically sent to adult court no matter the charge. Let's trust our judges and professionals to make individualized decisions. Let's put kids in systems designed to help them, not break them. We cannot in good conscience continue to automate a deliberate process. Thank you.
Thank you. We're going to go to Melissa Goldman, and then we'll take questions.
Thank you, Madam Chair and members of the committee. I'm a resident of Silver Spring, Maryland, and I'm also the Senior Policy Counsel for the National Youth Justice Network. On behalf of NYJN, we urge the committee to issue a favorable with amendments report on HB 1433. This bill will help to ensure that for many more young people, the decision as to whether to charge them as adults is given the serious consideration by a juvenile court judge that such a significant life-altering decision requires. Our goal should be to rehabilitate young people so that they can lead healthy, productive lives going forward. That is the humane thing to do, and it's also the best route to protecting public safety. Keeping large numbers of our youth in adult courts and adult facilities runs counter to this goal. The conditions for young people locked up in detention facilities run by the Department of Public Safety and Correctional Services are often dangerous, overcrowded, and lacking in medical and mental health treatments. In a recent call that I had with a public defender in Baltimore, she shared with me that one of her young clients, who'd been locked up in the youth detention center run by DPSCS, was refused medical treatment for a bullet lodged in his foot. He was forced to pull this bullet out himself. In another situation, a young client of hers, housed in Towson Jail, also known as the Baltimore County Detention Center, was stabbed twice while he was there. I could go on, but this is an inhumane way to treat our young people. By passing this bill, far fewer youth will need to be initially detained in DPSCS facilities due to being auto-charged. Additionally, even if a prosecutor seeks to waive them from juvenile to adult court, the process will move much more quickly, and DJS will be able to accommodate these young people in juvenile detention facilities where they will be safer. We urge you to amend this bill to end the practice of auto-charging for all youth and to vote in favor of it. Thank you.
Thank you, Mr. Chair. My question's for the
the ladies from OPD. I just want to understand the two processes. So if we switch from the process where they go to, I'm just going to call it big kid court, and then before, so they're charged as adults, they're in this line, this system, then they get sort of held by DJS potentially while they're awaiting their actual trial. Then they come up to, big kid court, and then they would go into the regular prison system if they're found guilty. Is that how it typically works?
So, and if I'm understanding, sorry. So when a child is charged as an adult, the case begins in adult court.
Right.
And the court has a particular amount of time to, in fact, indict the child if it's a serious felony.
Okay.
So generally, it's around 15 to 30 days.
Okay.
So you're accumulating the cost by how long it takes. In the adult court, generally, you have 180 days to bring the case to trial. The reality is, depending upon the jurisdiction, like for example, in Baltimore City, for a case to actually go to trial, it may be 18 months to 2 years. But the cost is being accumulated how long it takes. As opposed to in juvenile court, by statute, it requires a first hearing within 30 days. Okay. What we have not touched upon is essentially, by starting a case in juvenile court, you also have a sooner resolution for the victim. Because in juvenile court, the calendar moves more quickly. Okay. So within 60 days, there has to be some sort of resolution in juvenile court.
Okay, so let's say then we move everything to the DJS process and everybody's automatically goes there. They have a trial within 30 days, essentially. Let's say that it's facts sustained. Is at some point, if they haven't been waived back up, what happens? So they don't go to prison, obviously, because they've stayed in the DJS line. They're not going to be housed for 18, 24, 6 years for murder in DJS. What happens? Do they get sent home?
So I just want to be clear. So it is not a DJS process. It is the court system, but it's a court system, either you being adjudicated in the adult system or you being adjudicated by the court in the juvenile system.
Okay.
So if you are found fact sustained in the juvenile court, that is the first prong, and then the second prong, the court will make the determination as to what are the needs of the child.
Okay.
So that includes placement, for example, in a juvenile facility, and depending upon the needs of that particular child, and that is another important difference, that when we are automatically charging children as adults, we're not taking into consideration the individual needs, development, and circumstances of that child. And when you give the decision to the court to determine the proper place to adjudicate the case, then the court, a neutral arbiter, can make that decision. And if deemed necessary, the court would have and does have the authority to determine whether or not it stays in juvenile or move it to adult court.
Okay, and what percentage of your cases where they do get charged as adults would you say that you try to waive them back down to juvenile?
100.
100%. And how many are successful right now?
As Ms. Anderson said, it's about 80%.
80%. Okay, so it's got a pretty high success rate.
And what I would add to kind of your steps in the process is that when somebody is charged as an adult, they may be held in a juvenile detention center, but they're still facing the adult charges.
Right.
So, okay.
Yeah.
I just wanted to clarify that.
Yeah, we actually, several members of the Freedom Caucus got to go and with DJS and look at the Hickey School recently, which was much appreciated. We learned a lot. Okay, so I think I understand the system a little bit better now. I just want to make sure I understood I have an actual flow chart I drew because I'm still in 6th grade. So now I understand how it works a little bit better. And I definitely get your point on the 30 days piece. But I think a lot of us are just concerned that there could be some really egregious situations that maybe could fall through the cracks, and we could have somebody who's really a threat to society that ends up back on the streets when they shouldn't be?
So if I can address that, like some of the most egregious cases that come to mind are like Nick Browning, who at 15, a week before his 16th birthday, killed his entire family.
Right.
That was in, I think, 2008-ish. So had this law been in place at that point in time, I have every confidence that the state's attorney would have filed a waiver hearing. I have every confidence that I would have lost that hearing. I don't see me winning, even for a 15-year-old, a quadruple homicide.
Okay.
So, he then gets moved to an adult facility to be tried. There's another infamous case from, I think, 2000 of Felix Fitzgerald, who sexually assaulted a staff member at Hickey, actually. He was charged with what at the time was first-degree sex offense, now would be first-degree rape. That would start in adult court. Again, I can file for transfer. I don't know if I'm going to win that or not.
And under this bill, would that now be, that would both of these would start in DJS?
Well, Fitzgerald would have started in adult court.
Even under this bill?
Yes.
Okay, all right. I appreciate you guys answering my questions.
Well, I'll wait. I have a couple questions. Delegate Hornberger.
Thank you, Mr. Chair, and again, thank you for having me as a guest. I definitely agree with you. Justice delayed is justice denied. We want to move these people through the system as quickly as possible. For the worst case offense that would have, if it's status quo, gone to adult court, so now we're saying it's going to the juvenile court. If the charges are brought forward, the person accepts a plea deal, or maybe he's convicted, or what have you, of those offense, what is that top line offense as described by the bill? So what would be the most egregious offense that someone would be convicted of?
I'm not sure I understand your question, so let me rephrase it and tell me if I'm wrong.
Yep.
Are you asking what the most serious offense under the current bill someone would start in juvenile court?
Yep.
I think that's probably strong-arm robbery.
Okay.
Possibly first-degree assault. They're both in the same serious category, I think, in the sentencing guidelines.
And then what would be the typical duration of incarceration for that?
In juvenile court, I assume you mean?
Yep.
So it's really going to depend on the kid and the kid's needs. Typically, DJS does what's called a massed staffing. So they do a psychological evaluation, a psychiatric evaluation, which is slightly different and looks at like whether they might need medication, and an in-depth social history. Based on that, they provide referrals to specific programs designed to meet the child's specific needs. So some kids just have, behavioral modification needs. Some kids have significant mental health needs. And so how long they stay in the system is really going to depend on what their needs are. So let's just say then that they finish their program, however long that takes them, and they have a loving, supporting family that can take care of them when they get home, then they may be able to just go home. I've had plenty of clients who, I'm sorry to say, did not have that, and they wind up going to group homes and foster care homes. And so their commitment to juvenile services lasts a much longer time.
If I may piggyback, I think it's important that we speak about not only the 14%, but the 86% that, in fact, are transferred back. And the emphasis is that we are creating a great deal of harm having that 86% of children that are in the adult system for those months and months, especially when we know those cases are likely to be going back to juvenile court. So for those 86% at the very least, let's start them in juvenile court and not create that harm.
Yeah, so you kind of answered my second question is there going to be a scenario where you're in juvenile court, you age out, and then somehow you're moved because of the duration of your incarceration to adult court? Doesn't sound like that's the case. No. And then the second question is, let's say that someone is in detainment, whether it's pre-trial, post-trial, et cetera, they commit a crime while they're in detainment, and it rises to the level of adult court. What does that look like from a transferability standpoint and the discretion of the judge? Does this bill in any way impact that?
don't think that the bill would impact that. Again, like where the case starts depends on what the charge is. But like to use the case from Hickey as an example, even under this bill, he would start in adult court. He would have an adult bail review. We would file for transfer probably, and I don't know if we'd win. I like to always be optimistic about my chances, but that's a tough sell.
Sure.
And then he would be, the judge could hold him in an adult facility the entire pendency of the trial, and
Yeah, I mean, it could
obviously probably would in that situation.
There could be discovery too. I now,
Oh, yeah.
I now admit to also a murder or also some other offense. So I guess where I'm getting at is there's still the preservation of the ability of the judge to move the person to the other court should they determine necessary during this process.
And there's the ability of the state's attorney to ask them to do that. They can ask them to do that for any charge once a child is 15. And in the case of, under this bill, actually, even under current law, once a child is 12, they can ask for them to be charged as an adult if they're charged with first-degree murder or first-degree rape.
All right, thank you for that clarification.
Sure.
Madam Public Defender, how, Mr. Artigue, how long does it take from the time that the child is arrested and taken to central booking, they're charged as an adult? How long does it take them to get the representation of the Office of the Public Defender?
You mean to be assigned counsel from the Office of the Public Defender? We generally assigned a time of arrest or close to it.
I mean,
How
currently.
soon do they enter?
So I'm going to say that varies by jurisdiction. Well, that's true. So, but he also works in Anne Arundel County. So now I don't know how to answer that. But our processes did change a little bit a few years ago when intake had to be, well, not intake, but like the qualification had to be done by a commissioner. So the commissioner, at least for incarcerated people, does that immediately. I can say in most jurisdictions, we pick up those cases, we prioritize them. Like we pick them up in Baltimore City almost immediately, if not in fact immediately at bail review. And it's the same where you practice in Anne Arundel County.
So, but it could be as long as a week, or, I mean, how?
No, that would be a longer.
On the long side. How long does it take from the time the attorney enters for them to file waiver?
So therein lies the challenge, because in PG County, for example, the judges actually will entertain a transfer motion while the case is still in district court, but nowhere else will they do that. So you have at least that 15 days while the case is still waiting for a probable cause finding before we can file the transfer. But typically, it's one of the first motions we file. As soon as we know that a kid is eligible for transfer, that's among the first things we do.
Right. Going to Baltimore City, do you happen to know how many kids are waiting transfer right now?
One of our other witnesses is Crystal Williams, who has worked most recently in Baltimore City. So I'm going to suggest you ask her that question.
Okay. Delegate Phillips.
So, Mr. Chair, that was a great question because I'm thinking about a question that might relate to that. How much of an impact, we talk about disparities, racial disparities, how much of an impact do social economic issues, wealth, have on both the decision for charging and also the waiver up or down of children in the system? And the existence of private counsel. I know that's like 3 questions.
So I will begin and then I will tag team my colleague. So I would first start by saying when a child is charged as an adult, and we're not looking to the offense of murder, but a serious offense, for example, robbery, deadly weapon, or carjacking, they go before a commissioner and then before the judge, and the judge sets a bail. The issue comes in terms of the ability to make bail. So if you have a child from a more marginalized community, a poor single income, the issue of whether or not that child is able to make bail versus a child that comes from an affluent family. So I would say that's the first place where you see a disparity in terms of treatment based upon income.
I would say that it's a bit more ingrained than that as well. Quite honestly, in my experience, just to use an example from my community, also your community, since you're my delegate, one of my daughter's classmates, and I should say, just so you understand, like, this is the sort of thing that happens to all kids in all walks of life. She's in AP and GT classes. One of her classmates got into a fight with a boy. He fell and hit his head and blacked out for a few seconds. That boy was charged with first-degree assault. He is, from a relatively affluent family, and was immediately able to get out on house arrest because his family could afford to pay that. My clients' families can't. And so I think you can't underestimate the impact of being poor and being part of the system. And when you add to that the many, many kids we have who are wards of the state through, foster care, and we've terminated their parents' parental rights, they truly do have no one advocating for them except for us. They don't have a foster parent that comes with them to court. They have a DSS caseworker, and I can tell you that we call it like the hot potato game because, as soon as a kid who's been in custody of DSS for their entire lives gets in trouble, now they're DJS's problem. It's horrifying.
And so as we get deeper in the process, does the issue of wealth continue to exacerbate itself as you get deeper into the process?
Absolutely. Because as I was saying before, if you're lucky enough to have a supportive family who can take care of you and make sure that the things you need are the things you get, then you're much more likely to get released home, but also much more likely to never get in trouble again. And the steps that DJS is currently taking in terms of workforce development are crucial. As the secretary said earlier, my clients have been begging for as long as I've been an attorney, I need help getting a job. I don't know how to get a job. And a lot of them don't have the soft skills. They don't know how to, it's not as simple as just showing up on time. It's like how to interact in an interview, how to speak formally as opposed to slang. And so the programs that DJS is undertaking are critical to all of us having safer communities, because we know that if people don't recidivate, then we're all safer.
All right.
I just want to piggyback.
Thank you.
Feel free. Yes.
Thank you, Mr. Chair. I thought I heard from both the Madam Public Defender and also Ms. Goldman that you were testifying in favor with amendments. And if so, could you just describe those? I don't recall really hearing what they were.
So in terms of the Office of the Public Defender, we're seeking the consideration of all offenses. Okay. And it is delineated in our written testimony specifically.
Okay. All right. Thank you.
And that would be the same for the National Youth Justice Network.
Thank you, Mr. Chair. What is the recidivism rate for violent crime youth offenders?
Youth offenders? I honestly would have to look that up in the DJS data resource guide. What I can say is that when you look at their recidivism, because they report recidivism, honestly, in a number of different ways, which I think is pretty useful. When you look at their recidivism rates for kids that have been charged as adults and released from facilities after completing their program, I think it's like 20%. But when you look at the DPSCS rates, first let me say DPSCS in terms of apples to apples, they are not even counting apples. Like they're pretending it's an apple. They don't look at rearrest rates. They don't look at reincarceration rates except for as it relates to the DOC. So it's just people coming back to them, which I think is not great. But there, even with that, it's still like 37% recidivism rate, which is significantly higher than DJS's rate.
Okay, and I'm asking because I'm looking at the NIH right now, so it looks like, according to them, that if they are released within 36 months, the rate is about 61.2%.
That could be. I mean, in terms of rearrest, that may very well be.
Okay. Now, do you take into consideration that, you know, there are certain mental disorders that are very difficult to treat, and frankly, there are some people who just are not able to function in society. And when you look at psychopathic behaviors, you start to see that in adolescence. And, you know, even before it becomes psychopathic, you have conduct disorder, oppositional defiant disorder. And as they escalate and they become more impulsive and have a thrill-seeking sort of behaviors that result in them seeking thrill through committing certain acts, you know, and I'm talking violent crime, I'm talking, you know, rape, robbery, homicide. I'm going to be honest, I do have a concern about this bill allowing all offenses. Doesn't matter what the offense is. I mean, have you all considered the rate and some of the factors that will, you know, be almost difficult for some people to be habilitated? Sometimes it's not rehabilitation, sometimes it's habilitation.
So what I would say is we don't want to throw out the baby with the bathwater. I certainly understand your concerns. You know, I live in the community too. I don't want to be raped and murdered. Ballpoint, you know, that's a valid point. But what we do know is that most kids will grow out of this behavior. The numbers that won't are pretty small, but when we treat them all as though they are going to keep engaging in these behaviors, we increase the likelihood that they will.
Okay, so, but are you aware that there are some behaviors that are not outgrown? If anything, they progress, they escalate, especially when you're talking about psychopathic behaviors.
And we acknowledge that and acknowledge your concerns. But what is taking place in this bill is the consideration as to where does the offense start. Oh, I'm sorry. The consideration in the bill focuses on where does the offense start. Does it start in the adult court and the state's attorney makes that decision, or does it start in the juvenile court and we have a neutral arbiter, a judge makes that determination as to whether or not it stays in juvenile court or it is heard in adult court? Nothing in this bill precludes it if a judge deems it appropriate for the matter to be heard in adult court. So the issues that you are speaking of are extremely relevant, but that is not what the bill is attacking or addressing. It is just saying, take it out of the hands of the state's attorney and allow a judge to make that determination. And since we know over 85% end up in the juvenile court and it saves us money, let us just start it there. And that is the essence of the bill.
So why is it that you still have 20% that remain in or that don't make it from adult or not approved for the juvenile court? What about that 20%?
There are five factors.
Are they more violent? Are they more?
Well, the court is making, and that's the thing. So right now, the way Maryland is, we are just automatically just pushing our children into the adult system. When the judge is making a determination, the judge is looking at 5 factors at that individual child. And one of the factors does include the seriousness of the offense. But the judge also looks into the amenability of the child. But because you're looking at the individual child and considering the factors, of course there will be times when perhaps it's not appropriate. But what we've seen is that over the majority of the time, it is appropriate. And we're asking that we do not continue to harm our children, especially our Black and brown children, that we not continue to harm them.
Yeah, and I agree that, you know, we certainly don't want to do any more harm than good, but we certainly don't want to do more harm to the community if we're allowing people in society who have severe issues that are almost, and you know, I mean, I'm only speaking from experience, okay? And I've worked in juvenile detention centers, and I know that there are some children that have these behaviors that could have been inherent, could have been genetically predisposed, or it could have been their environment that contributed to it. And there are some people that just can't be rehabilitated and function in society. So I'm wondering if that 20% are kids that, when you look at these 5 pillars, or you mentioned immutability, severity of the crime, I'm just wondering if that 20% are the ones that the judge determines is just not fit for, you know, any sort of rehabilitation, or
And under the bill, the state still has the opportunity to seek that they are charged as adults.
Okay, thank you.
But under the bill, it's the standard that exists now as to whether a case should be in the juvenile side. So in other words, it would be effectively what would be in the best interest of the child?
Actually,
I'm sorry, I missed the question.
So the standard that would be used under the bill, what would the standard be under the bill?
The standard under the bill for waiver is, and this is existing law, is whether the child is fit for juvenile rehabilitative measures. So they have to look at whatever programming is available through DJS and determine whether the child is fit for those rehabilitative measures.
So if there's literally any rehabilitative thing that might possibly be available for a juvenile, that would be acceptable.
It's determined child by child, yeah.
And that is what is in fact now being determined child by child, and that's what happens child by child though, right?
It's my understanding that we're automating at the front end when we should be deliberating at the front end instead of automating it. So that's what I understand the discrepancy to be.
But I guess what I'm saying is if we're just going to adopt the same standard that exists right now and then drop it down.
Oh, but it's.
If you wanted to go the other way,
but I think
you're putting a perhaps even bigger roadblock in front of cases that are more serious.
No, we're moving it from the discretion of the state's attorney to the discretion of the court. And so when it's charged, when it starts in the juvenile court, the judge will make that determination, as opposed to now, the state is automatically charging these children.
But at that point where we are in the process, at that point in the process, you're at the waiver hearing. You have that standard, and you've moved the standard then under this bill from there down to the juvenile hearing in order to move it up. And it is also a challenging standard for the state then to overcome too, right?
Yes, so, but just let me.
No, I mean, that's fine. That is a perfectly fine answer. I just wanted somebody to say it. That's what effectively would happen, is you just shift the standard.
We do, but it also is a different standard. So the standard.
Okay, so it's a different standard.
Yes, that's what I'm trying to say, is that in transfer, the question that the judge has to answer is it in the best interest of the child or society to transfer a child to juvenile court? In a waiver proceeding, the question the judge has to answer is the child fit for juvenile rehabilitative measures?
That's a different question.
I don't know why the statutes are different, but they are. In terms
Maybe
of
something for somebody to look at.
in terms of, whether it will be more difficult, the burden will be on the state to prove that the child is unfit for juvenile rehabilitative measures. That being said, when you look at the data dashboard from GOCAP, there are about 100 offenses where kids are charged as adults that don't start there. And so I have to assume that those kids all got waived.
So as part of the waiver hearing, how long is it between the time that a waiver hearing is requested and the waiver report is finished?
Well, apparently the average length of stay for that period of time is 27 days.
So it's about a month for the report to be complete?
Yeah.
And does that vary depending on what part of the state you're in?
Apparently not.
Okay. The number of people, all right, I'll get to that question a little bit later. Delegate Kaufman.
Yes, I have 2 questions, if that's okay, Mr. Chair. It's brief. Madam Public Defender and Ms. Watts, you have talked a lot about people of color, as you should. But isn't it also, I would bet, Ms. Watts, if I were a betting man, that a lot of you, because Delegate Congolo mentioned oppositional defiant disorder and other things like that, that a lot of the people that you interact with who are charged as adults have disabilities. Is that accurate or not?
That is accurate.
And then also, just following up also on Delegate Congolo's question, what you're advocating for goes further than what the sponsor proposes, because her bill outlines specific instances where this process people could not be brought back down to juvenile court. Is that correct? So that your request goes a little farther than what Delegate Tolles is intending?
Our request does go farther than what Delegate Tolles is proposing, yes.
Thank you.
Delegate Tolles, and this will be it. Delegate Tolles.
Huh?
You like time?
I know. I'm getting it out.
Okay.
Thank you. So this question, so I need y'all to answer y'all questions succinct, because as you can see, the chair want to move on, and y'all taking a long time answering these questions. So let's just be succinct in our answer. So actually, this question is for Madam Public Defender. To Delegate Kaufman's point, that is going farther than what this bill does. But first, let me start off and say, for my bills, I prefer you say Prince George's County. Okay, so let's put that on the table now. So to my question, would you, considering that this bill it's a cost savings, it impacts Black children more than anyone, which the racial disparity note says that. Would you rather move the needle or not move the needle? So it's a simple question, Madam Public Defender. In this bill where we are moving the needle to some level, or would you rather keep it as is? And if you can answer that as succinct as possible, there's only two ways to answer it: either move the needle or do not move the needle.
I'm going to say yes. OPD supports the bill. The only thing I'm saying is that include all children, but right. OPD does support the bill.
Well, I think that's, when you say include all children, we are including in all children. It just says that, any charges in first-degree murder, second-degree murder, they still can waive it down to the juvenile court. We're just saying that certain charges would start, the majority, handgun charges, which, as the chair said himself, are the majority of the cases that we see, would start in juvenile court. So I'm asking in terms of the Office of Public Defender, we are trying to move the needle by having some of the majority of these charges start in juvenile court. If this bill were to move forward and we needed to take that posture, would that be something you would move in the direction of supporting?
Yes, OPD supports changes.
Right, but you said with amendments. Without your amendments is what I'm saying. Is that a yes without the amendments?
If this ends up the only thing that is moving forward, then OPD supports it.
Correct. Okay. Thank you, Mr. Chair.
Thank you very much.
Thank you.
The next panel, Mr. Lawrence, sorry. Okay, Lawrence Grand Prix, got it. And then him, Ryan Palmer? Ryan Palmer, just checking. All right, sir, go ahead for 2 minutes, please. Well, and then we have those people who, we have favorable with amendments.
Yeah.
All right, we're gonna talk to you. Good. 2 minutes right there, and then we'll go to other people. Right.
Lawrence Grand Prix, Director of Research for Leaders of a Beautiful Struggle, urging a favorable report. The Sentencing Project shows that despite youth representing 5% of arrests, youth were mentioned on over 50% of Fox 45 news studies that mention the age of offenders. Given that they do this twice as much as other news outlets, it feels like we're operating in a world where youth do 50% of the crime. That's not true. So here's some data to help support this bill. First, bias prevents the current system from working. A study by Goff et al. Called The Essence of Innocence says black youths are deemed 2 to 5 years older and are deemed less innocent. They call this adultification. So automatic charging equals automatic adultification, denying innocence to our children. A Chen et al. Study says that one of the determining factors of dangerousness and culpability of youth accused is the darkness of their skin. This is not about shortening a sentence for hardened offenders. This is giving the space to deal with this bias. The second point, automatic charging equals negative consequences for our youth and communities. A 2010 report by OJJDP says the best studies showing any deterrent effect of adult charging are over 30 years old, and more recent studies show no deterrent effect or even some negative impacts of charging youth as adults. They give 2 reasons. First, neglect effects. It's the saying more likely to receive services to prevent recidivism in youth facilities. We know many of our youth are going to return to DJS facilities, but remember, the alternative is adult facilities. That leads to the second issue, and I want to read this as a quote. Compared to those in juvenile facilities, juveniles incarcerated in adult facilities are 8 times more likely to commit suicide, 5 times more likely to be sexually assaulted, and almost twice as likely to be attacked with a weapon by inmates or beaten by staff. They call this the brutalizing effect. We cannot naturalize the violence happening in adult facilities because it's not only impacting our youth, it's leading to the recidivism that we can prevent with this bill. Finally, study shows this works. A Kaufman study says that youth with similar assault cases, those who are formally processed versus informally processed, those informally processed have rearrest rates and reincarceration rates 20 to 40% lower than those who are formally processed. We cannot let a pandemic spike in violence ignore this decades of evidence supporting this bill.
Questions? Seeing none, thank you very much. Now we'll go back to favorable with amendments. Josh Rovner, Crystal Williams, Frank Patinella, Flannery Gallagher, Aubrey Edwards-Luce.
Thank you, Mr. Chair, Madam Vice Chair, and especially Delegate Tolles for sponsoring this bill. My name is Josh Rovner. I'm the Director of Youth Justice for the Sentencing Project and a resident of District 18. We welcome steps that would limit Maryland's aggressive use of automatically sending adolescents to adult courts based solely on the charge. However, there's no evidence that carving out individual offenses from starting in juvenile court for youth is better for public safety or for youth themselves. My written testimony points to research reviewed by the CDC and National Research Council, consistently finding that sending a youth to the adult system generally increases rates of violence among youth. Ending automatic charging is better for public safety than striving to concoct the quote-unquote right list of charges. Importantly, Maryland allows for discretionary waivers under which adolescents can be transferred to adult court. In fact, 20% of youth charged as adults since 2013 were charged discretionarily. Ending automatic charging would still leave the discretionary pathway open. Clearly, too many young people, most of them Black, begin their cases in adult courts under current law. Please note that youth found delinquent in the juvenile system can be held through their 21st birthday. The current process is so inefficient that reforming it will save the state $17 million a year once fully implemented. HB 1433 is a step in the right direction, but more steps are required.
I will take Mr. Rovner's extra time if you don't mind. Crystal Williams here on behalf of the Office of the Public Defender. Greetings, Chairman and members of the committee. I'm here to testify on behalf of the agency, but also as an attorney who has experience representing youth charged as adults in Baltimore City, as well as kids in the juvenile system. And first and foremost, I want to make sure that we highlight the fact why we are here today. And what needs to be said is that this bill does in fact represent years of research, data, undeniable facts, shifting opinions, and highly negotiated, coordinated, and collaborative efforts, culminating all around and uplifting a necessary change in Maryland's laws. This very body passed legislation in 2019 to formally vet out the best path forward in addressing long-standing, problematic, ineffective, and costly juvenile justice laws and practices. The 2021 report from the JJRC evidenced additional time and careful consideration specifically around the issue of charging youth as adults, and they came to the conclusion and recommendation that was very clear. Based on the testimony and data received, the council recommended that the state end automatic charging of juveniles as adults and instead require that all court proceedings against juveniles be initiated in juvenile court. And yet, 4 years later, this body is still struggling with accepting what is not only clearly the right thing to do, but the factually proven recommended solution for public safety and criminal justice in Maryland. Indeed, holding on to false notions that charging children as adults is the best way to keep the public safe is actually harming our communities and making all Marylanders less safe. We know that 95% of incarcerated youth will return to their communities before their 25th birthday, because as we know, not everyone is incarcerated for life. When we lock people up, they eventually come home. We also know, because of years of research, science data has shown us that prosecuting children in the juvenile system where more immediate services and repercussions can be met is in fact the most effective way to rehabilitate. If I could have your grace. Thank you. It is the most effective way to rehabilitate their highly malleable and formative brains and behaviors, curbing the likelihood of engaging in more crime and providing them with critical tools to open doors and pathways for a life away from crime. This struggle to pass even the most limited and carved out versions of automatically charging children as adults so that more youth can be properly and successfully rehabilitated also clearly demonstrates how uniquely and deeply embedded this notion in Maryland's history.
Ms. Williams, please.
And larger story of how it must continue to rectify the rippling harms of misguided laws.
It's in writing. You can submit it to the committee, and that'll be fine.
5 more seconds.
No. Mr. Patinella. Whoever would like to go next, I'm sorry. Please submit it to the committee.
I appreciate you.
Yeah, that's all right.
Good afternoon. Flannery Gallagher. I'm a legal fellow at the Center for Criminal Justice Reform at the University of Baltimore School of Law. We're grateful for this opportunity to testify regarding House Bill 1433. We urge this committee to issue a favorable with amendment report, amending this bill to end the automatic charging of children of all ages and for all offenses in adult court. To be clear, HB 1433, including with the amendments we support, does not prevent a child from being prosecuted as an adult in Maryland's criminal courts. Instead, it simply ensures that cases begin in juvenile court where a judge can determine whether transfer to adult criminal court is appropriate. The research is overwhelmingly clear and consistent that automatically charging children as adults causes more harm and makes us less safe. Youth prosecuted in adult court recidivate at higher rates than youth charged in juvenile court, including when researchers matched their offense type and profiles. A number of studies have shown that youth in adult court also recidivate sooner and more frequently than their peers adjudicated in youth court. And as compared to youth in the juvenile system, youth in the adult system are particularly more likely to commit the most violent offenses in the future. These higher rates of recidivism can be attributed to a variety of causes, including lack of access to rehabilitative resources in the adult correction system, problems when housed with adults, and direct and indirect effects of a criminal conviction on the life chances of a child. Put another way, we should end the practice of automatically charging youth because it's better for kids, especially youth of color and youth who have experienced adverse childhood experiences. But we should also end the practice of auto-charging youth as adults because it's better for all of us and will improve public safety and community well-being. For the foregoing reasons, we urge a favorable with amendment report. Thank you.
Good afternoon, Mr. Chair, Ms. Vice Chair, members of the committee. My name is Aubrey Edwards-Luce. I'm the Executive Director at the Sarah and Neil Meyerhoff Center for Family, Children, and the Courts at the University of Baltimore School of Law. There are 40 to 50 children in adult jails on a given night in Maryland. Only Baltimore allows youth who are charged as adults to stay in juvenile facilities. Sending youth to the adult criminal system is a serious action. It communicates, contrary to the research, that an adolescent is undeserving of the hope and rehabilitation that's found in the juvenile legal system. It tells teenagers that they are hardened criminals. It says to young people, even before they've had their day in court, that they need the harsher, longer, more punitive punishment that's found in the adult criminal system. It prolongs separation of teenage children from their families and teenage parents from their very young children. Automatically charging youth as if they are adults is in direct contradiction to their well-being, our community safety, and children's right to family integrity. CFCC has submitted written testimony that urges the committee to amend HB 1433 so that all youth would start in juvenile court and then be waived up as requested by the state's attorney or approved by the court. Kids who have not yet been adjudicated deserve individualized assessments with a judge before they are placed in adult carceral and punitive settings. If amended as proposed, this bill would protect youth's constitutional rights to family integrity, align our legal system's practice with the science of adolescent development, and protect youth from harmful conditions and facilitate youth's access to developmentally appropriate services. For these reasons, CFCC supports HB 1433 with amendments that would end the automatic charging of all youth for all offenses. Thank you.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. Frank Patinella, Senior Advocate with the ACLU of Maryland, and I'm going to give to you what you all been waiting for and say, me too. And I just want to emphasize the amendments here. It's important that we do it now to start all children in juvenile court. And that, we got to get out of this super predator narrative. It's been decades long debunked, so thank you.
All right. Questions? The Vice Chair. Do you want to ask a question or, okay.
Yes. I'm sorry. Thank you, Mr. Chair. I wasn't sure I was going to ask this question because I kind of feel like it's been answered, but I need it to be a straight line. And the woman next to Ms. Luce, I can't remember your name, I'm sorry.
Yeah, Flannery Gallagher.
Say it again.
Flannery Gallagher.
Thank you. So I thought I heard you say that automatically charging youth as adults decrease our safety. I think that's what you said, something along that line. Can you draw the straight line to that? On how you reach that conclusion?
Sure. Thank you for the question, Vice Chair. So youth who are automatically charged in adult court and youth who are adjudicated in adult court recidivate at significantly higher rates than youth who are adjudicated in juvenile courts. And there are a variety of different ways to measure recidivism, and throughout those types of measurements, that has proven to be true in the literature over and over again. So it makes us less safe by increasing recidivism for children who are coming home out of juvenile courts and children who are coming home out of adult courts.
Okay, and so perhaps that, 180 days that that a youth is spending in an adult detention center, lockup, or wherever they are in an adult facility, perhaps that is endangering them. Could that be?
I think there's a reason. Yes, Vice Chair. I think there are a lot of reasons to believe that's the case for a couple different causes. One is during that detention in an adult facility, that child is not receiving the types of supportive services that are addressing the root cause of how they got there in the first place. And at the same time, they're incurring additional trauma, being exposed to violence with people who are much older than them, and in some cases, as the committee has heard today, being placed in solitary confinement to be restricted from sight and sound of adult incarcerated people.
May I add something here, if that's all right? So she's right in that youth who are charged as if they're adults are more likely to offend, about 33% more likely. Now, I didn't say 100% more likely, because there's a lot of kids who are going to reoffend regardless of which system they're treated in. What the evidence shows, those studies that looked at 14 different states that had auto charging, and in 13 of those states, youth were more likely to reoffend, and in the 14th state, it was equal afterwards. These are some natural experiments. So like Idaho passed some auto charging in the early 1980s while Montana didn't, and offending went up in Idaho and stayed the same in Montana. You can compare Philadelphia to New York, northern New Jersey counties to New York City. Over and over and over again, the data, the research, the evidence, backed up by the Centers for Disease Control and Prevention and the National Research Council, said that youth who are charged as if they're adults are more likely to reoffend. This is a public safety bill.
Okay, so let me just ask you this question, Mr. Rovner. So with that said, with those states, that's very helpful, that comparison. Were those children housed or detained in adult facilities when they were automatically charged as adults?
I don't know.
Okay, that's fine. I was just wondering, because I was trying to make that line that goes from 180 days. When we have school, you're in school 180 days. We're supposed to be in school 180 days. So essentially, these kids are missing a year of school. And I was trying to understand how that was working out.
Yeah, I mean, this process is so bad for the young people we're talking about that they die younger. A recent study showed that comparing kids who are charged as if they're adults and incarcerated, 5% of them died by age 39. That compared to 2% who died by age 39 for a control group. Okay. Prison and jail is bad for you.
Thank you.
It's good to see you, Ms. Williams, again, back here at the committee. And so I asked before, how many people in Baltimore City are awaiting a transfer hearing? Do you know?
Yes, Chair, thank you. And I do have those numbers for you. We were actually able to get some current data specifically for Baltimore City, and that is around 100 cases. So we have, I've seen a couple numbers.
Maybe multiple cases for.
So you're asking specifically for Baltimore City?
Yes.
Right, correct. So approximately 98 is one number I got. I also got a number closer to it on 118. So I'd say roughly 100 for Baltimore City.
All right, and so that was where I was going. Those are cases. You may have people, juveniles, who have multiple cases.
That is.
I have 70 waiver hearings that we're waiting.
That is true. There are cases that can be duplicative where you have one client who has multiple cases in either juvenile court or adult court or both.
And my numbers, the numbers that I've received say that 42 are being held in some kind of lockdown detention. 22 are being held within a DJS facility. 4 on home detention, 2 in bail, and the rest apparently are on pretrial, as I understand it. So it's not to say, and I've went to the Juvenile Justice Reform Council here, and we've had this bill multiple years. I understand the issue with adult jail, but coming down here, in Baltimore County, how many people are waiting for a waiver hearing?
I cannot.
54. 11 are at the detention center. 31 are at DJS. The majority, it appears, as I look around the state and I ask for information, of kids are being held at maybe not everywhere, but in many places at DJS facilities. In Wacomico County, 9 waiting for a waiver hearing. 3 are physically at a detention center, or I'm sorry, 3 are physically at the detention center, 5 are at a DJS facility. 1 is on pretrial. I guess what I'm trying to say in a bigger picture here is, I get the argument. The argument is that all of these kids are being held in adult facilities. We have made changes, then the changes that have happened over the last 7 or 8 years, in fact, have allowed many of these kids to move into a DJS facility and to be held there because we've sought to avoid some of the problems that come from adult facilities. It strikes me that the issue here is more of a choice of law issue increasingly than not. And so going back to Ms. Williams, not trying to play gotcha, I kind of want it on the record. You see, and I think it's in part because Baltimore City has a DJS facility that they can go to more readily, so does Baltimore County. How do you kind of address the issue of the real fundamental issue on this bill is where ultimately these cases are decided? It's either going to be decided in adult court or decided in juvenile court.
No, that exactly is the point in terms of where these cases are going to start out. And again, this bill is only carving out very specific crimes to start in juvenile court. Right. And again, this bill is not something that says that no kids can be charged as adults, because that's not what Maryland is ready for yet. Although that is what we're recommending and asking, we realize that is not where we're at. And so this bill right now is saying that only certain crimes, increasing the amount of crimes that would be eligible to start in juvenile court, but not all crimes. There is still a process both ways. It's a two-way street. But in terms of where these kids are being housed, that is actually one of the reasons why we need to change this law, is because there is such a discord across the state in terms of facility availability, where these children are actually being housed, how they are being housed. It varies by county and by capacity. And so there needs to be a streamlined process and system in place for kids when they are charged, where they are going, and making sure that there is capacity for them to be housed in a DJS facility, because there are still children who are being housed in adult facilities when there is no bed capacity, which means that they then have to be in solitary confinement, which means that they are also subject to a host of other issues. And I just want to make one other quick point. Yeah. As someone who has represented these kids in the adult facilities, even when, they're often waiting for beds to open up, right? But these kids, when they're in adult facilities, they are subject to strip searches on a daily, routinely basis, just to see family, just to see attorneys, just to have any kind of contact with the outside. And oftentimes they reject those contacts and communications because they themselves are victims. And so that's what we're talking about with the harms. There are so many harms that go along with having kids in adult facilities. And that's just one of them that I know has always stood out to me as just, I cannot believe we allow for kids to be strip searched on a daily basis by adults in the adult
Ms. Williams, and then I'll go down to Delegate Phillips. In your experience, the cases that come into the docket there for kids who are charged as adults, the majority of them, at least what the Reform Council showed, the majority of them are for basically simple possession of a handgun. Would you say that's correct?
Yes.
Yeah, and those cases almost always are being waived down.
Correct.
And so I think, I went to Poly, so I'm not great at math, but it strikes me that it was for Embry. So it strikes me that if you take those people out of the mix, then the people who are left are the people who are significantly less likely to be waived down.
Yes. So yes, and I'm glad you asked that.
Not always, and exceptions to the rule, but yes.
Yes. So the bill carves out firearm use to remain as starting in adult court, but it does allow for possession to be starting in juvenile court. And I'll give a key example case in terms of why that's important in cases that I represented. You have a kid who's in a car with multiple other people, and there's a weapon or a firearm in that car. They might not know that's there, but guess what? Every single person in that car is getting arrested, and they will be charged as an adult if they're over the age of 16. And so that is the problem. Why are we doing that? We need to change that process because that happens all the time.
Well, and I think that goes some way to what Delegate Tolles is trying to do here. And so I guess what I'm trying to take apart with some of my questions is those cases, the simple possession of a handgun, and for some people, me saying simple possession of a handgun doesn't seem very simple to some people. But having said that, those are the cases where far more often than not, they're being waived down, as opposed to staying in the juvenile, staying in the adult side.
Or even dismissed, and I would love to defer to this expert.
Briefly, and then we're dragging on, so I'm sorry.
So you're correct that firearm possession is in fact the most common reason why youth are automatically charged as adults. It's not remotely half. Last year there were 268 youth automatically charged as adults on handgun possession out of 932. Close to a quarter, not nearly half. So those waiver hearings are being won on much more serious charges than simple handgun possession.
I guess the question then also, and from earlier this afternoon, there's also a question that we are constantly running into in this area of the law of counting apples and apples. And that's why I went to the question of how many cases are there versus how many people are there. And I think we should be looking more at the people, because in my experience, sometimes that possession of a gun is also coming in connected with something else. And that was one of the things I think we even ran into in the Reform Council that created some mystery there. The bottom line, as far as I see it though, there are some crimes that clearly end up in waiver far too much. Delegate Phillips.
Thank you, Mr. Chair. It was your gotcha question that kind of stirs this up in me. And I do understand that there were a number of young people who perhaps have been charged as adults that we've gotten into a place like Hickey. In Baltimore County, we're working really, really hard to make sure the youth are not in the Baltimore County Detention Center, and we're having some success, but still they're ending up there. This is my question, though, because it goes beyond that. even if I send a child to Hickey, if they're charged as an adult, they still have that time factor, correct? In terms of getting into court, having their case heard, getting the services they need. Is that correct? So that's another disparity?
That is absolutely, yes, that is absolutely correct. Because when you're in the adult system, when you're charged as an adult, regardless of where you're housed, you're still operating under the rules and the laws within the adult criminal court system. And that is by the 180 Hicks day of 6 months to have your trial. And so all the pretrial motions are operating within that 6-month time frame versus in the juvenile court system, it is crunched down to 30 days if you're detained or 60 days if you're not detained. And so all of those pretrial motions have to happen within that shorter time frame in the juvenile system.
And so to your point about the system having a more significant impact on those youth that are charged as an adult, that exacerbates that issue. Is that a fair statement?
Yes.
Okay, thank you.
All right. Seeing no further questions. Thank you all very much. And now we'll go to those people who are in opposition. Catherine Rosenblatt, Scott Schellenberger, Allison Healy. Then we will move on.
So.
Whoever would like to go first, Mr. Schellenberger, I guess.
Yes. So please.
And Trina Selden from Out for Justice?
Yes.
Is in opposition?
No.
No, you're in favor?
Yes.
We'll be with you in a moment. All right, you signed up unfavorable. Okay, Mr. Schellenberger, please, for 2 minutes.
Okay, Scott Schellenberger, State's Attorney for Baltimore County. Number one, Delegate Arcan, please ask me about the money. The delegate from Ways and Means, please ask me about the process. Delegate Phillips, please ask me the questions you were just posing before. So my anecdotes are not anecdotes. My anecdotes are cases. These are dead people that are in this written testimony. Please read it. If you look at the statute that you have put forward, the Felix Fitzgeralds who raped the person at the Hickey School would not start in juvenile court. But if you listen to the amendments that everybody else wants, he would start in juvenile court. But the person who matters the most, in my mind, is Nick Browning. And I know everybody says you always use Nick Browning. Well, it's not the only one. Please read my written testimony. There are a list of 15-year-olds who, if this bill passes, would start in juvenile court. And yes, I can transfer them up to adult court, and I understand that everybody says there are all these time limits, but guess what? When I asked to transfer up, the defense counsel, who are very good counsel, they're all good lawyers, they're doing their job, they're going to ask that there be a psychological study. Well, that gets delayed by months and months and months. So that 15 days you heard about is nothing. That happens in the regular case of a simple theft in a juvenile situation, not in a case that's being transferred. And again, Nick Browning, 15 years old, 6'2", 200 pounds, IQ of 125, planned to and executed 4 people. 4. And he killed them on purpose. And if you do the amended bill, he's going to start in juvenile court. And even this bill, because he's 15, he starts in juvenile court. Please feel free to ask questions.
All righty, there we go. Please, yes, for 2 minutes.
My apologies. Good afternoon, Catherine Rosenblatt. I am Deputy Chief for the Juvenile Unit for the Office of the State's Attorney for Baltimore City. And I see how legislation impacts our cases in real time every day. I see many cases of youth waiting to be connected with services. Of critical significance are the instances when the Department of Juvenile Services has asked the court to modify dispositions for violent offenses, often transfer cases, claiming that there are extensive wait lists at placement facilities and asking the court to downgrade placement from hardware secure to staff secure, or even just to leave them in the community. However, the months delay that we see for youth to be connected with mentoring and treatment, behavioral health, substance abuse, also in the community, is a clear indication that the services aren't there either. The proposed changes to jurisdiction for these serious and violent offenses would place additional burdens on already overtaxed agencies. The increase in juvenile cases has revealed shortcomings in services, available beds at placement facilities, and capacity for proper supervision by the Department of Juvenile Services. With every case and every hearing, our ASAs seek the best outcome for both the respondents while keeping our community safe. Unfortunately, the changes in this bill proposed would make that harder to achieve, and that's why we're opposed.
Hi, I'm Allison Healy. Delegate Hornberger asked me about juvenile detention for the most serious crimes. In any event, I just want to address the things that I've heard here today and what we're seeing in real practice. So we've heard about better outcomes due to more resources. However, we know that the Department of Juvenile Services right now does not have enough resources. Every day we are seeing juveniles shuffled through the system, not obtaining the services they need and being shuffled right back out. While they're awaiting services, journaling, counting as services, writing in a notebook, counting as services. We're doing crime victims a disservice, but we're also doing these offenders a disservice. The resources are not there. So that data doesn't translate when you don't have the resources to give. There is no law prohibiting juveniles from being held in the Department of Juvenile Services. They've sat here and told you about adult court and how they shouldn't be in adult court. But I have the Joppatown High School shooter who we said put in juvenile detention, and DJS was the only person arguing against holding him in DJS, saying keep him in adult jail. So those two things don't go together. And they were citing lack of space, wait lists. We can't hold the number of cases we have now. We can't hold these people. And you want to add more cases to that caseload, they can't maintain the caseload. Either way, judges make the decision. I've heard this morning state's attorneys make the decision. We don't make the decision. Either a motion's being filed to transfer from adult court to juvenile court, or a motion's being filed to waive from juvenile court to adult court. Either way, the judge is the person making the decision, not us as state's attorneys. And last, I would say that they say prosecutors want to decide where it's charged. And no, we want to keep our communities safe. The number one priority needs to be public safety. And for that, I ask for an unfavorable report as to this bill.
Delegate Hardberger.
Yeah, just really quickly, and I don't want to diverge from what I asked before because I'm trying to understand this process.
Sure.
So all of these different scenarios that we've outlined in terms of pathway, okay, what the advocates want, what the proponents want, can all of those take place currently under current law? Is there discretion there to do all of the above?
Yes. Yes.
If all of these players decide to do so?
With the exception of life for 16 or old, sentences of carried life, first degree rape, first degree murder, they're not eligible for transfer back.
Which, as written without the amendments, it doesn't cover that.
Correct, doesn't cover that. But yes, as to everything else, yes.
So in your opinion, because I've heard from the presenters, what is the problem that this bill seems to try to fix?
Well, the problem that this bill is trying to fix is that for several years, I believe 4, maybe 5, they tried to do the amended bill, and that is start everything in juvenile court. And we have successfully fought that, and this body has turned that down every time. And so I think someone thought, well, let's go part way. And therefore, we won't go as far as saying everything starts in juvenile court. Let's take this baby step, which in my mind is not very a baby step, but let's take this step and see if we can at least get some of these to start in juvenile court and require people to waive them up. And the thing that's important to remember is, and I finally found the statute, several years ago when there were complaints about everybody being held in juveniles being held in adult facilities, you all passed Criminal Procedure 4-202, which says that even if you're charged as an adult, you can be detained in a juvenile facility. And I was very pleased to hear that Chairman Clippinger pointed out that the meanest state's attorney currently has 34 of his adults charged sitting in a juvenile facility. And of course, I'm referring to myself. So that bill that you all passed, CP 4202, has done a lot to change where people are being held while these decisions are being made. And I'll just answer your question, Delegate Erickson. We're not going to save any money because although the statute requires that we file charges quickly within 15 days, the defense lawyer, again, is going to do a good job and ask for a hearing and ask for a psychiatric background. These get delayed by months and months and months. And therefore, all this thing that you hear about, we're going to save $16 million, I think it's going to be a break even. Because whether they're being held at that detention center or we're waiting for them to be moved, it is not going to make that much of a difference as far as the money goes.
Thank you.
Delegate Taylor.
Thank you, because he answered your question. Of course you did. Of course you did. Of course you did. So I'm also trying to understand the process, right? And I'm going to use the Nick, I forgot his last name, who did the horrendous crime. And Delegate Congolo mentioned mental health issues. I'm assuming that this young man at 15 to kill 4 people had some mental health issues, right? So
actually, no.
Well,
he had been planning for months. He wanted his family's money. He wanted to be stopped being told what to do. His lawyers did a great job investigating his background. The worst thing they could find when he kept alleging his father abused him was that one time on the lacrosse field, when he did something wrong, his father wiggled his helmet and told him not to do it again. And that was the worst example they could find of a father allegedly abusing him. And he had very good lawyers.
Yeah.
They tried to waive or transfer him back down to juvenile court, and that was denied. And he's now serving 2 life sentences in the most secure facility in the state of Maryland out at North Branch.
did he get a psych eval?
Oh, yeah.
Okay. So it's my understanding, as I heard somebody say, if you start in the juvenile court, then there's an opportunity for whomever to take a look at this person individually and potentially address their needs individually. If you go straight to the adult court, then you don't have that wherewithal. Is that, so can you?
No, that is not so. Nick Browning had good lawyers. They've tried to transfer him back down. There was a psychological profile done. There was a social worker who did an investigation. They got his school records. That's how I know what his IQ was. They got all those things. So whether you're trying to move up or down, all the same examinations can be done. And as Ms. Healy said, that examination is given to a court, and it's a court who decides which way it's going to go.
It just takes longer if you start in the adult court.
I disagree with that.
I think it takes about the same time.
I disagree with that wholeheartedly because as Mr. Schellenberger was saying, they're getting the same evaluations, and more often than not, we the state are not prolonging these hearings. It's the defense who's prolonging these hearings because they're getting experts, and however long it takes for them to get the evaluation is how long it takes for them to get the evaluation. And they're going to want the same evaluation, whether it's a transfer or it's a waiver. So regardless, that hearing is going to occur when that evaluation is complete, regardless. So I disagree wholeheartedly that a waiver or a transfer is going to happen in any different amount of time.
I apologize, if I may chime in on that. The cases that are up for either waiver or transfer do get that extra level of evaluation. The cases that come in on the regular day-to-day juvenile dockets don't. It is not until sentencing that there is any evaluation done of any services needed by that youth. So we see kids regularly where we have to ask the public defenders and trying to work out with them, okay, well, what's going on here? We're reading between the lines in the police report. We're talking to officers. What was your impression of the kid? What did the mom seem to say? Did anyone, show up? Was he released immediately? Was he detained at all? the closest we have to figuring out what's going on in that youth's life is at any detention hearing where a parent is present, or at that point DJS has done some kind of contact with the kid, or the sentencing evaluation report after the child is found fact sustained. That's the only time that we find out anything about them that is sort of done through official routes. And that's first degree assaults, anything that would come back as originating in juvenile. And often those handgun cases can be kids who feel insecure and unsafe themselves. We don't find that out unless the kid is able to talk to the public defender is then able to call our office and have a conversation. It takes actually a great deal more investigative legwork when the cases come through the juvenile system in the regular way, and it's not because there's any research done by DJS when they just come through the regular way. They may not see any services until they're found fact sustained, which can be months, 6 to 9 months after the incident.
Thank you, Mr. Chair. Thank you guys for being here. I just actually wanted to ask you to help me think through this. I pulled up the data that somebody else had mentioned previously about the sort of recidivism rearrest rates for kids that go through the DJS side, which is ideally, if all things work out for this bill, where they want most of these cases to end up starting. The 2022 rearrest rates for some of these regions is super high. I mean, Baltimore City has its own region, it's 50%, 50.5%. My county, Hartford, is a lot lower, 27.3%, Baltimore County, 33.3%. I'm trying to figure out what could lead to such a disparity in the rearrest rates. And I'm wondering in my mind if it's potential, and you just tell me, I could be way off, but tell me if I'm getting anywhere towards warmer. Is it possible that in some of these regions, there may be some judges who are a little bit gentler, and so perhaps in Hartford County, they're not proving waivers as often, and we're seeing a lower rearrest rate in the areas where they're not getting the waivers approved?
I can't speak necessarily to, I guess, percentage-wise if we're doing it less. I mean, we have our fair number of cases transferred, to speak to actually the question Delegate Hornberger asked of the public defender earlier. I had a 15-year-old attempted murder, shot his sister at close range, almost killed her. She was lucky to have survived. The judge did grant transfer in his case.
Wow.
And he spent less than a year in detention.
Really?
Yeah, in a hardware secure facility, but less than a year.
And so now where is he?
Back on the street. But not only that, his mom wouldn't take him back. She didn't want him back.
Wow.
His dad is in, I want to say it's Georgia, some other state. There was a question whether he was going to be released and be put into foster care.
Wow.
So it was not a system where we are protecting this kid from reoffending, right? That is what our system is supposed to be. And I know that everyone thinks we're just here to put everybody in jail, but we don't want these kids to reoffend any more than the public defenders do.
Right.
And we are not setting them up under our current system and resources to not reoffend. Do judges' decisions have some play in it? Probably. Does environment, upbringing, parental, familial history have something to do with it? Absolutely. There are a wide variety of things, what their traumas are in their past, there's a million things that I think go into that. So I don't think it's a real hard and fast answer as to why the counties are different, but I think all of those factors play into it.
Okay, that helps me. Thank you, guys.
Back a little bit more to the premise of the bill and talk to, if you don't mind, talking to me a little bit about what it really means to be detained as a young person in the juvenile facility versus in an adult facility. For example, starting out, if you're going to be starting in the juvenile court system, you're dealing with a judge who has more experience dealing with young people. And, sort of what does that look like in most cases? And then, again, with the detention piece of it, how does that look? I mean, kids, young people will get more resources in the juvenile system, and versus being in an adult system where they may be segregated in some way, they may not receive all the educational benefits that they need and all the other resources they need. So could you just talk a little bit to those two things for me, please?
So do you want to start?
Sure. Well, I believe Delegate Clippinger touched on this, but most of the youth charged as adults are actually already in DJS facilities. Correct. And I believe the woman from DJS advised the same. So when they're in DJS facilities, so for Baltimore City, that's their basically, I mean, not to go too detailed, but when a youth is arrested and charged as an adult, they go to central booking, they're processed, they're immediately taken to the Youth Detention Center. That is a DOC, Maryland Corrections facility. They're held there throughout their sort of the preliminary motions, and at some point, the public defender's office usually files a motion to say, can we move them to a juvenile facility? It's been pretty habit for our attorneys to say, sure, that's fine. Sometimes they stay at YDC. Most of the time they move to BCJJC. Once they're at BCJJC, or if they're still at YDC, they have the opportunity and they do attend Eager Street Academy. We know this because when we get the transfer of jurisdiction reports, it includes their grades and some of their attendance from Eager Street. So they are able to obtain some services. We are completely in agreement with DJS and OPD that we would love that to be more services. If they're already in DJS facilities, we don't know why they aren't receiving the full panoply of DJS services. It's a DJS facility.
But there are times when they are not necessarily placed into DJS services and into the juvenile facilities. And when that happens and they're placed in the adult surrounding areas, what happens next? How does that look for us?
So now do you mean that they stay at the Youth Detention Center or that somehow they end up back at central booking?
They end up at central booking and or some other place where there are more adults, where they are not confined to.
They can't stay at central booking. If you are under the age of 18, you are not to be within sight or sound of an adult. So you at least it's the city's.
There is some segregation.
There is.
Yeah,
Right.
it's different, and I will follow up on that because it's different
thanks.
county to county because we can't use YDC, only the city can. So it's a little bit different.
So in Baltimore County, we can handle them separately as male inmates, those 11, because we have a separate area that we keep them away from the adults. Our big problem comes when we have a female. And unfortunately, I mean, just 6 months ago, I was calling down to BJC and saying, can you all take this young lady? Because she's got to stay in the medical facility at our detention center. And we actually were able to, they were able to find an empty bed and allowed us to send that down there. So we entered into a MOU so that we could do stuff like that. So again, and I know I've said it before, but I'll say it since we're talking about it one more time. To all to hear, we need more money put into DJS so that all of us are not faced with these problems, and we want to do this all the right way. But there are people, and that's the example of my written, of people who just should not be treated that way. I mean, remember, DJS can only hold on to somebody until they're 21. Very often, they don't even hold on to them until they're after 18.
But we're still talking about
young people here.
Yes, we're talking about different.
Let's keep it within
Okay,
that
we'll keep it with
vein,
the young.
But also recognizing that you are from 3 different jurisdictions, right?
Yes.
And you are doing things 3 different ways, which is kind of interesting also to see.
Well, we are not, to be clear, we are not permitted to use YDC, and we actually,
I understand what you're saying. I'm just saying, just looking at it from an overview, right? We're seeing 3 different situations here, whereas I wonder if just not charging kids as adults makes a difference. And now we have a different pathway to deal with them, just generally.
So I think there's differences in how they're being held. I think if you probably talk to our offices about what cases we are charging as adults and what cases we are not, I think you would find a pretty significant level of consistency over what types of cases we would elect to handle in adult court and what cases
would you mind providing that to us? That would be great for us to kind of understand what you are doing. If you're saying you're doing something different, I'd like to know that as well.
I mean, we could try, I would imagine. I mean, that's a large, sort of realm, but we can certainly, ask the question and see if we can get it. But as to, I will speak to our jail also, is that we do keep them sight and sound separate, obviously. And that was actually what happened with our offender who is actually awaiting trial right now, is that we wanted him to not be sight and sound separate because it's like 23 and 1 sometimes, and that's obviously not good. We understand that. So when they asked to have him moved to a juvenile facility, we said we don't object. Let him go. He can get an education, he can get services. Actually, that's why Mr. Marks, our other offender, ended up getting transferred because he did so well. He got some services there and then moved back. But this offender, we said the judge ordered, take him to a juvenile detention facility. DJS flat refused to abide by the judge's order, said we're not doing it. He's not eligible for transfer. And we said, but there is no statute. Even if he's not eligible for transfer, there's no statute that prohibits you from taking him, and it is in the best interest of this child for him to go there. They flat refused to the point where we had to have multiple hearings where the judge had to admonish DJS and say, I have ordered it and there's nothing that prohibits, take him. And their excuse was, over and over again, we have wait lists. We can't handle the people we have in juvenile court. That's what they said on the record in open court. We can't handle what we have now. And we're going to send our most serious cases down there and ask them to add to their caseload that they already can't manage. I mean, that defies logic.
Thank you. Appreciate it.
Vice Chair.
Thank you, Mr. Chair. A couple questions. First questions obviously are for Mr. Schellenberger because it's just fun. So you were talking about juvenile court and adult court. So let's talk about juvenile court and adult court. So in juvenile court, first of all, do you go to juvenile court, right?
I haven't been for a time, but I do get reports. Okay. I have specific lawyers who are assigned to juvenile, including a senior, a trial attorney who runs the unit.
Okay. So do the rules of evidence apply in juvenile court?
Yes.
Okay. And is the burden of proof beyond a reasonable doubt in juvenile court?
Yes.
Yes.
Okay. And are the children in orange suits with handcuffs in juvenile court?
No, the judges usually don't want that.
Right.
Even if they're detained, they have clothing.
Why?
It just creates a bad impression for even just a judge, because you don't have a jury, for even just a judge to see them that way.
Right. So, okay, you gave me more on that one than I thought you were going to give me. Thank you.
Keep going. I'll get to my old self.
Who's in the courtroom?
It's limited to the state's attorney, the defense attorney, the judge, some support staff for the judge. You can't bring in, like, a crowd can't come in and just watch.
Who's in the courtroom in adult court?
Everybody who wants to.
And what do they wear?
Well, if it's a trial and it's a jury trial, judges will make sure they have clothing.
But if it's a hearing?
If it was a bail hearing and it was something like that, they could very easily be in the jumpsuit.
And handcuffs possibly?
Possibly, but you also have to understand that some of these bail hearings we do remotely.
Gotcha.
And so they know they're in jail because they're doing it remotely.
Right. Okay, so Now, let me ask you about the young lady. I cannot remember your name. I apologize.
That's okay.
But I heard you say 23 and 1. What's that?
23 and 1 is essentially, isolation. They're in a cell by themselves. They get 1 hour out of the cell per day.
I know what it is. Okay, so they're in isolation for 23 hours? Is that what you said?
Yes.
And they're out for 1 hour?
Which is why we try to send them to a detention facility.
And
Our
that's
jail
in
doesn't like having them, trust me.
And that's in adult detention?
Yes, adult detention.
So I just wanted to make sure I understand. So I heard that 85% go back to DJS. Do you think that number is what's the word, elevated, or do you think that number makes about what in your experience?
You mean transferred back to juvenile services?
I certainly don't think 85 applies to my county.
I would agree with that. I don't think
half.
Maybe half.
Maybe half. Maybe?
I'd say a little less than half.
49. Okay, and in your, are we, I forgot, what county?
Baltimore City.
Yes, right, okay. So would you say 85 or half?
I think it depends on the case. I know that's a terrible, terrible lawyer response.
I'm asking in the aggregate.
In the aggregate, yes, I would say half or a little bit more than half, but I don't think it's quite 85%.
Okay, that's fine. So half of your cases end up going back to DJS, and half of them end up staying in adult court. That's fair to say? Somewhere around there?
Yes.
Okay. All right, so I just wanted to make sure, because you were giving us examples. I appreciate the examples of the extreme cases, but I need to have a little bit more neutral data to work with as well. Thank you so much for answering my questions.
Thank you, Mr. Chair. Really quick, I also forgot your name on the end. You indicated that you would, that you do not want the kids, you prefer them to have juvenile services. Is that what you said? That you said something along those lines. Because you want them to get the services.
Yes, we also want them to not reoffend, right? We're about public safety, right? So we want children to have the services to not reoffend. We don't have that right now. We just don't. I mean, that is the fact of the matter. We don't have it right now.
Okay, so what, because again, the bill is saying, is let's have all charges. It has a certain amount, certain charges that will go for juvenile court. So at what charges would you, if you want, so my point is if you would like, you believe that they should get the services they need so they don't reoffend, what charges would you be okay with that would?
I don't believe
because you don't want them to reoffend, so we got to get them these services, right?
So as Mr. Schellenberger said, I would agree with him. There are people, and I think I heard it from over here as well, there are people that are not amenable to treatment. And that is one of the factors when we go to a transfer hearing that the court looks at. When we're going through these evaluations, psychological evaluations, DJS reports, one of the factors is amenability to treatment. And there are children who are not amenable to treatment. I know that that is tough to hear, but judges make findings to that.
Let me stop you there, because I just, and I'm sorry to cut you off, I just want to be like succinct in the responses in the essence of time. So how many children in your cases that you've seen are not worth saving, or don't think that they could be?
It's not about not worth saving. That's not what I said.
I know, I embellished it a little bit, but that's pretty much the essence of it. You feel like
that's not what I said.
So in your case, in how many cases have you seen that you think that children are not, some of these kids are not fixable? Would you say half? Would you say 2%, 5%?
As Ms. Rosenblatt said, it's a case-by-case basis. Right. And we have to look at the facts of it.
In your case that you've seen, that for kids that are not, it would not be, regardless if they go to juvenile court, they still will not be healed.
I think Mr. Browning is a great example.
No, that wasn't my question.
So if you look at my written, you look at my written testimony, I think there are about 7 youth in there, juveniles in there, who we believe committed very adult crimes. So I put this list together several years ago when I emailed every state's attorney in the state and said, give me your worst who were juveniles. And these are the ones that I got who fit under this statute. I had a lot more that was under the previous statute, but under this statute, it's pretty much limited to these ones that are listed here. And what I think State's Attorney Healy is saying is, and what I'm saying also is, we want to help the juveniles when they commit non-violent offenses, so that we don't, and we want to help them a lot and do everything we can for them so that we don't see a Nick Browning or a Felix Fitzgerald or a Tavon Williams or all the other ones that are listed here. We want them, if they've committed a lesser offense early, but I have to tell you that Nick Browning should never walk as a free man again.
And you're probably right. My question to you was, and you could get back to me, is now I have two questions I would like you to get back to me. In what cases do you feel, and what charges do you feel are nonviolent charges? Because if you look at some of these, what do you, out of these, abduction, kidnapping, armed robbery, third-degree sex offense, personal.
Those are all crimes of violence.
What do you?
Those are all crimes of violence.
So my question is, I'm talking to State's Attorney Schellenberger now, okay? Thank you. My question to you, Mr. Schellenberger, is what cases, you can get back to me on, what charges do you believe are nonviolent that you would be okay with? And then my second question is, how many cases do you see that you feel, back to my original question, how many cases, whether it's half, 2%, 5%, that you see that you think are fixable or healable children, or they're not healable? I want to know your number.
So
And you
when
can
it
get back
comes
to me on that.
Sure, when it comes to nonviolent offenses, I think they are healable. And I hope we put a lot of effort into healing them. When it comes to the crimes that are listed here, the 33 violent crimes that this legislature picked out several years ago and said, these are the worst crimes of the worst. I don't know of a robbery that happens in Towson that isn't a horrible robbery. I don't know a first-degree assault that happens that isn't a first-degree assault. Remember, it's not just simple assault. That wasn't just a punch at the school. That was a complete beating and beatdown. And so what we're saying is, we think that they should start in adult court, and if they can prove that they have some ability to be rehabilitated, then they can go transfer back down to juvenile court and get the help they need.
I was going to close by saying that I believe that the majority, because of some socioeconomic situations our children go through, I believe some may not be, but I believe most of our children, particularly at a young age, are healable.
And I believe that.
Thank you, Mr. Chair.
And I believe that too, and that's what I'm trying to say. These are the exceptions.
Well, give me a number. Give me a number. I asked you for a number.
I'll have to do that.
Thank you.
All right. Thank you. When you first were speaking, you said that these are not crimes that you have any part of determining whether they go to adult court or juvenile court. That's not exactly true, though, right? I mean, the state's attorney has the ability to charge in these cases, has the ability to put somebody in front of a grand jury, I mean, you do have the discretion to charge in these cases.
Yes. What I said, though, is that ultimately, at the end of the day, whether this case remains, either way, that's going to be decided by a judge. So the argument that we heard all sort of afternoon was, let a judge decide whether it goes to adult court. Well, if we charge them in juvenile court like this bill proposed, then a judge is going to decide in these cases when we file for waiver whether he goes to adult court. The same applies in the alternative the way it is now. It's filed, the defense asks for a transfer, and a judge is going to decide whether he goes to juvenile court. So either way, the judge is making the decision where this case is ultimately heard.
I understand, but still the initial decision made by, I guess, a police officer, even at the beginning of the story, could conceivably have made the decision as to whether this was going to be a charge that was going to ultimately land in adult court. But more often than that, there's a state's attorney who's seeing that not long after, who's making a decision one way or the other. But let me go to another question, and that goes to possession of a handgun. What is the treatment program for possession of a handgun?
I'm not aware of any.
Okay. Just wanted to make sure that was out there because it strikes me that that is a big chunk of the cases that we're talking about here.
It makes up a
simple
big
possession.
number. It makes a big number, yeah.
It is it's a big part of that, and they're not included in Delegate Tolls's bill. They're knocked out of the list in Delegate Tolls's bill, and so that just kind of wanted to come back to that.
And there is also, per conversation we've had, there's also no juvenile drug treatment program right now. None. There's no,
But we don't charge kids, I mean, but there's not, for simple possession of CDS, they're
I'm not
not being
suggesting
charged as
that,
adults.
but my point is that's where we're missing resources. There isn't treatment for these kids for the things that are needed.
So my last question, and then this committee will please not run me down. The last question, in the back and forth with the public defenders a moment ago, the standard that would be used is the question that I kind of, and we have the standard at the waiver hearing for whether a juvenile should be sent back to juvenile court or whether they should be held in adult court. And under, as I understand it, under Delegate Tolls's bill, that standard would just shift down. And so I'd like for not more than about a minute or so, if you could focus on that for a second. If it were not that standard, what standard would it be?
So it's not that the standard change, it's whose burden of proof it is that changes. So if the public defender, if I start them in adult court and the public defender wants to waive them down, then they would have the burden of proving that the person is fit for rehabilitation in the juvenile system. And if it's a transfer up where the state is saying bring them up to adult court because I now have to prove that they're not rehabilitatable and therefore the adult system is better for them. In case anybody.
I guess my question is if the standard were different, that there was some, I don't know what this would be, but you didn't have that standard. You had a different standard that reflected the fact that it was going up as opposed to going down. What would that be? And if you don't have an answer to that question, I'll stop and we can get on with our, with the other 10 bills that are sitting here.
I mean, as it is currently, amenability plays a huge, it's the key aspect in any transfer hearing, and I apologize. It's transferring the case down, waiving the case up.
Got it.
In any transfer hearing, there's the Davis case. The judges tend to look at amenability. That tends to go to, are there programs that have been proposed as existing by DJS? In waiver hearings and that in transfer hearings, the burden is on defense to show that there are programs and that the youth is amenable to them. The waiver process is similar, except it's the state's burden, and it's the state's burden to show that the youth has had the opportunity to be rehabilitated and that there's nothing left for them. If this happens to be a first-time offense or a third-time offense, but the first time they've ever received services, it's an incredibly high threshold to meet. And unfortunately, because as previous testimony has shown, there are youth who do not receive services, it means it's likely that the majority of cases would remain in juvenile system where there would be a sort of massive caseload for the Department of Juvenile Services to try and then service when they can't meet the threshold that they have now.
So just, I guess my question a little more broadly, and then really we'll stop. So the Supreme Court jurisprudence, though, is the same whether it's a transfer or a waiver, effectively. Or is there a distinction between the transfer?
Davis is specifically in a transfer case.
Right. All right. That's something else I can deal with in all my spare time. Thank you very much.
Thank you.
That concludes the testimony on the second bill of the day. House Bill. Oh, the gentleman from Out for Justice, you're going to have 2 minutes. Where are you? Or did he leave? No, there. Please come up. Beg your pardon. 2 minutes, please.
Good afternoon, committee vice chair. Thank you for having me. My name is Trina Selden, and I am the founder of Out for Justice, a community built by and for people directly impacted by the criminal justice system. And we know the research says, but beyond the science, let's talk about what it means in real life. Kids who end up in the system often face struggles most adults couldn't imagine. A report from Human Rights for Kids found that 90% of kids in the justice system have suffered multiple adverse childhood experiences. Things like abuse, neglect, homelessness, or having an incarcerated parent. That number jumps even higher for Black and brown youth, for foster kids, for those struggling with mental health. Yet, instead of responding to these kids with care and intervention, we throw them into an adult court and too often into adult prison, where they are more likely to be insulted, to self-harm, and to be permanently locked into a cycle of incarceration. I know this because I've experienced it and I've witnessed it over and over, the way that the system fails young people by making choices for them before they even have a fighting chance. HB 1433 is a step forward, but we must amend it to end automatic charging altogether. No kid should be told that they're beyond redemption before they even understand what that means. Charging decisions should be thoughtful, individualized, and based on the facts of a young person's life, not dictated by laws that ignore everything we now know about childhood trauma and development. I urge this committee to do what is right, not what is easy. Maryland has the opportunity to be a leader in justice reform, to finally move beyond outdated policies that harm children and do nothing to make our community safer. Passing this bill with all these amendments will be a bold step and a necessary step in that direction. Thank you for your time and attention, and most importantly, your willingness to do better for our kids, and I hope you will seize the moment and make the right choice. Thank you.
Thank you. Questions? Seeing none, we thank you very much. That now concludes the testimony on Delegate Tolles' bill, House Bill 1433. We're going now to House Bill 952. Delegate Griffith. Delegate Griffith is coming up with Sean Bolson, Tina Teuffer, Hassan Giordano, Allison Healy, and then there are several in opposition.
I only have 3 of my witnesses. One second.
I think I see. Yeah, okay. Hey. Nearly all of them. All right. Delegate Griffith, go ahead.
So believe it or not, Mr. Chair, 6 years in General Assembly and 2 years in Judiciary. This is my first bill in this committee ever, so.
Okay.
Yeah, I know. I know you're all feeling great. I know you're all feeling great right now. So, all right. Thank you, Chair Clippinger, Vice Chair Bartlett, and members of the committee. For the record, my name is Delegate Mike Griffith, and I'm requesting a favorable report on HB 952, Juvenile Sex Offender Registry, Qualifying Offenses and Access. HB 952 strikes at the heart of child protection, especially for those within our public schools. Their protection and well-being is put in jeopardy when among them are juveniles that have been convicted of sexual offenses. In these cases, since that information is currently sealed from school personnel, necessary safety precautions cannot be put into place to ensure all students are secure and protected, especially victims. As a result, students may be unintentionally putting themselves in harm's way, and school staff and administration tasked with safeguarding all student well-being is left in the dark. To compound this, schools may be putting perpetrators and their victims in the very same classroom. And I certainly don't need to lay out all the hurt and trauma that will cause or has caused. Therefore, to address this issue in a way that provides an avenue for student safety and protects all those involved, HB 952 not only permits the local superintendent or their designee to access the juvenile sexual offender registry list, but it also updates the list to include several crimes such as child pornography. I want to be clear, non-consensual child pornography. And note that this is only the local superintendent or their designee that would have access to this list. It's not teachers, administration, staff, or other students. It's simply only 2 individuals with the entire school system that are who are best equipped to discreetly and appropriately put into place the required safeguards to protect all students. Furthermore, to continue providing safeguards for all parties, HB 952 updates when a juvenile can be removed from the list. Under current law, when probation ends for a juvenile that, for example, committed rape of a minor, they can be removed from the list even if they're under the age of 18 and still be presumably around other young individuals and students in a school setting. To address this, HB 952 simply updates this removal to only happen when the juvenile reaches the age of 18 or their probation ends, whichever occurs later. In adding this change, the safety of all students and children can be considered and kept at the forefront of all decisions. Therefore, I request a favorable report on HB 952. Thank you.
I'll go next. I'm Allison Healy, State's Attorney for Harford County. I'm here to offer my support for House Bill 952, as supported by MSAA. The intent of the Juvenile Sex Offender Registry is to provide effective notification and communication regarding sex offenses committed by juveniles in an effort to identify individuals who could be at risk to the safety of other individuals, especially other children. Our children are our most vulnerable citizens, and they deserve the maximum protection. The registration should be based on the offense and not the age. If we want to know if an adult committed this type of offense, the same should be true of a juvenile who is likely to have greater contact with children. It is essential for the registry to be available to our school superintendents or their designees, as they must be aware of identified sex offenders for the protection of other students who could potentially end up in classroom settings with those offenders. The statute limits the registration on the list to while the juvenile is under the jurisdiction of the court. We are now seeking for that to, as noted, go to the age of 18 or they're off probation, whichever is later. Just this year, a juvenile offender who committed a second-degree rape and a separate fourth-degree sex offense on children who were not even old enough to be in school yet was taken off probation after just a year at a hearing where everyone at the hearing, including his own family, indicated he was still very much in need of rehabilitative services. When his probation was terminated despite that, he was no longer subject to the jurisdiction of the court and was removed to the registry and ended up in public schools presenting a danger to those children. It is a disservice to the hundreds of thousands of students to ignore their safety by not making these changes. The overall safety of the vast majority of children and students must outweigh any concerns related to updating the list and extending the registration period on the list. As you deliberate, ask yourself, would I be willing to have my young child in the same classroom with the juvenile who committed these serious sex offenses? Would that concern me or would it not? This bill is a necessary notification and communication bill that aims to provide public safety for all students. I respectfully request a favorable report.
Good afternoon, Chairman. Well, good evening, Chairman Clippinger, members of the committee. Hassan Giordano, External Governmental Affairs Chief for the Office of State's Attorney for Baltimore City. You have the written testimony on behalf of our office submitted on behalf of State's Attorney Ivan Bates. So we've been here a long day. I'm not going to go through that. I just want to really bring your attention to some of the discrepancies we have and why this bill is imperative. We had a juvenile last year in our jurisdiction who was a juvenile sex offender convicted in multiple jurisdictions, one being Harford County, another Baltimore City. They were on the juvenile sex offender registry with charges and convictions in multiple jurisdictions. They resided in Baltimore City, went to school there, yet the school system had no idea whatsoever on their background. This is a convicted sex offender who was then taken off of the registry because the juvenile judge in Baltimore City vacated the jurisdiction from Harford County, which they were on the registry for. So that took that person off the registry within a year's period of time. It's not like the adult system where the probation does not play a factor in them staying on the registry. So against the advice of the therapist who said that this juvenile needed more therapy, the family and everybody else in the courtroom, they took him off and vacated the jurisdiction and the probation, unfortunately taking them off the sex registry. House Bill 952 represents a more balanced and necessary approach to enhancing community safety by ensuring that these juveniles who commit these type of offenses are properly monitored, expanding access to this critical information to our school systems, and adding more serious offenses to this registry. It strengthens the protections for children and our families and across Maryland. I respectfully urge the committee to issue a favorable report on HB 952. Thank you.
Thank you. Good evening. Thank you for hearing my testimony this evening. I am Sean Bolson, Superintendent of Harford County Public Schools, and I'm here also to speak in support of HB 952. So I will just put this through the lens of parents. Parents in my school community, and I would suspect most others, expect the superintendent to have access to information like this. They would be, and frankly have been, surprised to learn that the superintendent of schools doesn't have access to this type of information that might keep their children safe. One of the things we experience, and particularly with crimes like this of harassment and the other more serious crimes, is that it's not that uncommon for the victims to be right there in the same school and in the same classroom. I mean, this is where these students meet the people who end up being those they harass. And so looking at the lens of a parent who perhaps after something happens again, or they learn later, the parents really don't understand why I couldn't have done more. And we have such an important responsibility to teach every student. So we take both the victim and the harasser, we take the responsibility to teach them very seriously, but we need to have the information to make an effective plan to create a safe environment for those students. So just looking through the lens of those parents who really expect us to know, I ask for a favorable report on HB 952. Thank you for your consideration.
Questions? Seeing none. Oh, sorry, I couldn't see it. Please, Delegate Erickson.
Thank you, Mr. Chair. Thank you guys for being here. So this is we got a couple bills like this that try to address the same disturbing case. I mean, these mothers, of course, they're gag ordered, but it's disturbing what's been going on and the updates in the case. You know what it reminds me of? Just a tangent. It reminds me a lot of the Amy Caprio case, because that mother was begging for her baby to be called in, bring him in, I don't know where he is, help me, help my child. And so now I hear, this is news to me, that mother or family members of that offender was saying the same thing, and who was the judge?
I can't reveal. We still got to practice before.
I'm gonna find out eventually, but that is so disturbing. So anyways, okay, so I see you're doing things a little bit differently. You want it to go to the superintendent or the superintendent's designee. Could you just give me an idea about who that person could be, and like how far could it spread?
It could be contained to those two people.
Okay, so just two people.
Yeah, so the superintendent would need to know and go directly to designee. The designee would have to reach out to the school. I mean, the schools would require some training to understand that when you get this call, you have to make these adjustments, but we'd be making some sort of a plan. But the person who would get that is in a position, because it would be the same person who works through kind of all of the issues across schools and placement and things like that.
Okay.
So it could be isolated to people with the right training.
And the idea would be that you would have in an advance, essentially, some kind of template where when you get a call like this, okay, we've got somebody there, facts sustained on a sexual abuse, they're in the same classroom as one of their victims, and so you guys would sort of have that sort of plan, but then you would
Yeah, and this isn't the only situation where a call like that might happen. So it wouldn't, just because someone was told.
Right.
It wouldn't mean that, someone would automatically jump to a conclusion about that student.
Oh, right,
So.
yeah. Okay, I really appreciate you guys coming down. I'm really happy to see you here, Dr. Bolson. I appreciate you being down here.
Further questions? Seeing none, thank you very much. We will hear from the people in opposition as soon as I figure that out. All right. Elizabeth Lee Torno, not there. Stephen Bergman, Alyssa Fio, Megan Berger, Kelly Quinn.
So Megan Berger had to leave as well, and Professor Latorno also was not able to.
Okay, well, we'll hear from the three of you then. Start from my right and move over, mostly because he got there first and sat down first, and it's a quiet competition, we gamble. Mr. Bergman, please.
Good evening, Mr. Chair, Madam Vice Chair, and committee members. My name is Stephen Bergman. I've been practicing delinquency law for 23 years with the Office of the Public Defender. HB 952 is an extreme piece of legislation that removes the age limitation for inclusion on the registry, expanding it to include children as young as 10. This body last year precluded any child on the non-public registry from attending in-person school ever again. Thus, under HB 952, fifth graders who commit a sexual offense would never again see the inside of a school. HB 952 is an extreme piece of legislation that decimates the distinction between the non-public and public registries by making the non-public one widely available. Neither the local superintendent nor the designee, who could be anyone employed by the school, is required to keep this information confidential. They would have access to the names of all registered children enrolled in all districts throughout the state. This creates a high risk that the names will become public. This could result in severe reputational damage to the child that would be impossible to repair and could lead to dire consequences, including suicide. HB 952 is an extreme piece of legislation that vastly expands the number of offenses that require registration. Currently, children are eligible for inclusion on the registry for violent third-degree sex offenses, but not for third-degree sex offenses based on age difference alone. The law should not preclude a fifth grader from attending school for playing doctor with a younger sibling. HB 952 proposes to expand the registry to include fourth-degree sex offenses, impacting children who touch someone in an intimate area. Squeezing someone's behind on top of their clothes should not result in a 13-year-old being precluded from attending school ever again. HB 952 is an extreme piece of legislation that usurps the authority of the juvenile court judge by keeping a child on the registry until age 18, even when a court has found that the child poses no threat and no longer requires juvenile court jurisdiction. I urge an unfavorable report. Thank you.
Good evening. I'm Kelly Quinn from the Choice Program and also the chairperson of the Coalition to Reform School Discipline. We are advocates, service providers, and community members. We want communities to be safe, and we want all children to be able to go to school. We're committed to making discipline responsive to students' behavioral needs, and we want discipline that is fair, appropriate to the infraction, and designed to keep children on track to graduate. 10 organizations signed on to our testimony. There are several reasons why we are opposed to this. I refer you to our written testimony and that of Professor Letourneau. We are guided by facts, research, science, and the law. We also draw from professional practices, and in our considered opinion, we know that treatment works for children with a sex offense. Please review Professor Letourneau's extensive research, 3 decades of research. We also know that involuntary virtual placement generally has negative impacts. Virtual instruction is often inferior and is not appropriate to long-term placement. This bill would also run afoul of federal law and regulations. We already have 3 existing mechanisms in place to achieve this bill's goals. We've got the courts, we have HB 814 of 2024, and reportable offenses. Education is the #1 protective factor in preventing youth from recidivism. Our communities are not safer when children are denied the structure and support services that schools provide. All children deserve classrooms, not screens. We believe in facts over fear.
Good evening, Mr. Chair, Madam Vice Chair, members of the committee. My name is Alyssa Fio. I'm an education attorney with the Public Defender's Office with 30 years of experience representing children in education matters. We all care about safety, but this bill will not make our schools or communities safer. And most alarming, it's in direct conflict with the statutorily stated purpose of the juvenile court, which is rehabilitation. As you know, last year, the legislature passed a punitive measure that bans any student, regardless of disability, who's on the juvenile registry from attending public school in person. HB 952 casts an even wider net on in-person school attendance by ensuring that children as young as 10 can be put on the registry, expanding the list of offenses, and taking away the authority of the court to terminate jurisdiction, thereby removing a child from the registry. The juvenile court makes individualized decisions every day about a child with all the information before it. About services, about safety in the community. HB 952 undercuts the juvenile court's purpose and authority. Moreover, HB 952, under that provision, this bill, there's no determination as to whether the child is actually a safety threat in the school setting. It is a blanket rule that results in a permanent sentence of education deprivation with no opportunity of review, even years later, to determine if the student is in fact a safety risk. Mandatory exclusion of children from school and isolating them from home is not good policy and will only create additional safety concerns. Virtual programs generally deprive students of all the benefits of in-person school, including the opportunity to build positive relationships, participate in after-school activities, and have access to free lunch and breakfast. With this bill, Maryland will be relegating children as young as 10 years old to the isolation at home with no opportunity for review. As you may remember, virtual school was difficult for our children. We urge a no vote on HB 952. Thank you.
Thank you, Mr. Chair. Do you guys think that a youth who's raped a 3-year-old should be put back into public school? You could just get quickly yes or no if you could.
I think, first of all, I'm very familiar with that case. I'm not allowed to discuss it.
Just broadly on the topic, do you think
on the topic?
Do you think the child should go back to school?
I think that a child who has committed a sex offense,
raping a 3-year-old,
does not in and of itself mean that a child is a threat to their classmates. Okay. I think it's a fundamental flaw with these types of bills, and let me explain why. For a child to be on the non-public sex offender registry, that child has to have been adjudicated delinquent, is under constant court supervision with frequent review hearings, sometimes every other week, is being constantly supervised by DJS community case managers with regular reports going to the court, is participating in mandatory sex offender counseling, which is ordered by the court, counseling that has been shown to be highly effective with astoundingly low recidivism rates. These kids are under an incredible amount of scrutiny. They're probably the kids least likely to commit a sexual offense in the highly structured environment of a school.
Unfortunately, that child that you're referring to committed that sex offense again. You're right, it wasn't in the school, but he raped another infant not that long after that. So he immediately reoffended. Ladies, would you like to contribute?
I just have to say I'm very familiar with that case. And because it's a confidential juvenile matter, I'm not allowed to discuss it. And frankly, including those who testified here today, nobody is allowed to talk about a confidential court record absent a judge's order allowing it. I will say that much of what is out there in the public, including testimony you heard today, is one-sided, misleading, and highly inflammatory.
Okay, we appreciate your opinion. Ladies, how do you feel about someone who's raped a 3-year-old going back into public school?
So I would say that the way that you're asking this question, it's somewhat impossible to answer. If
you could just say you don't like it.
Well, I'm a parent, and I believe in the juvenile court reviewing expert testimony, ensuring that a student has treatment. I believe in the research that Professor Latorno has extensively set out in terms of the success of treatment. And what concerns me about your question is that you are assuming that children are the same as adults, and that is not, in fact, the case.
That's not what I'm assuming. I asked you a very simple, ma'am, I asked you a very simple question. Okay, let's let the other lady answer. Go ahead.
Do you want to continue? No. This is really hard.
I know, it's hard for everybody, but yeah. It's really okay hard for you to say, I wouldn't want my daughter or my son to be in a classroom with someone who raped a baby. You can say that, and no one is going to judge you the worse for it if you want to.
I need to say that I also would be concerned if that child is at home, the offender is at home with a 3-year-old who's not going to be in school.
Well, luckily
being
he's
somebody
not.
Outside of school without the protective supervision and the structure of an educational classroom is scary to me too. This is all really scary.
Let me move on to one other sort of maybe we can come together at some point question. You stated some concerns about things that were included, 4th-degree sex offense, things like that. If we put guardrails on it, if we tightened it up a little bit, if we made sure that the superintendent, as I'm sure he would agree to, signed confidentiality. As you know, school systems already have lots of access to protected data. If we ensure that that data was protected and we tightened up who we're talking about, maybe we're not talking about 10-year-olds, maybe we're talking about 13 and older, then would you find that that is a more reasonable policy, or would you still be staunchly opposed to it?
Well, just to be clear, this bill, currently, to be on the non-public registry, you need to be 14. This bill does away with that, so it's anybody within the juvenile court jurisdiction, which for all sex offenses except for 4th degree means 10-year-olds.
Okay, so for the sake of the negotiation,
okay, but I
14 then. If it was just 14, we got rid of fourth degree,
I
where
would
are
say that a couple things. One, just cards on the table. The Office of the Public Defender was against that bill last year, and we're still against it, that precluded kids on the registry from going to school for all the reasons we talked about. But there's nothing in this bill that limits it to just the superintendent or their designee. There's nothing in this bill that says that it has to be kept confidential.
Well, let's say we added it. What if we added it? How would you feel? That's what I'm trying to get at. If we fix it, do you love it?
Okay. I'm sorry. I would still be very concerned, and here's why. Currently, it's allowed to be public safety and for law enforcement purposes. And the kids don't go to school at the Department of Public Safety, so that's not a problem. But these types of information, this gets out. And yeah, it might just be the superintendent and their designee, but then they decide that a certain teacher has to know. So then the teacher knows, and they talk about it with another teacher in the hallway, and some student overhears. That's the way things are in schools. They just are. They were when I went to school a million years ago. They still are. So I would be very concerned. And also, a superintendent or their designee does not only have access to the names of the kids in their district, they have access to the names of every single kid on the registry in all sorts of different districts.
Okay, what if there was some kind of penalty if the information was disseminated inappropriately?
I would still be very concerned.
Okay, I appreciate it. Thanks.
Yes. Ms. Fio, that's your name, right?
Yes.
Okay, you said you're an education advocate, and let me preface it by saying that my good friend, the sponsor of the bill, is a tremendous champion of people with disabilities. Yes. But do you see how, could the gentleman's bill, despite his best intentions, run afoul of the Individuals with Disabilities Education Act? Because that is my concern. I'm just curious if you think it's unfounded or I might be on the right track.
No, that is definitely our concern, and that would have been the testimony of Megan Berger from Disability Rights Maryland, and you can refer to her written testimony. We were very concerned with the passage of the provision that passed last year. Specifically, we considered it to be a violation of the Individuals with Disabilities Education Act as well as 504, the Rehab Act. And the reason is that the provision that passed last year dictates that a student is not able to attend in-person school and determines it's either virtual or home and hospital or RICA or something like that. Under the IDEA, children must be educated in the least restrictive environment. Home is the most restrictive environment. In addition, the IEP team determines the appropriate placement for a student, and the provision from last year, as well as this bill, usurps that authority.
Thank you, Mr. Chair. You're welcome, and seeing no further questions, that concludes the testimony on this legislation. We thank you all very much. That was House Bill 952. Delegate Rosenberg is not here, and we've sent out a search party, so we're going to get to Delegate Edelson right now and House Bill 1442. Hassan Giordano, and there are the three of them. There are only three who are testifying on this bill, and so we'll see how quickly they can do it in the most, direct way. All right, Delegate Edelson, 3 minutes, please.
Thank you, Mr. Chair, Madam Vice Chair, and the dedicated and resilient members of the House Judiciary Committee. Great to see you all. For the record, my name is Delegate Mark Edelson, and I'm here presenting HB 1442. All of our jurisdictions have chronic absenteeism and truancy issues. Most jurisdictions reported an increase last year in their truancy rates. Baltimore City Public Schools reported a marked decrease, but still sits at around 38%. It is clear to me that while significant work has been done to address this issue, additional resources are very likely needed to continue to improve the metric and to have our students in the classroom where they need to be. Jurisdictions on the Eastern Shore and in Prince George's County introduced the truancy reduction pilot programs many years ago. In 2008, a DLS report was released that investigated the impact of these programs. The programs involves an assessment of the students' absences and what is stopping them from attending school, an introduction to services, and a requirement to attend school for a 90-day period without any unexcused absences. The report showed that approximately 43% of individuals enrolled in the program were successful in completing it and attended school regularly in the following 90 days. What that report was unable to uncover because of a lack of data was what happens on day 91. Let's face it, kids are smart. If you tell them they have to do something for 90 days and then the adults around them will get off their back, they will undoubtedly comply like any of us would for 90 days until they don't have to anymore. 90 days is a long time. Everyone here certainly knows that. But the question is it long enough to build good habits? Does it increase GPA? Does it increase graduation rates? Does it have other marked effects on student performance? The 2008 report was unable to provide this kind of longitudinal data. Also, frankly, it was published over 15 years ago and pre-COVID. HB 1442 would commission a new report that would investigate those exact questions with the longitudinal data that we need to see if such a program is successful, should it be continued, and for the residents of Baltimore City, would it make sense to include this program in Maryland's 8th Judicial Circuit, which is Baltimore City. Given the challenges we face in all of our jurisdictions and the incredible investment we are making in the blueprint for Maryland's future, we must do everything we can to keep our students in the classroom, keep them learning, keep them productive, and keep them safe. That is what this bill aims to do. With that, I urge a favorable report on HB 1442, and we'll turn it over to my panel.
Good evening, Chair Clippinger, Madam Vice Chair, and members of the committee. My name is Brant Fisher. I'm here today to strongly support HB 1442. This bill is essential in addressing a crisis that too many families in Baltimore City face: chronic school absenteeism. Education is a fundamental right, but for many children, barriers like poverty, transportation issues, and lack of mental health resources prevent them from attending school regularly. HB 1442 takes a proactive approach by expanding support programs, identifying root causes of absenteeism, and ensuring families receive the services they need, whether it's counseling, housing support, or basic necessities. By investing in wraparound services, we are not only keeping kids in school, but ensuring they have the opportunity to learn, grow, thrive in a safe environment. Without this support, too many children will fall behind and the cycle of poverty will continue. I urge the committee to issue a favorable report on HB 1442. Thank you for your time and commitment to Maryland's children.
Good evening again, Mr. Chairman, Madam Vice Chair, members of the committee. I feel out of place because I just realized this is the entire 46th district. With the chairman of the 46th, I'm representing the fighting 43rd district, so we're going to represent right now. But back again, we submitted written testimony on behalf of the office, on behalf of our state's attorney, Ivan Bates, who we want to first lend our appreciation to your colleague, Delegate Edelson, for putting this very important bill in. When State's Attorney Bates was on Fox 45 in 2023, and we came in office talking about the problems with DGS and the juveniles, he wasn't just complaining about it. He wanted to figure out why these children were committing these crimes. Part of our research was to figure out all the spike in daytime crimes that were occurring, and we were figuring out how much the truancy problem was playing into the criminal justice system in the city of Baltimore. So what we did with a little bit of research, we found that this body, back in 2004, passed HB 1443 to serve the needs of students and families only in Maryland's first judicial circuit in a program known as the Truancy Reduction Court Program. It started in Wacomico County back in 2004. It developed throughout the Lower Eastern Shore, Somerset County, 2005, Worcester County, and Dorchester County. Then it expanded, and y'all, in 2007, passed it for Prince George's County, but they tend to forget Baltimore City, who has the highest rate of truancy in the entire state. They left us with the sentence petition. And I don't have to explain to this panel how well that's done. So what we would love to have is not only for this bill to pass, but for Baltimore City to be given this remarkable program that's done through the courts to help really focus on this truancy. Our schools are doing a great job of trying to tackle that issue. We have a truancy court in Baltimore City. We don't want our children going into the criminal justice system. We want them in programs like this to be able to avoid these situations from happening. We, again, support HB 1442 and urge a favorable report.
Questions? Anybody want to give Delegate Edelson a hard time? No, it's a late night.
I'm like, we can.
We can. You do really have a question, the vice chair?
Okay, so the program works. Why do we need to have the report first and then make a recommendation for Baltimore City? Why didn't you come in, Delegate, with just asking for it for Baltimore City? I was just kind of
Yeah, it's a great question. I appreciate that. First, it does work, but the question is, would the same thing work the same way in Baltimore City? Because there are currently systems in place in the city, but they're not entirely congruent with what the program currently does. So, frankly, before sort of foisting this on the schools and the system in Baltimore City, I thought the prudent thing to do would be to look at what is working in other places. Would it work as is in the city? Would there be modifications that we needed to make? And ideally, this would help us to then come back next year and say, this is the bill that we can all work on with the schools. Everybody's on board. This is the programming that we need to move things forward. So, my thought was to take that thoughtful approach to it.
Okay, thank you.
Delegate Everett.
And I could ask this at another time, but I have
You know where to find me.
I know, I do know where to find you. It just occurred to me, have you talked to the Judiciary about whether they can get the student-specific information from the school system? Because it is confidential unless, I just wondered if that should be legislated, or they might have an MOU already, I don't know.
I don't know the answer to that question, other than to say there is a truancy court system in the city right now that works with our schools. So my suspicion is that they currently have access to that information. The challenge is that the system we have right now essentially adjudicates a student truant and then doesn't take the next steps like this program does to really get them on a program, have a caseworker, work with the family to understand what are the barriers and how do we collectively address them, and then move that forward. And so I think that they probably have that information. What we really need is that next follow-up step.
Any further questions? Seeing none, thank you all very much. That concludes the testimony on House Bill 1142. Delegate Pippi is just testifying by himself. Only one person on this bill. We're going to see how long this takes. House Bill 652. Delegate Pippi.
The man in the arena, Mr. Chairman. Mr. Chairman, members of the Judiciary Committee, Delegate Pippi, for the record here in support of HB 652. This bill is just a prohibition on hiring certain individuals at the Department of Juvenile Services. Individuals that have been convicted of abduction, kidnapping, manslaughter, murder, rape, sexual offenses, child abuse, certain felonies, assault in the first degree, intent to murder, assault with the intent to rape, assault with the intent to commit a sexual offense. As you all know, the Department of Juvenile Services has a very difficult task, and that is to rehabilitate young folks. It is not exclusively a punitive system, it's to rehabilitate. We have had 3,500 allegations of sexual abuse throughout juvenile facilities in Maryland, including in Frederick County at our facility up north in Frederick County. So, look, I think that people that are entrusted with the care and well-being of juvenile offenders, especially young juvenile offenders, should meet a strict requirement and background check. I know there's a background check required, but that still does not prohibit the Department of Juvenile Services from hiring these individuals. So with that, that's the bill. Happy to answer any questions that you might have.
Thank you, Mr. Chair. Is there a problem that this bill is addressing? Have we found that there's been a bunch of folks or anything that have been hired?
There is a problem. So as I stated, there's 3,500 pending sexual assault cases against Department of Juvenile Services employees right now in the state of Maryland.
Okay, thank you.
Thank you.
Any further questions? I guess one question, so the department sometimes will hire people who have been at some point in their lives incarcerated. and sometimes have been incarcerated for serious issues. They still go through background checks. They still go through a lot of different things, but they tend to be older. And there's, I mean, scared straight is sometimes the term that's used. I don't know if that's appropriate or not. But so this would stop them from hiring you. You said a moment ago, I wasn't sure I heard you, would stop them from hiring any of those people altogether.
So, you know, it's Mr. Chair, great minds think alike. So I was thinking of the scared straight because that might be a service, but you don't need to hire a full-time DJS employee that has a questionable background. If you wanted to bring someone in as a volunteer to maybe provide some insight into individuals, DGS can do that. But to hire them as a full-time employee overseeing the welfare of children in a facility, I think I have a real issue with. And obviously, with the amount of pending cases relating to sexual abuse, I think there's an issue there. But to your point about if we had an individual that, let's say, was convicted of murder and served 30 years in prison, got out, and now wants to spend the remaining part of their life telling people what not to do, you know, so that they don't wind up in a similar situation, maybe offering some insight. This bill would still permit DJS to have volunteers potentially come in and give a speech or things of that nature. But what this bill does, it prevents the hiring, and there's a distinction there.
I think for people who are convicted of a serious sex offense, they'd be on the registry probably for the rest of their lives. So I'm sure they wouldn't get, they wouldn't get hired by the department anyway. But thank you very much for your bill. That concludes the testimony on House Bill 652. Thank you. Oh, I'm sorry, Delegate Schmidt.
When you, Delegate, thank you. When you say pending cases 3,500, can you elaborate? What does that exactly mean?
Sure. Well, the look-back legislation that the chairman was instrumental in passing gave an opportunity for individuals that may have experienced a sexual abuse to hear their claims. And so there's 3,500 of those in Maryland of folks that were in juvenile facilities where a employee of DJS allegedly sexually assaulted them. And so one of the prohibitions in this bill would prohibit someone who's been convicted of sexual assault before from becoming a prison guard at a DJS facility. And I think that's the emphasis of the bill.
Okay, I see where you're going with that. Yep, that makes sense now. Thank you.
All right. Thank you, Mr. Chairman.
Thank you very much. That concludes the testimony for House Bill 652. Delegate Crutchfield and House Bill 1190. I didn't see Delegate. I didn't see.
Yeah, she was away and then she came back.
I don't have Delegate Taylor's folder. Oh, no, there it is. Okay, Delegate Taylor.
For that, we got a new family.
Kaisha Barber, Wendy Wilcox, Marissa Valeri is there. All right, that's fine. Just as a heads up for Delegate Crutchfield's bill, which goes further than the bill we heard earlier today. It's a reintroduction. Okay, I will encourage those witnesses to consider perhaps refining perhaps prior comments and making the same point. But let's go to Delegate Taylor and we'll go from there.
Thank you, Mr. Chair, and to all of my Judiciary Committee members, my very favorite committee. For the record, I am Delegate Kim Taylor, representing Prince George's County's District 23. Youth Services Bureaus have a 50-year history in Maryland. Several years ago, Youth Services Bureaus were defunded, and today more than half no longer exist. In my district, I am fortunate to have a functioning Youth Services Bureau at Bowie High School. At Bowie High, Youth Services Bureau programs include mentoring, mental health advocacy, dispute resolution, anger management, and most critically, life skills programs for chronically absent students at Bowie. Research in Maryland indicates that students who are habitually absent are significantly more likely to become involved in juvenile crime. Youth Services Bureau services are essential in preventing such outcomes, and data shows that Youth Services Bureau programs boast a 99% success rate in rehabilitating youth after being discharged from DJS. This remarkable success underscores the pivotal role these programs play in diverting juveniles from the criminal justice system and setting them on a path towards stability and productivity. Until we can convince our budget leaders to make the logical move back to the cost-effective Youth Services Bureau model, this bill, House Bill 814, requires the Department of Juvenile Services to report annually on its efforts to promote delinquency prevention programs, including evidence-based service providers like Youth Services Bureau, which we heard this morning, which are widely regarded as the gold standard for community-based intervention and prevention efforts. For these reasons, I am asking for a favorable report on House Bill 814. Thank you.
All right. Hi, I'm Wendy Wilcox. Thank you, Delegate Taylor, Mr. Chairman, and Madam Vice Chair. I'm here to support House Bill 814. I'm representing the Maryland Association of Youth Service Bureaus, and I'll keep my remarks brief. I know you've been here a long time. So first, we want to thank the department for agreeing to the bill and also for their acknowledgement of our services along with Delegate Taylor's and the success that we've been able to achieve. And so given the mandate in statute that connects us to the state agency, and given the decrease in state financial support for youth service bureaus, this bill will inform how DJS and youth service bureaus can better work together and define how youth service bureaus fit into the continuum of care. Thank you very much.
You don't have to touch it. I didn't have to touch it. Good evening to this esteemed committee, to the chairs of this committee. My name is Kaisha Barber, and I am the director of the City of College Park's Youth Service Bureau, and I also serve as the co-chair of the Maryland Association of Youth Service Bureaus. I'm here to add on to what my colleague said. I just want to let you know it's a match. Youth Service Bureaus are a match for many of the things that I've heard in this committee brought up today to meet the need of children who are coming to the attention of DJS. I know this because I have over 20 years of experience as a mental health clinician. I have also worked in the state of Maryland in 4 counties as a Youth Service Bureau provider. 5 of those in Prince George's County at the Department of Juvenile Services office, providing evidence-based practice care to SIN's youth who were coming to the attention of the department. We reported back on how the majority of those children were not known to the system for short-term and long-term outcomes. This is one of the ways I know that youth who come to the attention of DJS can be served by youth service bureaus and our evidence-based approaches and our proven history of effectiveness working with youth in all parts of the state of Maryland. Thank you so much for your consideration and favorable report on House Bill 814.
Councilmember Valeri, please, for 2 minutes.
Thank you. Good evening. Very endurance-favored Chair Clippinger and committee members. I'm Rockville City Council member Marissa Valeri. I wanted to share with you all that the Rockville Mayor and Council unanimously support HB 814. We're deeply thankful to Delegate Taylor for sponsoring this important legislation. The city was a partner with the state for many years as a designated youth service bureau, one of only 2 in all of Montgomery County. We have tried to continue offering the same services with city and county funding. However, like many other jurisdictions across the state, much more needs to be done, and the need grows as the population of at-risk youth grows. Youth in Rockville would benefit from a reinstated partnership with the state so that we can serve more youth. The Rockville School and Community Youth Services programs provides mental health services, youth development, and enrichment programs, but it's not enough. So we would love to see this bill be reported favorably. we have seen with our limited resources as a municipality, we've seen students succeed in homeschool and in the community. They were struggling to see any hope for success. And our meager programs were able to provide that. And so we would love to see this program expanded. I think it would be great to see how the report, I apologize, my dog's scratching at my door. She hates it when the door's shut. We would love to see how the report shows what is happening in Montgomery County. With a county also as large as Prince George's County, for us to not have a dedicated youth service bureau right now is quite the travesty. So I want to thank you all. I know it's been a long night, and we urge you to provide HB 814 with a favorable report. Thank you.
Questions, Delegate Williams.
Thank you, Mr. Chair, and thank you, Delegate Taylor, for bringing this bill. I guess one sort of a comment, I don't know if you had a chance to look at the fiscal note, but it looks like the DJS is able to do this with existing resources, so there's a zero fiscal note.
Isn't that so?
Isn't that so? And then my second sort of, isn't that so? So 15 years ago, we as a General Assembly devoted about $2 million in general funds that supported about 18 youth service bureaus across the state, serving children and families in 10 different jurisdictions. But now it appears that we are only funding about 8 youth service bureaus across the state. And so it seems like we have really, you mentioned the shrinkage and the investments that we have made, but yet you mentioned the 95% success rate that these youth service bureaus have had. And so I think this report would be really appropriate in us determining, the significance of that reduction. Isn't that so?
Absolutely. And I actually had a bill last year that sought to restore the funding to, I think it was to the tune of $4.8 million. And that was just the minimum. And I was asked to withdraw, not from our, I'm not saying our chair asked me, but I was asked to withdraw that because youth services bureaus were going to be considered under other funding streams for this year. But that hasn't happened. In fact, like you just mentioned, we're not even at where we were last year. So also I want to mention that I think some time ago, you guys remind me, was it 70 we had across the state?
No, 21.
We had 21, right, across the state, and now we're down to 8.
Yeah, I know we have an amazing one in my district in the city of Greenbelt.
Yes, you do, absolutely.
Right, thank you.
Yep.
Any further questions? Seeing none, that concludes the testimony on House Bill 814. Thank you all very much. Going to Delegate Crutchfield now, and then we'll go to Delegate Rosenberg. Delegate Crutchfield's bill is House Bill 1190. It deals also with youth charged as adults. We're going to give it 3 minutes for the sponsor, 2 minutes for everyone else, as it is a little different from a bill that has been previously before the committee. All I'll ask is for those who are testifying, we did have about 2 hours on this issue as a whole at the beginning of our day. To the extent that we can try to avoid relitigating some of the major issues, that would be nice, but, guy can dream. Delegate Crutchfield, Stephen Gravatt, Judge Karoom, Flannery Gallagher, Ian Farrell? No.
And Lila
Meadows?
She should be on virtually.
Lila Meadows may be virtual, is not on virtual. But
okay,
people.
She said she was, and
okay,
Ian.
She said we will keep an eye out for her.
Okay.
Delegate
great.
Crutchfield, please. Oh, the pages are here. Delegate Crutchfield, please.
All right. Hello, committee, Mr. Chair, Vice Chair. For the record, I'm Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County, and I am here in favor of HB 1190, which is my Youth Accountability and Safety Act. So I'm going to yield my time to my intern who wants to testify on behalf of me and the bill.
All right.
Good evening, Mr. Chair, Madam Vice Chair, and members of the committee. My name is Evelyn Choi, and I am the intern for Delegate Crutchfield this session. Thank you for this opportunity to testify before you today in support of House Bill 1190. House Bill 1190 will end the practice of charging juveniles with felony murder. Under our existing law, felony murder is codified under the statute for first-degree murder. Typically, the state has to prove premeditation in order to sustain a first-degree murder conviction. But for the felony murder doctrine allows the state to waive intent altogether. The only showing the state needs to make is that the juvenile was involved in an underlying felony and that the loss of life occurred. And because felony murder is charged as a first-degree murder, it carries a mandatory life sentence. Let that sink in real quick. Today, in the state of Maryland, there are individuals who have been sentenced to die in prison for murders that they did not actually commit and that occurred when they were children. That's even younger than me. This reality is shocking, and it poses grave constitutional issues in light of the Eighth Amendment and recent decisions from the Supreme Court that recognize that children must be charged differently than adults due to their diminished culpability and their tremendous capacity for change. In Granby, Florida, the Supreme Court concluded that when compared to an adult murderer, a juvenile offender who did not kill or intend to kill has a twice diminished moral culpability. Now, we don't know the exact number of individuals who are currently serving life sentences for a felony murder committed when they were a juvenile. However, we do know that there are more than 300 juvenile lifers in the state of Maryland, and 82% of them are Black. In fact, Maryland has the nation's highest proportion of Black youth sentenced to life without parole. That is why this bill, reforming felony murder, is an urgent matter of racial justice, and why this bill is a legislative priority of the Black Caucus this session. I do want to be clear, though, that this bill does not erase accountability for juveniles. Under this legislation, juveniles involved in the commission of a crime that leads to the loss of life will still be charged for those underlying felonies. In addition, this bill does not undermine public safety. A 2021 study found that less than 1% of individuals were aware of the felony murder rule prior to their arrest, meaning the felony murder doctrine does not work to deter crime. Instead of spending exorbitant funds on lifelong sentences that do not work to improve public safety, the state could be investing in evidence-based and holistic programming in schools and communities that proactively address the root causes of juvenile delinquency. I am asking for your support for House Bill 1190 to end this unjust practice in the state of Maryland. This is not a radical change. It is a step that over 11 other states have already taken. It is time for Maryland to take that step. For these reasons, I urge a favorable report on House Bill 1190. Thank you.
Thank you very much. Good job. Committee, very briefly, I just need to correct myself. I recognize this as another bill that Delegate Crutchfield once put in related to youth charged as adults. It's not that. It's about youth under felony murder. I apologize for what I said before. So let's hear from everybody else anyway. Judge Karoum, please.
So, Chair Clippinger, delegates, thank you everyone for your stamina in another long day here. I'd like to mention that I think Delegate Crutchfield is going to sponsor 2 amendments that will perhaps make the bill easier for those that otherwise might oppose it. One of those amendments, I think, is to delete the retroactivity provision so that it would not impinge on existing convictions or mean a burden of many sentence reviews under this bill. And the second one is there's a slightly confusing definition of first-degree principle that would be deleted so that it would not create confusion over existing law. The importance of this bill is that it would eliminate a situation where, as our lead witness said, there are juveniles who do not even have impulse control and may be basically semi-innocent bystanders. They may not know there is a gun involved. They may not be there when something has happened. It may be an unplanned event or an accident, and they may get life sentences from it. The doctrine, which has been abandoned in England, where it started, and most other Commonwealth countries, is one which has been found in lots of studies not to have any deterrent effect, both because people don't know about it and because it is not something which someone who is acting on impulse would be influenced by. A study showing the difference between states with and without felony murder doctrines is that there's no difference in the crime rate. So this is not a law that advances public safety. It is a law that causes much lengthier sentences and costs taxpayers a huge amount for juveniles who are accessories and really do not know what they're doing. So thank you for hopefully giving a favorable report to HB 1190 as
Thank you very much. Good. Yes.
Yeah, hi, my name is Steve Gravatt, and I'm here to provide a juror's perspective on the felony murder rule. In 2020, I was alternate juror number 1 for a trial where the defendant was charged with armed robbery and felony murder in the first degree. The defendant participated in a robbery where his accomplice accidentally killed the victim with a box cutter. As a juror, I was torn between competing duties. On the one hand, I wanted to do the right thing, and condemning a non-murderer to murder one did not seem like the right thing. On the other hand, I wanted to do my civic duty and apply the laws of the state as best I understood them. Since I had no reasonable doubt that the defendant had participated in a premeditated robbery, I had no doubt that the defendant had participated in a premeditated robbery or that the robbery had resulted in death. That meant finding him guilty of first-degree murder. So whatever choice I made, I was gonna feel bad about it. Fortunately for me, all the real jurors made it to the end of the trial, so I didn't have to participate in rendering a verdict. I later learned that the jury found the defendant guilty of armed robbery, but innocent of first-degree murder. There are two possible explanations for this illogical finding. The first is that the jury simply didn't understand the law. After all, it's counterintuitive that the state would expect you to find a non-murderer guilty of murder. The other possible explanation is that the jurors willfully chose to disregard the law because they found it unjust. The crux of my testimony is that the state of Maryland should not be asking its citizen jurors to enforce a law that is either so illogical they're liable to misunderstand it, or so contrary to our sense of justice that we choose to disregard it. So long as the felony murder remains on the books, it's important that we reduce the charges associated with it. By removing the first-degree murder charge for minors convicted of felony murder, we'll reduce the burden on jurors to condemn young people who have not murdered anyone to a lifetime in prison. Thanks.
Good evening. Once again, I'm Flannery Gallagher. I'm a legal fellow at the Center for Criminal Justice Reform at the University of Baltimore School of Law. We are here in strong support of HB 1190 as amended by Delegate Crutchfield. House Bill 1190 prohibits children from being convicted of first-degree murder under the felony murder provision. Felony murder is a legal fiction that defies our system's bedrock principles of proportionality, fairness, and justice by imposing the most serious penalties available in the criminal justice system on people, including children who did not intend to kill, did not anticipate a death, and did not participate in killing another person. While the idea that an adult consciously choosing to commit a felony is as culpable as one who deliberately kills another person is dubious at best, it is particularly hard to justify when it comes to children. Convicting children of first-degree murder under the felony murder provision produces extreme and unjust results, eroding the legitimacy of our criminal justice system. A number of felony murder cases in Maryland illustrate the extreme and absurd results of the application of this doctrine to people of all ages. For example, in Stewart v. State, Stewart robbed a motel clerk with a written note. No gun was reported nor found. Prior to the robbery, the clerk had had surgery for cancer that removed a lung. A few hours after the robbery, the clerk experienced trouble breathing and died of a heart attack. Stewart was convicted of felony murder and eligible for a life sentence. Furthermore, the felony murder doctrine causes intolerable and extreme outcomes across the criminal justice system as a whole by undermining the legitimacy of the system and contributing to mass incarceration. For example, in some states, anywhere from 1/4 to 1/2 of incarcerated people sentenced to life without parole were convicted of felony murder. For the foregoing reasons and those in our testimony, we urge a favorable report.
All right, 2 people virtually. Ms. Meadows, please, for 2 minutes, and Mr. Farrell.
Hi, good evening. Lila Meadows with the Maryland Office of the Public Defender, here in support of House Bill 1190. I want to thank Delegate Crutchfield for bringing the bill and also thank the committee for an opportunity to brief this issue at the beginning of session. During the briefing, I spoke about the felony murder rule and how it's utilized in Maryland, how the law is constructed. But again, we have a problem here where it's very difficult to untangle premeditated murder in the truest sense and felony murder because of the way the statute is constructed here in Maryland. Given that, I've undertaken some data analysis to try to wrap our arms around the scope of this problem in Maryland. Unable to obviously review every murder one case in the state, we pulled data that runs from 2017 to 2022 for every case where first-degree murder was charged. There are approximately 115 people charged with first-degree murder in that time period. And I can tell you that of those cases, 59 of those individuals were juveniles charged as adults for first-degree murder. The best that we can tell through our analysis, about 33.9% of those cases can be classified as being prosecuted under the felony murder doctrine, about 42% as premeditated murder, and then there's about 23% of cases where I'm just not able to make a determination based on the information. And so that's kind of what we're looking at in terms of the scope if you think about just that time period. We support a prospective repeal of charging children with felony murder because doing so is simply out of step with the law. It's out of step with the truths that we know about children and how they operate and inconsistent with our legal doctrine. And so we urge a favorable report. Thank you.
Mr. Farrell, please, for 2 minutes.
Good afternoon, members of the committee. Thank you for giving me the opportunity to testify before you today. I'm an associate professor at the University of Denver Stern College of Law. My areas of expertise include constitutional law and criminal law, and my research has included several empirical studies of key concepts in constitutional and criminal law. In one of my empirical studies, I asked Maryland residents their views on felony murder. More specifically, I presented 500 Maryland residents with examples of felony murder and asked them what crimes the perpetrator should be convicted of and what punishment they deserved. The results of the study were striking. For example, 92% of the study participants said that, according to their sense of justice, these felony murders should not be first-degree murder. On the question of what sentence was deserved, the median answer was 7 years in prison. I want to emphasize that these are not my personal views. They are the considered moral judgments of a representative cross-section of Maryland residents, including on political affiliation. Crucially, both Democrats and Republicans disagreed with Maryland's current felony murder laws. 87% of Republicans in the study said that felony murders should not be first-degree murder, and the median sentencing range Republicans thought they deserved was only 8 years in prison. The results of this study strongly suggest that passing this reform bill will align Maryland law more closely with the values of all Maryland residents. Thank you.
Questions for the panel, Delegate Erican.
Thank you, Mr. Chair. I wanted to give you, a delegate, an opportunity to respond, if you wanted to the Judiciary. They had some concerns about potential nullification beginning on page 3. I don't know if you had a chance to read it yet. And then you already know some of the other opposition in reference to the Amy Caprio case. I know we've both heard it for many years, so I thought I'd give you a chance to respond if you wanted to.
Okay, thank you very much, Delegate Arakan. In fact, the amendments that I have, which are obviously friendly amendments from me, do take care of the concerns the judiciary has.
Okay.
Because they're all talking about the retroactivity of what the bill currently says. What I have done is I've gone back with the amendments to make it a prospective bill so that going forward, this is the only issue here is that it is to definitely repeal the statute itself and not give people the opportunity to go back and review convictions.
Okay, I understand. And then to the gentleman who was the juror, thanks for coming in. This is an interesting perspective we don't usually get. Are you familiar with the concept of jury nullification?
I'm not an expert, but yes.
Okay, yeah, I was just wondering if that was brought up in your deliberations with the other jurors at any point.
So I was alternate juror number 1. So I didn't have the opportunity to sit with the jurors. So I don't know what happened in that jury room. I don't know if somebody in there was like, hey guys, we can nullify. I have no idea what happened.
Okay, that would be very interesting information to have if anybody comes across it.
Any other questions? All right, seeing none, that concludes this panel. We're going to hear from 2 people who are favorable with amendments. Tyler Mazur and the mayor of Glenard and Kashena Cross, who's virtual, is not on. All right, we're going to hear from the one person who's favorable with an amendment. Mr. Mazur, please, for 2 minutes.
Good evening. Good evening, Chairman Clippinger, and members of the House Judiciary Committee. My name is Tyler Mazur. I'm a practicing student attorney in the University of Maryland School of Law's Youth Education and Justice Clinic. The clinic represents children who have been pushed out of school via suspension, expulsion, and other means, as well as individuals serving life sentences for crimes they committed as children or young adults. The clinic supports House Bill 1190 with an amendment that extends the repeal of felony murder to emerging adults aged 18 to 25. Maryland's felony murder law contributes to injustice in 2 major ways. Firstly, it contradicts modern scientific understanding of brain development. Research has clearly established that the areas of the brain connected with an individual's sense of both short and long-term consequences do not fully mature until approximately 25 years of age. The felony murder law ignores science and instead relies on the foreseeability of a death occurring to justify a life sentence. Yet the science makes clear that the ability to foresee the consequences of one's actions, let alone the actions of another, is conclusively less developed in children and emerging adults than in older adults. Excuse me. Secondly, the felony murder law disproportionately affects Black individuals in Maryland. Research indicates that Black individuals are overrepresented among those convicted of felony murder in states across the country, including California, Colorado, Florida, New Jersey, Pennsylvania, and many other states. In Maryland, nearly 80% of individuals sentenced as emerging adults and who have served 10 or more years in prison are Black. Maryland's felony murder law serves as a vehicle to punish Black youth with extreme prison sentences, traumatizing individuals and contributing to damage that spans generations. HB 1190 is a major step forward in aligning our state's law with modern science and addressing racial disproportion in Maryland's incarcerated population. For these reasons, the clinic urges a favorable report. Thank you.
Questions? Seeing none, thank you very much. That concludes the testimony in favor of the bill. In opposition, Scott Schellenberger, Allison Healy, for 2 minutes each.
I think Mr. Schellenberger has left the building.
All right, 2 minutes, please.
So he's left me on my own. That's fine. Thank you, Allison Healy again, Harford County State's Attorney. I think Delegate Crutchfield, although I think addressed some of my comments with regard to the retroactivity, obviously that was concerning in light of reversing perfectly good convictions and what we see with victims having to relive things with post-convictions and such. However, with regard to individuals who act in concert or in a common scheme, where they go into, we'll say, a robbery or something of that nature together, and that the offense could not have been committed without each of them participating, such as a lookout, a getaway driver, things of that nature. it does not seem it does not seem fundamentally fair to treat those individuals differently, to treat one person more harshly than we would treat another person. They acted together in concert, and they should suffer the consequences equally and fairly distributed between them. Again, I think we spoke as to the, I was going to speak as to the retrials, but it sounds like that's no longer on the table. So with that, I would just ask for an favorable report.
Questions?
Great.
Seeing none, thank you very much. And that concludes the testimony on House Bill 1190. Delegate Rosenberg is going to come up right now. He is the only one testifying in favor of House Bill 873. We'll let him testify. Then we have two, maybe, well, one definitely person testifying in opposition. Delegate Rosenberg for 3 minutes.
Thank you, Mr. Chairman. This bill is, this committee is well familiar with the issue of juvenile justice, and specifically the legislation you passed last year, House Bill 814, which added several offenses to the juvenile court's delinquency jurisdiction. One of those provisions that was added was theft of a motor vehicle. Ultimately, after the Senate reviewed the bill, that fell out of the bill. This would restore it, or puts before us once again what is the appropriate juvenile court jurisdiction for auto theft. And it is prompted by my experience with my constituents of saying that someone can steal a car, go to juvenile court, and be back out on the street the next day as if nothing had happened, and with barely a slap on the wrist. And so what this bill would do is put this issue before us again in the form that it passed the House. And obviously there would then need to be a different outcome in the Senate for this to become law. The likely result, as you well know, in the delinquency jurisdiction is rehabilitation services, not penalties. So I don't believe this is a vindictive bill, but would be designed to have a greater impact of deterrence on the juveniles who are committing this offense of motor vehicle theft, which is of significant concern, I'm sure, not only to constituents of mine in the 41st District of Baltimore City. So I would urge a favorable vote and appreciate your consideration. Thank you.
Questions? Delegate Grammer.
Thank you, Mr. Chair. Just wanted to be clear, does the bill put the jurisdiction in the juvenile court or the adult court? You didn't hear clearly what the bill did.
I'm sorry, the juvenile court.
Okay, thank you.
As did the bill last year.
Questions? Seeing none, thank you very much.
Thank you.
All right, Kimberly Watts, Trina Selden. Trina Selden?
I'm coming.
Okay. In opposition, are you in favor?
Yeah, no opposition. Thank you.
No, you're okay. You don't need to testify.
I don't need to testify.
All right.
Thank you.
And that concludes the testimony on House Bill 873. There are 2 pages here. We're going to take them very quickly, especially Sophia O'Connell. Please come to the table.
Oh, okay.
Please tell the committee who you are.
Good evening, committee. My name is Sophia O'Connell. I'm from Anne Arundel County. My name's Emma Martin. I'm from Baltimore County.
All right. Well, we certainly welcome you to the committee and saw you're still here with us at 11 p.m. at night. Ms. O'Connell, is it possible that your father is named Dennis?
I believe that's possible.
Is it? It's a relatively non-committal answer.
Yes, my dad's Dennis O'Connell.
Yes, your dad stands, great, okay, yeah. And is he a public defender here in Anne Arundel?
Yes, he is.
And does he work at circuit court?
Yes, sir, he does.
Oh, And does he sometimes have cases with me?
Yes, sir, he does.
All right. He is as fine a lawyer as I've ever been with. He is an amazing gentleman, and I'm lucky I get educated by him routinely. And I really enjoy working with him. And I'm glad that you're here as well.
Thank you, and he feels the same way about you, for the record.
Thank you very much. All right, we should just end the hearing right now. I'm sorry, I don't know your father.
Yeah.
But we are very happy that you're here. You're from Baltimore County?
Yes, I am.
Oh, do we have any of our Baltimore? Which high school?
I go to Hereford High School.
Hereford, the Hereford zone.
Way up, yep.
All right, that's fantastic. Thank you both for being with us here this evening. Thank you very, very much for spending some time with us.
Thank you for having us.
Thank you.
Thank you.
All right, we'll keep going. Thank you, Delegate Tomlinson. Had to have a little bit of a break in the action. Delegate Tomlinson, Michael Stewart, Eric Roby, David Morris, if he's still out, they may be outside. Oh boy, we're running out of people.
I don't know, David, was he ever here?
Who?
Yeah, I think everybody's left.
Yeah, David Morris was here. I saw him standing outside for a little bit of time. All right, well, this is fine. We're going to hear from you on House Bill 622, please.
I can find more people to testify if you like. I'm sorry? I can find more people to testify if the committee would like. Thank you, Mr. Chair, Madam Vice Chair, and honorable members of the House Judiciary Committee. For the record, my name is Delegate Chris Tomlinson, and on behalf of Delegate Mike Griffith and myself, I'm here to introduce House Bill 622. In 2022, the Child Interrogation Protection Act was passed. As a result of that legislation, the following things now happen when a child is taken into custody. Once taken into custody, the officer must immediately notify the child's parents or guardian. As documented in the fiscal note, the notice must include the child's location, provide the reason for the child being taken into custody, and instruct the parent on how to make immediate in-person contact with the child. Law enforcement cannot start to interrogate the child until the child has consulted with an attorney, whether that be a private attorney or a public defender. Once again, as noted in the fiscal note, to the extent practical and consistent with the Maryland Rules of Professional Conduct, an attorney must communicate and coordinate with the parent. Along with this bill came the creation of the Public Defender's Youth Access to Counsel hotline that is available 24 hours a day. And this hotline allows law enforcement to contact an attorney for children who they are preparing to question. What this bill does, that I'm introducing today, makes one small tweak to the Child Interrogation Protection Act. This bill allows the parents to waive the requirement that the child first connect with an attorney prior to the interrogation starting. This legislation is not a complete reversal of the Child Interrogation Protection Act. It's simply peeling back one element of it. For many years now, the juvenile crime has been front and center and a top issue, not just for the Maryland General Assembly, but for our committee. I appreciate last year all the work we did and the changes that we made to our juvenile crime laws, and I'm proud to support the major juvenile law reform bill that we passed. I'm sure all of us remember back in late 2023 when we had multiple meetings, both virtual and in person, leading up to the 2024 session to learn more about our juvenile crime laws. We heard from law enforcement, we heard from youth justice advocates, we heard from the Office of the Public Defender, we heard from folks from all walks of life about this issue. And one of the speakers that stood out to me during one of the virtual meetings, I think it was the first virtual meeting, was a police officer from Montgomery County who told a story about a child who had gotten in trouble and was in their custody. Law enforcement, they were able to reach the child's parents, and the parents came to the station. The child's parents told law enforcement that they wanted their child to speak with them, and instead law enforcement had to explain to the parents that they couldn't do this until the child had talked with an attorney, and the parents could not believe that they did not have the right to waive that requirement. Unfortunately, a lot of troubled youth come from dysfunctional homes with parents who are either not in their lives or are struggling with their own problems. But in some cases, juveniles who get in trouble have parents who are engaged parents who are involved in their child's life. And these are the parents that rush to the police station to learn what happened. And in many ways, they're doing the right thing. I'm happy to answer any questions from the committee. Thank you, Mr. Chair.
Michael, I'm sorry. Thank you, Chairman Clippinger, Vice Chair Bartlett, and members. Michael J. Stewart, Special Counsel to Haven Shoemaker. I'm here to testify for a favorable report for House Bill 622. And let's talk about the real world where we live. In the real world, there are no child custodial interrogations anymore. And not in my jurisdiction and not many others, because what happens is even if the parents are there and they want the child to confess or talk about what the conduct they might do, they still have to make a phone call to the Just Say No hotline, which you get a OPD who's never met the child, has no connection, knows nothing about the case, and whose default line will be, don't say anything, even if it's to the benefit and the best interest of the child. So this is a common sense tweak. All it does is allow a parent, and if you want to look at in Courts and Judicial Proceedings 38A02, one of the purposes of the juvenile justice system is to seek to hold parents of children entering the system accountable and responsible for remedying the circumstances that led to their children's entrance into the system. So if they want to do that, if you want to tell Junior when you show up to say what your involvement is, own up to it if you did it, and then let's take steps, it's not going to happen. So they just don't question them in custody. It just doesn't happen. There's a public safety exception, thank God, but nobody knows what it is and we have trouble communicating it. I can tell you we had a case where we had a juvenile in a murder case who confessed to that there was a hit list of people, which we were able to tell people that, oh, you're on a hit list, and we were able to address that. There's cases where juveniles who are 17 are with adults and they commit violent crimes, and they are not able to distance themselves from the adults in those crimes because they are not interviewed custodially. So I would urge a favorable report, and I'll answer any questions.
Yes, and if I can have two, if they're very brief. Delegate Tomlinson, I have a question for you. My question is, why is it fair for somebody who will not face the consequences, who will not potentially go to jail if they incriminate themselves, to waive their child's right to waive the child's right to remain silent because mom and dad or dad and dad or whoever it is aren't going to be the ones going to jail, or facing any sort of consequences. So can you tell me why it's fair for somebody who's not going to be facing the consequences to waive the child's rights?
They're not, Delegate, they're not waiving their right to remain silent. The
question was for the sponsor, respectfully.
Yeah, like you were saying, yeah, they're not waiving their Miranda rights. They're waiving the requirement to have to get on the phone or a video conference with an attorney, whether it be private or a public defender.
Well, yeah, but it's the same difference because it's somebody who's not going to potentially face the consequences of whatever they might say. Telling them, go ahead and waive it. But we can agree to disagree. And my question is, sir, you called it the Just Say No hotline, and I can understand why the Fifth Amendment might be frustrating for you. I find certain amendments of the Constitution to be frustrating for myself. But isn't that just good lawyering to advise a client of their rights?
There's a fine distinction, and the fine distinction is this is a statutory requirement that an attorney must be consulted. An attorney must be consulted. This has nothing to do with Miranda, which would still be given, which would still be recorded on body worn, and the parent can't waive Miranda. In that situation, you look at the totality of circumstances, and the parent's presence is one of those circumstances, whether or not the confession will be admissible. But as far as it goes, like I said, this is not the Fifth Amendment right to remain silent. This is not the Sixth Amendment right to counsel. This is a statutory creation where you have to go through a pro forma talk with an attorney, and I can tell you this. Like I said, I've only been a state's attorney since 2023. I was a private attorney for 30 years. doing defense work. And there are times when, not many times, but there are times when you can get yourself out of the jackpot by telling your story. And this doesn't even allow to tell their story because the default position, and I can tell you, if you can ask OPD how many times they've told them to talk, and if it's more than 0, I will come back here and eat this entire desk. So I can tell you, there's a fine distinction that's made. You would still get what they call the youth Miranda, which is a simplified Miranda, and the child would still have to decide what they wanted to do on that. But as I'm saying is, I'll tell you what, call the number tonight. I'll give you the number, I'll find it and see how long it takes and see and you can ask somebody on the other end what their advice would be. So it's not a reasoned attorney-client consult or anything like that. All that we're doing is giving the opportunity for a meaningful, you know what, there's an old Scottish proverb that says confession is good for the soul, and sometimes it's good in the best interest of the juvenile to tell what happened. As I will say, and this is an impediment that is completely shutting down any meaningful custodial interrogation of juveniles.
Well, I thank you for your perspective, sir, and for your offer for me to call the hotline. But to be frank with you, after these hearings are over, I'm going to have a hot date with my pillow. Thank you.
Fair enough.
The Vice Chair.
How do you follow that?
How do you follow that?
Right. So, okay, my question, I have a couple, but I'm going to make them fast. My first question is to the bill sponsor, Delegate Tomlinson. Did you read the Office of Attorney General opinion letter that was brought as a result of the Child Interrogation Protection Act?
I did read all the testimony, but there was a lot of unfavorable testimony.
No, not the testimony, the opinion letter.
The opinion letter?
Yes, that speaks to the constitutionality of the Child Interrogation Protection Act.
Okay. No, I did not read that.
Okay. And this is for your witness, do people who can afford an attorney, a private attorney, do they not go through the do they not go through the OPD hotline?
Usually, if you can afford a private attorney, you don't go through the OPD hotline.
Right, so not everyone calls the hotline.
No, ma'am.
Okay.
Not everyone calls the hotline.
All right. Can I waive your rights for you? I just want to know.
You could not waive my Miranda rights.
Right.
But we're not talking about constitutional rights. We're talking about a statutory.
Can I waive your statutorily?
If you pass this amendment,
rights.
you could. If I was your parent, guardian, or otherwise, and all I would be doing is taking that impediment away to an actual conversation if it was be had. But you've got the parents there who care and they want their child to talk. They still don't have to do it.
So is there anything in the bill that prevents the child from coming back with their parent and speaking later? Just voluntarily making a confession?
Well, if they're not in custody, that's the whole thing. It has to be a custodial, and usually this is when they've caught you red-handed and your parents come down. Okay.
Right. So your parents come down, you follow the statute, you follow the law as it exists, you go home, mommy and daddy.
Well, you're no longer in custody.
I got it. Mommy and daddy say, I really wish you had talked, Junior. You didn't talk. I'd like for you to tell what happened. Junior, you march yourself right back down there to that police station and you tell them what happened. Because you're saying that's what would happen in the police station anyway. Is there anything in the bill that prevents a parent from coming down with their child and that child making a confession?
No, ma'am. But the way we instruct in-service law enforcement is because they're very hesitant to do it. I mean, ideally, you would approach a child if they're not detained and go in a setting like they're in the living room with the parents present, so there's none of this impediment, there's no handcuffs, there's no in the back of the car and all that. But in the real world, when somebody's done something serious and you have a situation where a kid is picked up with a gun or something like that and they're picked up with other adults and stuff and you know, there's not always that time. You have the child there. There may be a public safety threat. You have to address it then. You might not be able to let them
And
go.
isn't there a public safety exception in the bill?
There is, but nobody really knows when it applies, and they're
Is that a
afraid.
problem that we need to fix, or do people need to read the bill and understand the law?
Well, it hasn't been interpreted, so law enforcement officers and their counsel are gun shy about testing the waters on these things and where they might end up. Look, I understand if some kid, there's a bomb threat called into a school, or I'm going to shoot up a school on social media and things like that. But in those instances, you go the extra step, you get a warrant, and you go down there and you do other things. So it's very tough, when a piece of legislation has to be interpreted by law enforcement in the field. It just is.
It doesn't have to be interpreted by law enforcement, but I understand your point and I respect your opinions. I just don't agree with them.
Yes, ma'am.
Thank you.
So I'm going to ask a question on the vice chair's, to follow up on the vice chair. The section that creates that exception is in G. The law enforcement officer reasonably believes that the information sought in the questioning is necessary to protect against a threat to public safety, and the questions posed to the child by the law enforcement officer are limited to those questions reasonably necessary to obtain the information necessary to protect against the threat to public safety. For example, somebody in a county who they were looking at the child as he was leaving. They suspected that he may have been involved with a shooting in the school. What would stop the sheriff in that county from saying, "Where's the gun"?
Yeah, and I hear what you're saying, but you'd have to develop, the other thing is, you'd have to have developed probable cause to actually have detained the child, or else they'd have to come in at your request. And that's not always a guarantee. Like, are you telling me that they've taken them out of off the school property as they're leaving? I mean, in the scenario, what's the scenario? Are the facts fleshed out?
They're standing outside of a school. The child, they enter into a custodial interrogation because he doesn't feel free to leave. It's a custodial interrogation, and they had just got the kid there, and they asked him, "Where's the gun?"
Okay,
the gun's in the school. Where's the gun?
Yeah, I hear what you're saying, but what calls them? You're talking about custody. Once again, to detain, you at least have to have a reasonable suspicion or probable cause to do that under Terry or some
They have
other
that.
thing.
They have the reason to.
Well, you can.
Where's the gun?
You can do that, and
why is that difficult to? Why is that difficult for law enforcement to figure out?
Well, if they don't know the animal, if they're just uncomfortable with it. But like I said, at this juncture, a lot of different things, they just figure it's safer to get these blanket policies so they don't offend some policy and get in trouble as a rank and file officer.
When I was here and in this chair when we were working on this, and this was language that was expressly requested by law enforcement
I got
added to the bill.
I got you, and like I
so
said,
if it needs to be clarified, I think we'd certainly be interested in how to clarify that language.
I agree, but in your examples, in the public safety example, that's the rarity, not the norm of the contacts and custodial interrogations of juveniles.
I accept that, but again, I'm not sure what is unclear about the.
Well, it's not unclear. They're uncomfortable with it, and it hasn't really come up. We haven't had that situation. But what does come up routinely is you stop a 16-year-old driving and they've got a bulge, and you take out and they have the gun, and you do certain things like that. And like I said, in certain cases, I mean, I'll give you an example. You've got the vandalism, malicious destruction of property. The kid's caught red-handed. The parents come down and they say they want little Johnny to confess. But even in this case, even if the parents want them to have this discussion, you have to call the no talk, the say nothing hotline.
I'm gonna rewind your comment just 15 seconds. They caught him red-handed. Why do they need the child to confess?
Well, the balls is a problem.
They caught him
I'll give you that.
red-handed. Why do they need the child to confess?
Well, I get you, but there's certain circumstances.
Do you?
Like,
I know, I'm sorry. I'm missing something here because that's the consistent issue here is, and you said it before.
Well, you're a prosecutor. You always want a confession.
I feel like I caught
too.
you red-handed. I mean, that is.
That's not the best example, but
Okay.
I'll give you the example.
I'll stop because both of us are, okay. I was the calm one for a second. Never mind. Delegate Boucher.
Thank you, Chair. And it's a little bit difficult because I'm friends with both these individuals, but let's deal with the text of the bill. The child's parent, guardian, or custodian consents to the custodial interrogation of the child without the child's consultation with an attorney. Let's look at the supreme law of the land. Amendment 5, no person shall be compelled in any criminal case to be a witness against himself. Amendment 6, in all criminal persecutions, the accused shall have the assistance of counsel for his defense. Where in this document does it state that a second or third party has the right to waive the constitutional rights of the first party?
Well, Delegate Bonsoret, good evening. I know you're a keen scholar of the Constitution. Bonsoret, it's French for good evening. It's good French for good evening, but
merci beaucoup.
Yes, I know you're a scholar of the Constitution, but once again, the fine distinction is we're not talking about this Sixth Amendment right. We're talking about a statutory requirement that is not enforcing the Sixth Amendment right. That's a different fine distinction. There'll still be read what we call a simplified Miranda warning for youth. It'll be recorded. Everything's recorded these days, so you have that safeguard. And he or she can still make up their mind whether or not they want to consult with an attorney. It's just that this pro forma checkbox where you actually have to talk to somebody, you have to. So they're not waiving a constitutional right. They're basically waiving or consenting to out of a statutorily created checkbox. And I believe it would pass constitutional muster.
Thank you.
Thank you both very much. There are people to testify in opposition to the bill. Marlon Tillman, Kelly Quinn, Frank Pazzadella, Aubrey Edwards-Luce. Mr. Patinella was first.
Hi. Good evening, Mr. Chair, Vice Chair, and members of the committee. My name is Frank Patinella, and I'm a policy advocate with the ACLU of Maryland. We oppose House Bill 622. We worked to pass the Child Interrogation Protection Act a few years ago, and we are advocating that it remain unchanged because of the protections that it provides for children. First and foremost, the Miranda rights of a child is the child's right, and the child's right alone. Parents or guardians can certainly be there to support their child if they're in police custody, but we assert that it would be unconstitutional to allow a parent to waive their child's rights. Secondly, studies have found that children don't understand the legal implications of their Miranda rights, which is why we support the requirement that law enforcement contact an attorney or public defender for a child before an interrogation. An attorney can explain unfamiliar legal terminology and processes in age-appropriate language so the child can make an informed decision. Also, law enforcement use scare tactics and intimidation during interrogations, and studies have found that children are much more likely to falsely confess under that kind of pressure. One study showed that children are 3 times as likely to falsely confess than adults. The research also shows that adults, on average, don't have a strong understanding of their Miranda rights either. Allowing parents to give consent to an interrogation of their child might sound like a good move, but many of them are simply not qualified to advise their children about the risks of waiving their rights. And if a parent is allowed to give consent to an interrogation, that added pressure on the child will increase the likelihood of a false confession. This bill will not improve public safety, and it could negatively affect an investigation. Lastly, the current SIPA law allows law enforcement to interrogate a child without contacting an attorney first if they reasonably believe the child has information about a serious threat to public safety. For these reasons, we ask for an unfavorable report. Thank you.
Sure, I'll go next. Thank you. Good evening, everyone. Thank you for your patience tonight. My name is Aubrey Edwards-Luce. I'm the Executive Director at the University of Baltimore School of Law's Sarah and Neil Meyerhoff Center for Family, Children, and the Courts. CFCC envisions communities where children and families thrive without unnecessary legal system involvement. We strongly oppose HB 622 because it would violate youth's rights and would fail to inform parents before they provide consent that could have lasting impact on their children. Youth's constitutional rights to counsel and against self-incrimination have long been confirmed in the United States by the United States Supreme Court. Maryland law currently provides youth the right to consult with a private attorney or an attorney of the Office of the Public Defender prior to being subjected to custodial interrogation by a law enforcement officer. These rights belong to the youth by nature of their humanity and presence in the United States of America. Youth's rights to counsel can only be infringed upon to advance a narrowly tailored government interest, which is to protect against the threat to public safety. Allowing a parent or custodian or guardian's consent to be substituted for the youth's informed waiver functionally denies the youth's right without requiring a narrowly tailored government interest. Secondly, under current Maryland law, police are allowed to trick and deceive youth during custodial interrogations, which can lead to youth providing false confessions. By allowing a parent's consent to stand in place of a youth's informed waiver, a parent might be exposing their child, who is innocent until proven guilty, to emotional or physical harm or the possibility of making statements that could have lifelong impacts for them. To be clear, a parent's consent should never take the place of a child's informed waiver. But if this bill were to pass out of committee, it should at least be amended to ensure that parents are informed of the risk of harm to themselves or to their child or to their relationship should they consent to their child's interrogation. Thank you.
Hi, hello, and good evening. I'm glad to see you. I am Kelly Quinn. I am represented by Delegate Luke Clippinger in District 46. District 46 is part of the real world where we believe in constitutional rights. The choice program at UMBC is opposed to 622. As a mentoring program, we have served more than 27,000 families in the state of Maryland and their young people since 1988. We serve as an alternative to the school-to-prison pipeline. I love coming here to talk to you about our work. I'd like to direct you to our written testimony, and I want to quote Frank Patnella and say, me too. I'll say what they said. And then I want to tell you about that night, Luke, that we met you last Monday when we came by your office, the ACLU et al.'s Day of Action, when Aubrey Edwards-Luce, the Executive Director of Sarah and Neil Meyerhoff Center for Families, Children, and the Courts, reminded us Miranda rights are children's rights are human rights. For these reasons, the choice program opposes HB 622.
Delegate Eric Hand.
Thank you, Mr. Chair. Thank you guys for staying up late with us. Isn't it so fun? We do this all the time. Okay, so in my area, there was a case, a shooting in a school. The police arrived, but there was no imminent public threat, so they didn't interrogate the youth. The gun, to my knowledge, to this date has still never been found because there was never any interviewing that occurred. So I'm thinking, is there some kind of middle ground we can come to? Like, what if we take the parents out of the equation? What if we do a child Miranda? And what about if we say you can't lie to kids under the age of 14 because they're too susceptible, they won't know any better, they won't know you're lying, whatever. What if we came to some kind of ground like that where we remove the parents completely, we give the kid a reasonable child Miranda, and then we prevent officers from lying to youth under 14? What do you think?
I can speak for our organization, and we're not in a position right now. We just don't have the time to dig into that right now, but happy to meet with you in the interim.
Okay, that's cool. Hey, that's a maybe. We're going somewhere.
Vice Chair.
Oh, I was just. She was thinking. She's pondering.
It's late for a law exam, with this hypo, right?
It's never late for a law
Never too
exam in
late.
this committee.
Never too late.
We're starting the rule on perpetuities here in a couple minutes.
24-hour, oh, Lordy. Okay, so I thank you for the hypo. Thank you for considering ways in which would uphold youth's kind of authority over their rights. I think, part of what's really important for that is that youth really need to be informed about what those rights are, and I don't really know how you get past that without actually talking to an attorney. So happy to engage in more thoughts around that, but I think that piece of requiring for youth to be able to consult with an attorney is important for them to be able to provide that informed waiver, right?
I hear you, and they wouldn't be prevented from doing that. They can always, once they hear the child Miranda rights, say, I want my attorney. Do you know what I mean? That they would still have the opportunity to say that. I'm trying to think of, though, in this case, we still have a missing gun. We don't know where this gun is. It's just floating around, and it can't be that far because they caught the kid pretty quick. So somewhere in the radius of the school and that child's home is a gun. Do you know what I mean? But it's not an imminent threat, so we don't know where it is.
Yeah, I hear you.
Yeah. All right. Thanks, guys.
Thank you. Seeing no other questions, thank you all very much. That concludes the testimony on House Bill 622. All right, now I think it's just us friends here the rest of the way. We're not waiting for anybody else. 638, Delegate Grammer. Grammer. Tina Tuffer? No?
Tina Tuford had a family emergency and she couldn't make it.
I'm sorry to hear that. I'm very sorry to hear that.
I'll get started when you're ready.
Please, 3 minutes, go ahead.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 638. House Bill 638 alters juvenile sex offender laws. Tina Tuford's 3-year-old daughter was raped. It was unbelievably tough for the family. Dealing with the schools, the courts, and the juvenile system made it hell. The offense that her daughter's rapist was convicted for as a juvenile was not on the statutory list. He was therefore not listed on the juvenile sex offender registry and was immediately placed back in public school. It wasn't until Ms. Tuford took it upon herself to call the school system to make them aware of the infraction that the school system investigated the issue and the student was removed. The family thought the nightmare was over. It wasn't. It was found that the juvenile was placed back into the public school system in Baltimore City. When the family inquired, it was found that the offender had left the jurisdiction of the juvenile system and which allowed him back into the school. When we passed House Bill 814 last year, it was unilaterally agreed that juvenile sex offender registrants would find alternative placement. It was mentioned that last year's bill had a massive holes and pointed out by the Tuford family, and it was advised that that was a bill for next year. Here is that bill. House Bill 638 deals with this issue in 3 ways. It expands the offenses that require an individual adjudicated delinquent to register with the Juvenile Sex Offender Registry to include any act prohibited under 3307 of the criminal law article. Second, the bill includes any violation of 3307 of the criminal law article as a reportable offense so that the schools are aware. Finally, the bill requires a juvenile sex offender registrant to remain on the registry until the registrant reaches age 21 while the juvenile court's jurisdiction over the registrant terminates. House Bill 638 closes gaping loopholes in the system that has allowed for rapists to be placed back in school with their victims and other potential victims. Our law allows horrific acts of rape to avoid registering. The law doesn't require school systems to be informed and allows offenders to reentry, which, to my recollection, was never intended or discussed. Tina Tuford could not be here today. We bring this bill on her behalf. Our intent is clear: alternative placements for sexual predators. We should close these loopholes to achieve that intent. Thanks for hearing House Bill 638. I'd be happy to take questions, and I'd ask for a favorable.
Questions? Don't see any. Delegate Valentine.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill. I did have one question. How often does someone come off the registry in general terms prior to age 21? Like, what are the circumstances in which they would come off and still be in school?
Well, it's really hard to know anything about that because none of it's public. And just to be clear, To be found juvenile, it's up until age 18, but the juvenile court actually has jurisdiction over those defendants within the jurisdiction of the system up until 21 for those cases. So it's really hard to know anything about that information at all.
Kind of one more question. What is the main, we heard a bill from Delegate Griffith today. What are the main differences between your proposed legislation and his bill earlier?
Great question. If you could read this bill in 15 seconds. It expands the crimes for which you're put on the registry from a handful of crimes under 3307 to all of the crimes under 3307. And the crime that was not on the list was sex with a child 10 or under. So it really just tightens it a fraction. It also lists all the crimes on 3307 as reportable offenses. And one of the, I guess the biggest difference between, one of the differences is he has a slew of other criminal offenses that frankly I just don't include. But the big difference I think between my bill and his bill is that he allows superintendents access to the registry. And in my bill, I just keep them, even though the juvenile jurisdiction expires, my bill keeps them on the list until the court finally has zero jurisdiction.
Thank you very much.
Thank you.
Thank you, Mr. Chair.
Any further questions? No. Thank you very much. There are people testifying in opposition. Ms. Letourneau is not there. Stephen Bergman, Alyssa Fieo, Megan Berger, Kelly Quinn.
Hang in there.
Kelly? Okay. You're the only one, well, maybe not.
I think Stephen and Alyssa are going to be virtual, and Aubrey's
We
here.
don't have anybody. Yeah, virtually. Kelly, it's just you, and you're going to get 2 minutes.
Okay. Hello, good evening. I'm Kelly Quinn. In this moment, I am here representing the Maryland Coalition to Reform School Discipline. We are advocates, service providers, community members, and attorneys who are dedicated to transforming school discipline practices in the Maryland public school system. We are committed to public safety just as we want to end the school-to-prison pipeline. We strongly oppose HB 638, and I'm going to just to reiterate some of what I said earlier when we had Delegate Griffith's bill. We are guided by facts over fear. We believe in research, science, and the law. We also draw from our professional practice, and in our considered opinion, we know that, as Professor Letourneau would be able to tell us if she were still here, treatment works for children with sex offenses in 97% of the cases, and is not appropriate as a long-term placement. This bill would also run afoul of federal law and regulations, including IEP and Section 504 of the IDEA. We already have 3 existing mechanisms in place to achieve this bill's goals. We have the courts. The judges possess the most facts in cases like these and are best poised to determine whether a child is safe to be in community. Last year, we had other process with HB 814. We had other processes, including a provision, and we have reportable offenses statutes that ensure school safety. I will say, as I've said earlier, education is the #1 protective factor in preventing youth from recidivism. Our communities are not safer when children are denied the structure and support services that schools provide. All children deserve classrooms, not screens. We're opposed to HB 6, whatever.
All right, questions, Delegate Grant.
Thank you, Mr. Chair. Thanks for being here very briefly.
Thanks.
I don't want to talk about this issue anymore, and I find myself coming back to this table to unfortunately do this. We've been dealing with this for 5 years now. Do you agree that it's the intent of the General Assembly to have alternate placements outside of the general public school system for sex offenders? Because that's what we tried to do under House Bill 814 with that provision is we tried to find alternate placements for sex offenders outside the system. Do you agree that's our intent?
I understand that to be your intent, and I also understand last year that this happened very quickly without careful deliberation and consideration.
So I just wanted to clarify, that is our intent. We've always discussed it that way. We don't want to have these holes. You mentioned that one mechanism we have is reportable offenses. Yes, that's correct. That raping a 3-year-old isn't included in the list of reportable offenses. And that's actually what my bill does, is it includes that crime. So why would you oppose that if you support that mechanism for dealing with this problem?
Because we are opposed to blanket restrictions, and we don't want to legislate on the most extreme and sensational cases, as scary and painful and difficult as they are to hear. We want to be able to have individualized treatments and responsive plans for all students.
Thank you, Mr.
Chair. And
Chair.
that's what reportable offenses does.
All right, seeing no further questions, that concludes the testimony on House Bill 638. Now, oddly, 683, just reversing the last two numbers, is going to be Delegate Grammer. Uh-oh, people just walked in. All right,
I'm ready when you are.
Delegate Grammer is testifying. There are a couple people opposed. I don't think there's anybody, no. Okay, Delegate Grammer.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 683. House Bill 683 adopts a framework for parental liability for delinquent acts of juveniles in their legal custody. One approach that some states have taken to help remediate juvenile offenders and decrease recidivism is to put in place parental liability measures in cases of juvenile crime where parents fail to deliver on their parental responsibilities. Approaches that other states have taken range from penalties, restitution, and even compelled participation in proceedings related to a child's delinquent or criminal act. For cases where a parent fails to deliver on their parental responsibilities, House Bill 683 puts in place a 30-day misdemeanor penalty, a $2,500 fine, mandatory restitution, and required participation in court proceedings, treatment, counseling, or diversion programs related to the child's delinquent or criminal act. Studies have shown that parental involvement improves student behavior and reduces delinquency. And we can remind parents who are negligent that they have a responsibility by passing House Bill 683. With that, I'd be happy to take questions, and I'd ask for a favorable.
Questions? Seeing none. Thank you very, Delegate Embry, sorry. Go ahead.
Delegate, I'm sure I'm missing something, but the existing law that the misdemeanor prohibiting a parent or any adult from contributing to delinquency of a minor.
Could you speak into the mic?
Oh, I'm so sorry.
I'm a little deaf.
No, I'm sorry. So the existing law that prohibits any person, not just a parent, from contributing to the delinquency of a minor, why does that not cover this behavior?
I actually couldn't find any framework for engagement or requirement or penalty for a parent who is negligent in their responsibilities, and that's why we brought this. This is modeled after language out of California.
I'll send you an email, but thank you.
Thank you.
Further questions? Seeing none, thank you, Delegate. We'll hear now from Vanita Taylor. Nadine Finnegan-Carr, please, for 2 minutes each in opposition to the bill. Ms. Taylor, please, for 2 minutes.
Good evening, Chairman Clippinger and committee. We are requesting an unfavorable report on House Bill 683 because as a question that was asked by the delegate, this bill is unnecessary. It is only a barrier to parents who are trying to do the best thing that may fall a little short. But I will tell you, there are statutes. It's redundant and unnecessary, and not any way does it promote public safety or rehabilitation. Anyone that's familiar with the Juvenile Code, Courts and Judicial Proceeding will know 3-8A14C, parental failure to bring the child to court is a liability. 3-8A17, A and B, there is required an examination and evaluation of the parent, the guardian, and the custodian. 3-819, D1, orders the parent, the guardian, and custodian to participate in rehabilitation services. 3-826, there's an order of controlling conduct that can be issued by the court for a parent who fails to abide by the regulations that the court has put on them in order to further their child's rehabilitation. 3-8A30, there is a crime for causation of encouragement of a child's delinquent act. It is prohibited under 3-8A30. We also have criminal law 3-602.1, criminal neglect of a minor. Under the center provisions, parents have the right to request reasonable efforts to assist them in parenting their child. We also have in the center provision 3-816 was an examination of the child, parent, guardians, or custodian. This bill is punitive, it is unnecessary, and it does not further any safety or goals of the state of Maryland. We request an unfavorable result.
Nadine Finnegan-Carr, Executive Director of the Center for Violence Prevention at the University of Maryland, Baltimore. This bill would, instead of strengthen our communities, contribute to their detriment. Some of the language is intentionally vague and may have a disparate impact on Black and or low-income parents. Charging parents does not address the issues which would put youth at risk for committing crimes and engaging with the juvenile justice system. In fact, it may actually bring the youth further into the criminal justice system as a result. I also have experience with 2 of my children. There are 4 of them, I won't say which one, and the juvenile justice system. They are all now adults and college graduates, but some of the things that I was able to do because I could flex my time, others would not be able to do, and as a result, they may end up charged. Families most impacted are comprised of parents and guardians who are struggling financially, working long hours, multiple jobs, and it already limits our ability to provide the level of supervision that they want because of this. This bill disproportionately targets families which are already vulnerable, especially low-income racial ethnic minorities such as Black families. Financially or criminally charging these parents and or incarcerating them for their perceived actions would be an overreach. There is no shortage of data on the negative impacts of this on their children, impacts which would be felt for the rest of their lives. This includes the fact that engaging their parents would add an additional adverse childhood experience to their lives, and these are children who are already disproportionately impacted by adverse childhood experiences. For these reasons, the University of Maryland, Baltimore Center for Violence Prevention is in opposition to HB 683. We would be willing to work with sponsors in the future to draft a better bill that might be more impactful in addressing issues which relate to the rehabilitation of juveniles in our state. Thank you.
Thank you, Mr. Chair. Thanks for hanging out with us. Okay, so you read through a list of like a lot of things that parents can get in trouble for. Can you sort of talk me through, so could only a judge put those in place, or could a police officer or some other law enforcement?
These are done by judge.
Okay, so how often are they, have you ever seen them used before?
Oh, all of these statutes are used on a regular basis in juvenile court.
Okay.
In fact, there was one I didn't mention about restitution, which is 3-8A28. Restitution can be ordered to parent, the child, or both, and it's done on a regular basis in juvenile court.
Oh, interesting. Okay. All right. So it is happening. I guess we don't really hear about it a lot. I haven't read hardly anything about it in the news happening. What's the difference between that and what this bill does?
What this bill does is criminalizes the parent's behavior. If they are a poor parent or something happens, this criminalizes their behavior and makes them liable for the actions of their child and the fact that they may not be a perfect parent. That is not what we choose to do. We choose to rehabilitate children. We choose to work with the families. In fact, in juvenile court, they will often order, depending on the issue, they will order family therapy. So this
I
bill,
have seen that.
This bill doesn't do any of that. All it does is be punitive towards parents and families.
Well, it does say on page 2 that they would have to participate in all treatment and counseling or diversion programs, that kind of thing. So it at least tries to reference some of the alternative options that judges might order. But are the other things you mentioned, would you consider those punitive as well?
Well, the things that I've mentioned are things that are already in our code, already in our statute.
Are punitive in nature.
Some of them can be punitive if you fail to act. But they're already in the statute. We don't need a statute. We don't need to add another crime to parents who are trying to do the best that they can do in order to say that we're doing something for public safety. This bill does not do that. It only criminalizes parents. And in fact, if we put a parent in jail, who's going to be there to take care of the child? Or the children in the household? Because they have more than one.
I hear you. I mean, your concerns, I think, are valid. I just say some of these parents are literally not doing the best they can. Not all of them, maybe not even most of them, but some of them are definitely not doing the best they can. I mean, our colleague over here is a social worker, and I've been able to pick her brain a lot. And some of the saddest cases she's told me about are parents who just don't care about their children's behavior, and she sees it. So most parents I know want the best and are really invested, but there are some parents that just don't care.
Well, they could be charged with criminal neglect, see? So there is already a statute on the book.
All right, I appreciate you guys.
Further questions? Seeing none, thank you very much. That'll conclude the testimony on House Bill 683. 588.
Thank you, Mr. Chair.
Ms. Finnegan Carr, I believe, is in favor or opposed?
In favor.
In favor, all right.
Ooh.
All right. Let's see what happens next. Delegate Grammer.
Just as shocked as you are. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 588. House Bill 588 requires the Department of Juvenile Services to report to local school systems arrest for reportable offenses or involvement in criminal organizations. Quoting local CBS News, Howard County Superintendent Bill Barnes told WJC he had no idea a 17-year-old student at Howard High faced attempted murder charges for a violent attack that left a victim paralyzed when he was placed in a school on an ankle monitor under the supervision of the State Department of Juvenile Services. The student is now charged as an adult with first-degree murder of a man from Baltimore who police found shot multiple times in his car earlier this month at an office building parking lot near the school. The 17-year-old was arrested at Howard High with a ghost gun that police said was loaded, had an extended magazine, and was modified to be an automatic weapon. When asked about the situation, Secretary Schiraldi responded, "When a young person is arrested for that, the police are supposed to inform the school system," Schiraldi said. "And when a young person is convicted, then it's the state's attorneys that need to inform the schools. DJS is actually prohibited from informing schools." Again, quoting the local CBS News article, "Do I think that a student who is alleged to have committed first-degree murder should be in our schools? I do not, and my placement decision would have been different and reflected that," Superintendent Barnes said. Barnes also said, "We did not know because no additional information was disclosed to the school system by the Department of Juvenile Services, the history or nature of the student's prior alleged crimes. He said school officials only learned of the details of the past case by attending the bail review. Quote, if this information and data had been available to me prior to yesterday, I assure our community that I would not approve placement at Howard High School. Our school systems are blind to the offenses of students who do not belong in the school system. House Bill 588 deals with this problem by requiring that the Department of Juvenile Services communicate to superintendents student arrests for reportable offenses or arrests related to criminal gang activity, as well as any educational program offered to that student. We can end the train wrecks in our school system by making the systems more informed. With that, thanks for the hearing for House Bill 588. Be happy to take questions, and I'd ask for a favorable.
Okay, Nadine Finnegan Carr again, Executive Director of UMB Center for Violence Prevention, and we are in support of HB 0588. I lost track already. All children deserve to be assisted in doing well in school, and this bill rectifies an issue that has an impact on their long-term well-being. Academic achievement levels influence a child's entry into and exit from the justice system, a fact that should not be ignored, taken alongside the fact that only 16% of Black and 29% of Latino fourth graders read at proficient levels, and that reading proficiency for special education students continues to decline. The message should be clear. Our education system is failing, and when those students end up in the justice system, this impairs our ability to restore young people to their communities. So if public education is really to realize its full capacity to reduce recidivism, it must make learning a top priority for justice-involved youth. And I believe that this bill fills a loophole with that. The intent of this bill to reduce the barriers which impact students' return to in-person learning, especially for those who are not formally processed by DJS or adjudicated delinquent, but were removed from in-person learning or otherwise disciplined following an arrest is necessary. Students in the justice system have significant educational needs that should be met by their local government, but notifying their superintendent so that they can provide them with the appropriate placement is necessary in order for them to achieve, and their academic achievement is predictive of whether or not they are recidivate. And so one specialized area for these students is their transition back to transitional school. This transitional period being fixed is something that I am definitely in support of, and we respectfully encourage a favorable report.
Thank you, Mr. Chair. I don't know if you already had any opportunity to look at the, let me scroll up and make sure I get the right title right. The Public School Superintendent Association, they were also favorable with it. Have you read it yet?
I have not seen it.
Okay, it's really long and detailed. So whenever you get a chance, maybe you could look through and just see if, I can't even find, it's so long, it's like 3 or 4 pages long. There's obviously an amendment somewhere in here, but maybe we could talk offline about what that amendment looks like and whether or not you like it or not. Can you just talk us through the practical implementation? Like what does this actually do on the ground level?
Yeah. Thank you for that question. So I've referred several times to the time I served on the Juvenile Oversight Fatality Review team. And if there's one thing I learned by being a member of that team, it's that Department of Juvenile Services and the school systems hate each other. And they constantly blame each other, and there is a distinct lack of communication. And for the school systems, they always say, we receive these kids and we don't know what the heck is going on. And I think that's a very fair argument. You know, back when, I think I was maybe sitting in on waiting for a bill hearing, and was Delegate Parrott had this almost a similar bill, and he was alongside the superintendent for Montgomery County Public Schools, not like a tag team you'd expect to see a whole lot.
Right.
But he made a very reasonable argument about communication and that, frankly, school systems are blind. Like, this gentleman is the superintendent of the Howard County Public School System, not like a raging conservative jurisdiction, you know what I mean?
Yeah.
But no matter what jurisdiction you go to, you hear the same concern, like, we just don't know. And if we just, look, if we knew the reportable offenses, criminal gang activity, and what educational opportunities this young person's already had, that would help us immensely.
Right.
And I think that's why I got a surprise supporter here
Yeah,
today.
and that's very much the tenor of the superintendent's letter, like the lack of communication, like being to the detriment of the student seems to be their biggest concern.
And keep in mind, the student file is shielded, so.
Right.
You know,
Right.
and another problem this addresses is the student moving from jurisdiction to jurisdiction.
That's another thing that they mentioned as well.
The other thing it seems to fix is the issue of if the child does receive alternative education, the superintendent being able to know where that student is in their educational levels when they return to the public schools. That piece is missing. And it is partially, I don't know if I would say they hate each other, but they definitely don't communicate, and it's because legally we don't allow them to communicate.
Right.
100%.
So this would address that.
Yes.
All right, awesome, thank you.
Tomlinson.
Thank you, Madam Chair. The testimony from DJS says House Bill 588 is repetitive and unnecessary as existing protocols already govern appropriate information sharing between DJS and local education agencies. Additionally, the broad information sharing requirements outlined in the bill raise concerns about student privacy and may create unintended barriers to successful reintegration into school communities. So one, do you think your bill is repetitive and unnecessary? And two, what do you think is more important, getting a juvenile offender, back into the school, or the safety of every other student?
This is why I slowed down when I read this section, so I'll read it again. When asked about the situation, Secretary Schiraldi responded, when a young person is arrested for that, the police are supposed to inform the school system. And when a young person is convicted, then it's the state's attorneys that need to inform the schools. DJS is actually prohibited from informing schools. So as the young lady said, the problem is that they're actually prohibited. So what we're doing here, part of the bill is statutorily empowering them to do so, but we're also saying that they're required to do so. So for me, I think, another thing I learned from being on the Fatality Review Committee is like truancy, like students disappearing from school is one of the top indicators that the student's going down a bad road. And I think, remediating the student and getting the student its educational opportunities, it's all part of the same question. I think we got to step back and look broadly at what we're not doing. And what we're clearly not doing is communicating with the school systems. Can I get an amen?
Amen.
Amen, Madam Chair. Thank you so much.
Other questions? Making me nervous. Okay, seeing no other questions, I don't think there's anyone signed up unfavorable. Okay, so that ends the testimony on House Bill 588. Next, we'll go to House Bill 1107, Delegate Bartlett. We have Delegate Bartlett, Emily Virgin, Sarah Sample, Marlon Tillman. Oh, he's online. Okay. All right, and we'll stop there. Unless there was anybody else you wanted to bring up with you, Delegate Bartlett.
Everybody can come up.
Everybody who's favorable, come on down.
Because I only have one unfavorable, and they're not here.
Okay, and there's some favorable with amendments, I think virtually.
We're all on the same page.
Okay, everyone's on the same page. So if you're favorable or favorable with amendments, just
Oh, she is? Okay.
come on down.
All right. May I start?
Yes.
All right, hello, good evening, and I'll make this quick and painless. For the record, I'm Delegate Sandy Bartlett. The goal of House Bill 1107 is to get kids out of adult detention. One thing you've heard all day long is we have kids in adult detention. We have kids in adult detention. Did you hear 23-1? That means when they're in adult detention, sometimes a child could be in restrictive housing for 23 hours, out for 1. So House Bill 1107 does 2 things. Well, it does more than that, but definitely 2 things. And that is, 1, it codifies restrictive housing requirements for with the use of children and adults, so that no one is in restrictive housing longer than 6 hours. Now, you will see in the only opposition testimony that we have from Department of Juvenile Services that they state that they only go up to 1 hour. That's fine. I don't have a problem with that. It says up to 6 hours, so I don't have a problem with that. Currently, Maryland is in violation of federal law. Maryland is losing money. The Secretary Schiraldi mentioned the Juvenile Justice and Delinquency Prevention Act, JJDPA. That is federal funding that we get if we follow the law. We're not following the law. We're not in compliance. We're losing money up to $500,000 per year because we have to put children in, well, according to DJS, we're putting children in adult detention facilities, as you will hear, and they are in restrictive housing, but they're not fully separate by sight and sound as they're supposed to be. I went to Jennifer Road Detention Center. I went to the Baltimore Juvenile Justice Center, night and day. The children in the Baltimore Juvenile Justice Center, some are charged as adults, but even then, they have a better situation than those in a detention center. The correctional administrators are here today. They're going to tell you their position, but I will tell you that what they had to do was pull down a screen. That was the best that they can do because it's just the adult facilities are not made for children. Also, let me just tell you, DJS is going to says that they don't have capacity. Let me let you know that It was DJS who brought this bill when it was required in 2021. The federal law said you get 3 years to get your act together. Here comes DJS, emergency bill number 1, emergency bill number 2, and we never got it. We got one passed. JPR got one passed 1 year. We've never gotten the two passed in both. We've never gotten the bill passed in both chambers. So here we are. Let's pass the bill. Let's get compliance, and let's get our federal dollars.
Good evening, Mr. Chair and members. For the record, I'm Emily Virgin, Director of Advocacy and Government Relations at Human Rights for Kids. This bill seeks to protect children against solitary confinement in 2 ways: by placing strict requirements on its use while still allowing for a temporary cooling off period, and by prohibiting children from being held in adult facilities. For children in DJS facilities, current DJS policies, according to DJS, meet or exceed the requirements in this bill, and we applaud them for that, but we know that administrations change, agency policies change, and that means that codifying these best practices in statute is the best way to protect children. Prior legislative efforts to end solitary confinement for children, while they made huge strides, they did not fully protect children in Maryland. The bill in front of you today would end the use of solitary confinement on children. That's because this bill removes children from adult facilities. Maryland does still allow children 30 to 40 on any given day to be held in those adult facilities. Federal restrictions prohibiting children from having sight and sound contact with adults means that when children are in adult facilities, as you've already heard, they are in solitary confinement. The state, as you've already heard, is at risk of losing federal funding because of these placements, and I'd encourage you to read the written testimony from Maryland State Advisory Group on that issue. The effects of solitary confinement are well documented on the mental health of a child who's being held in an adult facility. They are devastating and have led to the suicide deaths of children across the country. Children who are held in adult facilities are 36 times more likely to die by suicide than children who are held in juvenile detention facilities. Khalif Browder was one of those high-profile cases who died by suicide after being subjected to solitary confinement in New York. But just last year, a 16-year-old girl in Mississippi died by suicide in an adult jail. We implore the committee to not wait until something this devastating happens in Maryland before you take action to end this practice.
All right, good evening. I'm Laura Wilt with the State's Attorney's Office in Frederick County. I am a member of the Maryland State Advisory Group that wrote that letter. I'm not here speaking on their behalf. I'm an informational witness. I think I have read the amendments that are submitted, that have been submitted by Delegate Bartlett. I am so thankful for her work on this, and I do not understand. So it seems every year that we have had lengthy arguments about juveniles charged as adults. And every year advocates stand before you and they argue, it's awful having our youth in adult detention centers. So we need to strike the whole transfer laws and change this. But in reality, you can fix this problem by passing part of the amended legislation that's before you today. You have repeatedly heard our state's attorneys outcry that the decisions based on these serious cases should not be held and put in the hands of the Department of Juvenile Services, and I fully agree with that. But this bill is a compromise and it is a solution. Over the last 2 years, the Department of Juvenile Services response to juvenile crime has gone from bad to worse. In order to respond to serious crime, our laws regarding the juvenile service process must be changed. But you can make a difference by looking at this legislation, and specifically I would point to the amendment which puts in place criminal procedure 4-202.3. In that, it specifically says it basically puts this in process. If a police officer arrests a juvenile for a charge that they will be charged as an adult, they will go to a juvenile detention center. They will stay there until a judge makes a decision on a transfer hearing. So there's too many specifics, and I am not here commenting on the first 4 pages of the bill. I'm going to leave that part to the experts.
Good evening, Chair, Vice Chair, committee members. Thank you for this opportunity. I'm Ryan Ross, the president of the Maryland Correctional Administrators Association and the director of the Charles County Detention Center. I'm here today in support of Senate Bill 827 with amendment. The intent behind this bill is crucial. It seeks to ensure that children, including those under adult criminal court jurisdiction, are not housed in facilities where they are within sight and sound of incarcerated adults. This is essential for their safety and rehabilitation. Local adult correctional facilities are simply not designed to house juveniles. They were built to accommodate adult offenders, and their architecture is not allowed for proper sight and sound separation between adults and juveniles. While some of these facilities could, in theory, make infrastructure changes, like adding new wings or sections, the construction costs would be upwards of $30 million for each of the jurisdictions in Maryland. Staffing and program costs would be parallel. That said, retrofitting adult facilities is not the best or most efficient way to address the needs of juvenile offenders. Currently, juveniles who are initially booked into adult facilities and court ordered to be transferred to juvenile facilities routinely remain in adult facilities for days or even weeks, awaiting transfer approval from the Department of Juvenile Services. During this time, juveniles are often placed in the only facility areas that are able to support sight and sound separation, restrictive housing. To maintain this approach is neither ideal nor conducive to rehabilitation. Instead of trying to retrofit adult facilities, we should focus on creating and expanding juvenile facilities designed specifically for young offenders. These facilities would meet the unique needs of juveniles, provide age-appropriate programming, and ensure that they are kept separate from adult populations. I respectfully urge committee to issue a report favorable on this amendment to Senate Bill 827. Thank you for your time and consideration. I'm here for any questions. Thank you.
Thank you to the chair and members of the committee for having me. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we are here to support this bill. I just want to reiterate that when this bill came up last year, we were opposed to it, but through collaboration with the sponsor and the advocates, we've gotten to a point where we're sitting here supporting it because we do think that this is something that would be helpful because absolutely juveniles need to be handled with absolute care, and we just think that this bill will really help make sure that that is ensured statewide. So we're happy to support, and I'm here for questions as well. Thank you.
Mr. Bergman for 2 minutes.
Thank you. Good evening, Mr. Chair, Madam Vice Chair, and committee members. My name is Stephen Bergman. I'm with the Public Defender. I regret I haven't seen the recent amendments, so I apologize for not being current. I have submitted written testimony on this bill. I ask the committee issue a favorable report with amendments. HB 1107 has two objectives. The first is to ensure that all detained youth pending transfer hearings are held in secure juvenile facilities operated by DJS. The proposed language, the existing provisions, pardon me, the proposed language amending the existing provisions of Criminal Procedure 4202 does this in a clear and concise manner. DJS objects due to lack of sufficient capacity. Although I'm sympathetic to this, it should be noted that the department has two facilities that are listed on their website as temporarily closed, which, if open, would provide more than enough capacity. These are the Noyes Detention Center in Rockville and the Garrett Children's Center in Western Maryland. The overriding issue is to ensure that all youth pending transfer hearings are safely housed in juvenile detention facilities where they will neither be in contact with adult inmates nor subjected to solitary confinement in order to ensure this. The second objective is that all detained youth ineligible for transfer or who have been denied transfer not be detained in restrictive housing in order to meet the obligation that they have no sight or sound contact with adult inmates. While I applaud the intent of the bill, I think that there's a simpler way to craft the language. It would be far more concise to say, and this language is in my written testimony, any detained child under the age of 18 who is not eligible to have their case transferred to juvenile court pursuant to Criminal Procedure Section 4202, or any child under the age of 18 who has had their petition to transfer to juvenile court denied, shall be detained at a facility for children operated by the Maryland Department of Public Safety and Correctional Services. And with that amendment, I ask the committee to issue a favorable report. Thank you.
Questions on the last bill of the night, Delegate Erica.
Thank you, Mr. Chair. I'm really trying to contain myself right now. I'm sure you saw DJS's delightful letter. I'm going to just word vomit and then get your response back. So not only do they say, oh, we don't keep kids in solitary, but when we do, insert words here, that's neither here nor there. But then farther down, they're opposed to this, while earlier today, the very same kids we're talking about earlier today would end up in this facility. But in this letter now they say, oh, unfortunately, it would cause overcrowding and unnecessary delays. Oh, but wait, there's more, a $45 million price tag. I feel like sometimes the left and the right hand of government don't know what they're doing. This is like the left hand doesn't know what the left hand did 5 minutes earlier today. So I don't know if you have any thoughts on how they could come in opposed to this bill when it's talking about the exact same population of children. I'm at a loss.
I have thoughts. I have lots of thoughts about that.
Please, yeah.
But I will say that I found it interesting. Like I said, it was, in fact, the Department of Juvenile Services who introduced the bill in 2021 and who's introduced it as an emergency bill. And in 2022, it was introduced as an emergency bill. These are departmental bills. These are not sponsor bills. Departmental bills. Now, part of that is there was a different administration and, all of that. The other thing is that there were facilities that have been closed, as to Mr. Bergman's point. There are facilities that have been closed. There's a facility near me that has been closed. Waxter is closed. I think Mr. Bergman makes a good point, and that is if any of the closed facilities, and I know that some people don't like the idea of opening facilities, and I get that, opening meaning creating more facilities, but if it means totally, I'm trying not to think of a swear word right now, and totally messing up a child's mind, if it means totally not putting them in restrictive housing for 23 hours a day, if it means keeping them away from adults, and if it means that, then yes, we do need to reopen one of the facilities that have been closed, or do what they've said they can do in 1433, I think it is. Do what they said they can do. Move the children out quickly. Electronic monitoring for some, and being, community detention with electronic monitoring for some children who could actually apply to that. And in those cases that can move quickly in the system because perhaps we do pass 1433, which I support. Then yes, then we would have the facilities. But to come outright and oppose the bill, I found it very interesting. And also, I just think that I will say that I have heard specifically, and in a commission meeting, a work group, I specifically asked, could DJS have children in their facility who are in these adult facilities? And the answer was yes. So now the answer is no, we don't have capacity. And I just think that, and we're talking 35, anywhere between 30 and 40 kids. So we're not talking hundreds. We're talking anywhere between 30 and 40 kids.
Yeah, to the cost of $45 million allegedly. I mean, I think you were really kind about it. I don't know if I'll ever be able to believe a testimony brought in here again at this point after what I've seen today. So I think you were very generous in your response.
Delegate Valentine with what I believe will be the last question on this bill.
Thank you, Mr. Chair.
No pressure.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill. My question is specific to Assistant State's Attorney, Ms. Wilt. You mentioned in your testimony that it was informational, and you also mentioned some of the amendments, and I've got some notes here. What changes or what additional amendments, based on all of your experience, may change that information to a favorable?
One of the amendments is specifically, it changes page 5 of the original bill, 38A16. It reads just clean with the amendment. It says specifically that youth may not be held in an adult facility, and it goes to a period. And I think it needs to say without a hearing as defined in CP 4-202.3, which is the new language in the second part of the amended language. And then in CP 4-202.3, that's the other amendment. That one says all kids should be held in a juvenile facility, and it uses the language while awaiting trial or other legal process. I would strike that because that could be interpreted differently in every jurisdiction and make it while awaiting the transfer hearing. And then I believe that covers, so Mr. Bergman and I aren't exactly on the same page, but that would cover every youth before they have the doctors testify, before that long hearing where a judge decides adult or juvenile court. Those amendments would cover all of those youth must be kept in a juvenile facility. Thank you.
And ironically, that's exactly what was done in the departmental bill of 2022, House Bill 877, if you want to look it up, 2022, House Bill 877, 4-202.3 was included.
Thank you. Thank you.
All right. Thank you very much. That concludes the testimony on House Bill 1107. Committee, I need your indulgence for just a moment. So thank you all very much for coming and testifying tonight, but I need to bring to the table Andrea Seabrook. Andrea Seabrook doesn't want to come to the table, but committee, as many of you know, I went to Earlham College in Richmond, Indiana. It's a small Quaker-affiliated school. And in my third year at Earlham, I got to run the radio station, my third and fourth years. And one of the people I trained at the radio station was a first-year student from Annapolis, Maryland, named Andrea Seabrook, who later went on to great and amazing things in podcasts and on NPR, and she has been my friend for 30 years. And she watched today's hearings, and she noted when I said, we have to have some way to count apples as opposed to grapes and kumquats. And then she said, well then, why don't I bring in apples, grapes, and kumquats? Which we'll be writing to the committee and to share during our committee hearing with 110 witnesses tomorrow. So thank you very much, Andrea Seabrook. Thank you very much.
You guys.
All right. I love you very much, but that concludes the Judiciary Committee for today. Thank you very much. What's your DJ name? Can we make some? It was Luke.